Hi, everybody. We're starting a little early just because, why not? And really, we've got to get ready because there are some issues here I think we need to cover. And some people actually messaged me saying they didn't understand what this hearing was about. So today we've got Alec Baldwin's motion hearings. Now, it's not just for Alec Baldwin's motions. There's actually quite a few motions that have been left outstanding that the state has had that need to be addressed, as well as Alec Baldwin's team. There's a bunch of stuff that needs to be addressed we have not gotten to yet. So, what are we looking at here? Well, hold on here. Well, that was retarded the way I spelled that. So one of the big motions that's currently pending is Alec Baldwin filed a couple of motions to have these cases dismissed. One of the biggest ones is because of motion to dismiss that the evidence had been spoiled. And that means the evidence we're talking about is the gun. If you guys remember, we talked about this. The guns. Okay, perfect. I didn't have that timing set. Is the case involving where they shot the gun and they hit the hammer and they tried to break it seeing if they could get it to work, and they ultimately destroyed it on the hammer spur, so they had to get a new hammer. Now, the idea that it was anything special, well, they were able to replace the parts and the gun still worked. So that's there. And then the biggest issue, I think, for the state right now is arguing about Hannah Reid being able to testify and giving her immunity, because that's the other one. And if you guys look, the court has actually set out a nice little kind of like menu of what's going to happen. So here's all the stuff. Here's all the stuff, chat. Like, what are we talking about? So today, Friday, June 21st at 9 a.m., and we're going to actually make sure we have the screen ready to go for that. Are they? They have not started, it looks like. Okay, real quick. So you guys can see they have a whole list of motions here that they're looking at. Defendant's motion to exclude witnesses, an expedited motion for use of immunity. The state's motion for clarifying of an order. The defendant's motion to dismiss for failure to state an actual crime. Remember, we talked about this in other cases. They're actually saying whatever Alec Baldwin did actually isn't a crime in New Mexico. It doesn't meet the elements. And then there's a motion, and these two in the afternoon are dealing with the motion to dismiss about the destroyed revolver. So these two actually happen this afternoon. Now, if you look at how this is set up, notice it goes basically from 11 to 11:30, 11:30 to 12:15 Eastern time, 12:15 to 12:45 Eastern time, then a 15-minute break, and we're starting up at 1 again. I'm just going to keep going. I don't really see the point stopping at that. So with that said, let's switch over, and we are going to be ready.
Hold on for 1 second.
There is the judge. Uh-oh. Is Bowles going to talk again? I don't know if Hannah Reid still got Bowles. I don't know.
Okay,
Hey,
I'm just
how you doing?
making sure that the people that are trying to get on.
And Dolly, I sent you a link.
Are viewed. Okay, so good morning.
You're welcome.
Let's have counsel state their appearances. D10120202240013, State of New Mexico versus Alexander Ray Baldwin. Party state their name.
Carrie Morrissey and Erlinda Ocampo Johnson on behalf of the state of New Mexico.
And good morning, Your Honor. This is Alex Spiro. I'm joined by Luke Nikas, John Bash, Sarah Clark, and of course, Heather LeBlanc on behalf of Mr. Baldwin again.
All right, thank you. All right, so we'll start with the defendant's expedited motion for court order excluding defense witnesses. Go ahead.
We have just one technical issue, which is Mr. Bash has not been allowed into the hearing. If he could be allowed in.
Guys, this is Alec this is
Thank you. I see Mr.
Mr.
Bash has
Alec
joined.
Baldwin's the
Mr.
attorney.
Blanc will be handling that motion on behalf of the defense.
Thank you, Your Honor, and I will be arguing this first motion. So I know that the court has obviously reviewed the motions of the parties. I do want to very briefly, though, put into the record right now for the court the timeline again with respect to various filings that have taken place with respect to this motion, because I do think they are important for the court's consideration. The first is that there was a deadline for witness list disclosure that was issued by the court, and that deadline was May 6th. On May 6th, both the state and the defense filed witness lists that added new witnesses. The state added 8 witnesses and the defense added 9, and this was on the same day. Now, later this same day, the state inexplicably files a motion basically claiming that the defense has untimely disclosed these 9 witnesses and that we have been engaging in sandbagging by adding these 9 additional witnesses, again, keeping in mind that they had just added 8 of their own on the same day. Now, the defense does not reciprocate. We don't file any motions claiming that they've been sandbagging or that they've done anything improper, because both parties have in fact complied with the court's order and filed their motions by May 6th. Now, on May 21st, we respond and we point out the absurdity of the state's position and of their request. On May 31st, which is a Friday, the state files a reply. And in their reply, they are still calling for exclusion of our 9 witnesses who we listed on the deadline of May 6th. Now, at 6:52 p.m. on May 31st, that Friday, the state also files a notice of completion of briefing, which is basically informing the court that the matter is ready to be heard. There's no withdrawal of the motion. They are still maintaining their position and their request that our 9 witnesses should be excluded, the ones that we filed on May 9th. Now, at this point, the defense is aware that we have 8 days that were scheduled for trial. And with 8 days scheduled for trial, the state at this point has listed nearly 50 witnesses, and the defense had 26 that were listed on our list as well. Now, we know that there's no way that we could get through 76 witnesses in 8 days. It's not possible. And so trial is fast approaching, and so the defense recognizes we need to start preparing for trial. We need to start putting these resources where they need to go and be working toward trial rather than investigation. We have to switch gears. So acting in good faith and knowing the state's position with these motions that we've now filed and briefed over the course of the past month, the defense reviews the case and then makes a strategic decision that we can cut down our witness list significantly. And we proceed to file on Sunday, which was June 2nd, a written notice that we are withdrawing nearly half of our witness list. And so we consent to an exclusion of 5 of the 9 witnesses that the state has requested be excluded through their motion. And so we send a courtesy copy to the state of our notice of our intent to withdraw those witnesses. And we also send a new witness list to the state. Less than 3 hours after we sent those copies to the state, after the state now has this insight into defense strategy, and while the state had just hours before still been standing on their motion that our witnesses should be excluded, the state turns around and less than 3 hours later files an amended witness list, adding witnesses that they still have a pending motion to exclude. That motion is still pending, and yet they file an amended witness list adding witnesses that they are still seeking to exclude per their motion. The next morning, then, the state files a notice that they are withdrawing their motion. All of a sudden, there's no prejudice. All is well. All of these things that the state had declared to the court that they would suffer as prejudice by the defense's disclosure of these witnesses on May 6th is now no more. And in fact, they want to go ahead and add some of the witnesses to their own witness list. So we find ourselves, Your Honor, in the absurd position where the state has sought exclusion of witnesses by motion. And this is not through discussion. This wasn't correspondence through emails, through phone conversations where the state says, we think you should pull these witnesses. This is through motion practice. They have represented their position to the court, and they've represented their position to the defense. And they've notified the court, this matter is now ready to be heard because it is completely briefed. And yet within mere hours of getting a look at the defense strategy, the state tries to walk back their motion. Now, obviously there are rules of criminal procedure that are in place. There are criminal procedure rules that govern time for filing, that govern various procedures throughout this process. And these rules presume that the parties will operate in good faith. They assume, in particular, that the prosecutors will follow their ethical duty, which is to seek justice, rather than to simply secure a conviction at all costs. But however, there are times when rules are not sufficient, where perhaps the party is manipulating the court system. And in those times, the court has to look to other doctrines in order to ensure the integrity of the judicial system. And so we look for evidence of manipulation in the court system. And we can do that by looking at the first filing that the state had, where they moved to exclude the witnesses in this case. And in their motion to exclude, again, which was filed on May 6th, the same day that both parties filed their additional witness lists, the state lists out in details the prejudice that they will suffer. They say, even though we filed by the deadline, they point out to the court, there's only 8 weeks. We're only 8 weeks away from trial. The defense, by adding these additional witnesses, they don't have time to investigate this case. And so the defense is engaging in improper tactic, and we're sandbagging the state. The state is prejudiced. These are their words. These are their terms. They also note in their motion and make really what are patently false statements. And what they say is that the state has, at this point, by May 6th, has made all of its witnesses available to the defense for pretrial interviews. That is false. That is not correct. In fact, we had the state's expert witnesses, multiple expert witnesses were actually scheduled to be interviewed after May 6th, and were subsequently interviewed into late May, and then even more recently into June, based on some new disclosures that have been had. And so that we had not interviewed all of the state's witnesses, despite the representation in the state's motion. In addition, the state also told the court and asserted that pursuant to Rule 5501, the state not only disclosed its witnesses, but also has provided the defense with all witness statements and experts' reports, as well as underlying data and a summary of proposed expert opinions. That is also false, Your Honor, because, and the court will see through different motions that are going to be presented before the court, some of which will come before the court today, and others which we will be submitting to the court later. In fact, that is not true. We had not received numerous expert witness supplemental reports. Those had been withheld from us, including one that was particularly exculpatory by Lucian Haig. That had not been provided to the defense as of the May 6th filing of this motion.
What state
there were
do you
also
live in?
Statements by the state's other expert, Brian Carpenter, that had not been provided to the defense. And to this date, we have, as of this day, we have made numerous requests of the state that they provide these statements that have been redacted through an IPRA request that we had done to try to get a hold of different statements from various witnesses and things like that, communications with the state. And so we are in possession of some emails, for example, email correspondence that does indicate that there are opinions of the state's witness, Brian Carpenter, and yet those have been provided to us in a redacted format through IPRA. So we do not have the ability to see the contents of these statements, but we can see that they exist. Now, there are many, many of these documents, and we don't know fully what might be contained within these various email communications and correspondences between the state and their expert witness. And we've asked the state, in compliance with their affirmative duty to provide statements of their witnesses and statements of their experts and opinions of their experts to the defense, we've asked them to provide unredacted copies. And the response has been, you have to go ahead and identify for us which ones it is you need unredacted, and then we'll take a look at it. That's not how this rule works, Your Honor. The rule works that the state has a duty. They have a duty to go and look for and to exercise reasonable diligence to uncover statements and opinions of witnesses and expert witnesses, and they have an affirmative duty to provide those to the defense. And yet they're putting that burden again on the defense. We have also had disclosed to us over 150,000 pages of other documents. We had, as late as May 23rd, audio recordings that were taken by the state's investigator, Connor Rice, of various witnesses whom the state had listed on its witness list that we had never been provided. And we only received them on May 23rd. And the list goes on, Your Honor. It includes then the state has now filed, as the court is aware, is pursuing use immunity for Halyna Gutierrez-Reed. And in accordance with that, they have now provided over 361 recordings for our review based on statements that were made by Ms. Gutierrez-Reed. Now, the list goes on. There's more. There's more that has been disclosed and that continues to come. But these statements that the state has made in their motion as officers of the court are not true. These are factually not true. And so we are prejudiced. And this is why the doctrine of judicial estoppel would come into play, because this court needs to protect the integrity of the judicial process and prevent manipulation of the court system. And so when the court looks at judicial estoppel, it's a three-pronged test. The first two of which are part of the main test, if you will, and the third, while not necessary, is actually a part of the test that indicates that judicial estoppel is even more appropriate if that third prong is met. And so I'll go through those with the court now. The first is that the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. The second is that the first position must be necessarily inconsistent with the position the party later takes in the proceedings. And then finally, while not an absolute requirement, judicial estoppel will be especially applicable when the party's change of position prejudices a party who had acquiesced in the former position. And so we'll start with the first prong. With respect to the first prong, Your Honor, the state has successfully assumed a position. The state took a position in a motion that witnesses should be excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses that the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. I'm going to go to the state's motion. And so what the state says is that...
Guys, this really is not going to go anywhere at the end of the day. This is kind of like... This is kind of foofy, but
is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's
guys, she's using Zoom. She's blurred her background intentionally.
incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024 case, the site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument and emotion. And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a motion, or I'm sorry, they assumed a position. And they successfully assumed that position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has, and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position. They cite O'Brien, they cite the Gabriel Vigil case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, in this case, this is a case where the court did apply judicial estoppel. And there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only.
You guys are worse than a pack of high school girls. Damn. Holy shit.
Be met where the court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court. And therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel Vigil case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency. And the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were. Now moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly that is the case. Clearly that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded. And now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the 2 prongs are actually required, the third prong again indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So the defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day, and then a couple of days later, we informed those witnesses that they were released from their subpoenas, and we did in fact release them from the subpoenas, and we told them that those interviews would be canceled. We sent, again, courtesy copies of our notice to the state along with our amended witness list, and then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines. But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their motion on May 6th, noted that that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Hannah Gutierrez-Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez-Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding, and it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
Wow, that's not, yeah, guys, I can already, I'll tell you now, she's not going to grant it. She's not going to grant it.
I have a couple of questions before I hear from the state. First, you talked about that you decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation. If I'm misstating that, tell me right now.
No, Your Honor, that's correct. That is a big part of the consideration as well, which is why we were assessing our case in that moment to determine what needed to be done.
And so you said that you made this strategic decision, and that, but I'm not clear, and that they know what your strategic decision is. Is it anything more than you eliminated a witness?
No, Your Honor, we did not include any additional dialogue with the court or information in the pleadings, but again, we had pared down our witness list to almost half of what it was. And so I think that gives the state a pretty good idea of what we're going to be doing with the case.
Okay. And so then you're talking about this sort of bait and switch is what you're saying, where on May 6th, they had a problem with your witnesses, and then on June 2nd, you took certain ones off, and then on June 2nd, they added 3 of the witnesses that you took off. And I'm not quite sure how that short time frame I know you're arguing a little more than short time frame, but that's quite a short time frame, right?
A short time frame for what? I'm sorry, Your Honor, if the court would
For the
clarify.
for them to have added the 3 witnesses that you deleted.
Correct. Yes, it was a quick turnaround.
Right.
That is correct. Within
And
hours.
how do you explain that they have always added at the end any witnesses called by the defense, and that you had these individuals on?
That's correct, Your Honor. And so it's a different position, I think, than we would be in if, let's say, the state had not filed a motion to exclude. That's the part that changes, I think, the analysis in this case, because at any point, of course, one party or another can remove witnesses from their witness list. We could not add any more witnesses based on the court's order, but we could remove witnesses from our lists. And there was the catch-all of, any witnesses who were listed by the defense or by the state, and that is correct. However, what's different about this particular situation than the typical instance in which a party may just decide to go ahead and remove witnesses is that we did so in advance of the final trial witness list, for example, that this court has, which I believe is Monday. And so we did so in advance of that in order to say, okay, we're not even going to finish doing these other witnesses. We know where our case is going to go. We're pulling these people off, and this is what we're going to do. And we did that in reliance on the briefing that was filed by the state. And so it's a bit of a different position because the state had already effectively indicated to the defense as well that they did not intend to call those witnesses by moving to exclude them. You can't move to exclude witnesses from trial for the defense, but then be keeping them for the state. That's not what they were saying in their motion. So what they were saying was these witnesses should not be called at trial. And so they're saying that they also will not call those witnesses. We then in reliance said, okay, fine, we agree to not call those witnesses. And so this is a different position than one party unilaterally just removing witnesses from their witness list because it was done in reliance on the state's briefing and on their motions.
So the prejudice is what?
So the
You
prejudice,
went into this whole thing that is not in your, it's more of your Brady violation motion. So what's the prejudice?
So the prejudice at this point, Your Honor, is we already had canceled and released witnesses from subpoenas. So they were no longer valid subpoenas since we had already informed the witnesses that they no longer had to be there.
That does make a little more sense.
The witnesses, even though some of them had already been interviewed, the problem is, and again, we don't want to go through an analysis of what each of the witnesses would be because we're not going to reveal further strategy to the state than we already have. And so we're not going to do an analysis piece by piece, to tell them what the import is or is not of each of the witnesses. But suffice it to say that we did an analysis of these cases as a group, as a whole, could be released and could be removed from our witness list together. If only some of them are now coming back, then that can again impact whether or not there need to be other witnesses who would still remain on the list whom we have not interviewed. And the state says, we can just extend the deadline, right? We can extend the deadline to take care of that issue. That's the state's proposal. But again, we have a finite amount of time and we are in full trial prep mode at this point. And so that's the prejudice, Your Honor.
That you can't interview 3 more witnesses because you might have to interview some additional ones.
And that's the thing is we made a decision and a call based on whether or not we might need additional witnesses. That's correct. Beyond that, but at this point, we don't have the ability to do that, and so that's the prejudice.
Well,
so the prejudice is that you're preparing for trial and you can't do these pretrial interviews. I'm trying to. You need to articulate it for me.
Of course, absolutely, Your Honor. So that is certainly a part of the prejudice, and so it's multifaceted. So that is a part of the prejudice. The other part of the prejudice that is specifically related to the witnesses is in releasing or removing nearly half of our witness list. We also, again, some of these witnesses are interconnected, and so now we have removed 11 witnesses. And the state is now adding back piecemeal, which witnesses they want to put on. And it happens to be some of the ones that they had moved to exclude. Those are the ones who they've listed as being added. And so the prejudice is that it does impact our case and our presentation.
And then your judicial estoppel is talking about fast and loose, but you're also that, they took one position, then they took another position, but you're talking about all in the same, I don't know, what is it, 48-hour period? I mean, they added them and then did their withdrawal, and you're talking about that constituting judicial estoppel?
Yes, Your Honor, because it wasn't just that one moment either. It was the fact that this had been briefed over the course of a month as well, and the state had indicated that the briefing was completed. And these witnesses In particular, they were very difficult for us to serve as well. We don't know that we would be able to get them back. We had difficulty serving them through our process servers, and they were hard to find. And then there was also one who was released who was actually an out-of-state subpoena witness. And those also take additional time that we don't have at this point.
Appreciate it. Thank you.
Yes.
I don't know who's going to be arguing.
It's me, Your Honor.
Okay.
Thank you. May it please the court. Your Honor, the case that actually governs this court's analysis is State versus Harper. And in State versus Harper, the New Mexico Supreme Court at 211 New Mexico Supreme Court 44 paragraph 2 noted that exclusion of witnesses requires an intentional violation of a court order, prejudice to the opposing party, and consideration of less severe sanctions. And when considering sanctions, prejudice to the opposing party is a central consideration.
She does look like the judge 20 years ago.
In Harper, at paragraph 19, the Supreme Court noted that even when a party has acted with a high degree of culpability, the severe sanctions of dismissal or exclusion of key witnesses are only proper when the opposing party has suffered tangible prejudice. And in this case, Your Honor, first, I would submit to the court that prosecutorial discretion allows the prosecution to make decisions with regard to the evidence it plans to present at trial. Unless that faith is demonstrated, those decisions are generally not subject to review. I would submit to the court that in this case, what happened, Your Honor, is that on May 6th, there were a number of witnesses disclosed. Because that was the pretrial motions deadline, the state had no idea the defense was planning to call these witnesses. So we filed this motion. But then these witnesses were set for pretrial interviews, the ones that the defense now seeks to exclude. These witnesses were interviewed. These witnesses, then the state investigated the statements of these witnesses and determined over a period of that weekend that it would be there would be no prejudice to the state. So we went ahead and withdrew the motion. And so what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Halyna Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses. Well, if we're going to list witnesses on our witness list, we first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial. These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial. These were their own witnesses that the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified. The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals, in citing Standifer versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because, based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to, matter of state of Kuchan, at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue, and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson, and in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or they could have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts appellate courts would likely find, and did find in that case, that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case. Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
Reply, Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was there were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court, found that there was a lack of mutuality. So this is, a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, The rules do not contemplate gamesmanship, and this court should not countenance such conduct. I will also point out as a couple of final points that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st, and then the moment that the defense had had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed? What additional investigation was had that didn't already take place before? They have told the court nothing about any of those specifics. What changed was that the defense revealed its position, and then they sought to take advantage. And in addition, the state says that they filed its motion to exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words that they included because that was the standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court again to grant the defense motion. Thank you, Your Honor.
Yeah, that's not going to work, guys. It's not going to work.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order. The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendant's witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order because the doctrine is to prevent parties from playing fast and loose with the court by successfully arguing one position and then later adopting a position inconsistent with the first. And I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice as contemplated by Hutchins. So you'll get these orders next week. All right, next up.
All right, that's out of the way, guys. So now we have other motions. Now we have the issue about Hannah Reid's immunity. That's going to be the next one.
All right, this is the state's expedited opposed motion for use immunity. And
That's me, Your Honor.
all right, Mr. Bowles was trying to get on. No, this isn't his.
Well, I was actually wondering why he wasn't on because he did file a response.
That's
Well,
correct, Your Honor, and I believe the state's reply addressed both defendants' briefings as well.
Well, but there's an issue there because the defendant, Mr. Baldwin, does not have standing to oppose use immunity for Ms. Gutierrez. That's outlined in the case law. I can give you the case. It's State v. Brown.
Okay, I didn't even call this yet. I just mentioned about Mr. Bowles. So let me try to see if staff can get him on now.
Let's see what Bowles is going to say. I'm sure it's going to be profound. But remember, he does have a right to be here because Hannah Reid is the subject of this, and Hannah Reid is his client, so it looks like he's still involved. Yes, free the Gorilla Grip pussy pal. Yep. Yep, they're looking to offer Hannah Reid immunity to testify against Alec Baldwin. Because remember, Hannah Reid may get if her case gets reversed, anything she says could be used against her. So there is that divide. Do you think Alec has a cool phone name too? No. And let's get some super chats out of the way real quick, or some other comments. EDW Raptor with 5 subs. Let's go. Thank you very much, EDW. Dolly is saying Carrie should borrow that lady's hairbrush. Yes. Neosu says, what's your opinion of my state? I don't know what state you live in, so I don't know. Is Alec Baldwin's lawyer a Sith Lord? No. Arthur says they say the 14 words. Then Robert Lord's saying, so Alec Baldwin's reality show is a show with him and his family? What the fuck? Yeah. It's about him and Hilaria and all their kids. Yep. For real.
All right, next up is D1010-2024-13, State of New Mexico versus Alex Ray Baldwin. Again, this is the order denying state's amended opposed expedited motion for use of immunity for Hannah Gutierrez, and parties that are arguing, state your name.
Carrie Morrissey on behalf of the state.
On behalf of the defense, it'll again be briefly Ms. LeBlanc, and I understand Mr. Bowles is on too. So I don't know if the court's waiting to hear from him.
Okay, go ahead, Ms. Morrissey.
So, Your Honor, as an initial matter, the defendant,
Golly.
Mr. Baldwin, has no standing to oppose use immunity of Ms. Gutierrez, and that's laid out in State versus Brown, 126 New Mexico 338. And I imagine that's the reason that their response indicated really that their complaint was that it wasn't timely and didn't really articulate any other objections. And that's because they're aware that they don't have standing to present any other objections. So to kind of back up, Ms. Gutierrez, as the court can see from the pleadings, was initially named on the state's witness list in February. She was then named on the defendant's witness list in April, and I believe she was also named on the defendant's witness list in May. She was scheduled for a pretrial interview after some difficulty, and I personally intervened and set up that interview, even though it was the defendant's responsibility. So we interviewed her, and as the court can see, when we interviewed her, I would certainly argue inappropriately, her attorney instructed her to assert her Fifth Amendment privilege to questions that did not trigger.
Just a minute. Is there a reason why the attorneys are not on video? Under our rules, you're required to be on video when we're doing
sorry, Judge.
hearings.
See, she's allowed to assert the Fifth Amendment at any time.
Your Honor, I just kind of lost my train of thought. So she was scheduled for a pretrial interview. We interviewed her. Mr. Bowles instructed Ms. Gutierrez to assert her Fifth Amendment privilege when questions were posed to her that didn't really trigger her Fifth Amendment privilege. The state is not seeking information from Ms. Gutierrez about her criminal conduct. The state is seeking information from Ms. Gutierrez about the criminal conduct of Mr. Baldwin. The court can see from the transcript of the interview, at one point, Ms. Gutierrez just asserted her Fifth Amendment privilege without the assistant attorney. And when I mentioned to Mr. Bowles, I said, you're not really advising her to assert her Fifth. She's just doing it on her own. And he said, well, I think she can do that. So we have Ms. Gutierrez, who doesn't understand the circumstances in which she
So-
gets to assert her Fifth Amendment privilege,
She has the right to
just
do
asserting
that.
it, and her attorney not counseling her on that. So the bottom line is, it took a long time to schedule the pretrial interview. That's the fault of Mr. Baldwin's counsel and Ms. Gutierrez's counsel, not ours. They listed her, I believe, initially on April 19th. We requested her pretrial interview on April 21st. We didn't create any delay at all. Her interview was scheduled, and Mr. Bowles did exactly what Mr. Baldwin's counsel wanted him to do, which was just have her assert the Fifth to everything, because they don't want her to testify. She is listed on their witness list, and they presented her for a pretrial interview, but they don't want her to testify. They want to get her statements in as exceptions to hearsay. And certainly what the state is arguing to the court is that the hearsay statements that the defendant wants to present to the jury, those are statements that have to do with Ms. Gutierrez.
And what Carrie's getting at here is immediately they'll get the statements in as exceptions to hearsay, and then they won't be able to cross-examine Hannah Reed because she'll try to go, well, I plead the Fifth, I plead the Fifth, I plead the Fifth. And normally you're not allowed to do that. So that's what they're trying to do here, is prevent them from introducing these, and they have no way in after that. So that's what's going on there.
Gutierrez's culpability, and they are absolutely exculpatory to Mr. Baldwin, and they go to causation in this case. It's perfectly appropriate for them to present those statements. I'm not objecting to that or arguing that point at all. But what I am saying is that in turn, the state is also allowed to present testimony from Ms. Gutierrez that goes to Mr. Baldwin's culpability.
Mhm.
She has probably more information than any other witness with regard to Mr. Baldwin's culpability. We are simply asking that we also be able to present testimony
Mhm.
and evidence from Ms. Gutierrez. The defendant intends to do it. There's no question about it. So the first thing that needs to happen here is we need to have some kind of a question by question determination from the court as to which questions Ms. Gutierrez even can lawfully assert her Fifth Amendment privilege. Once the court decides, okay, this is the category of questions where I believe she can assert her Fifth Amendment privilege, then we make a determination about whether or not she should have use immunity to answer those questions. That's not terribly difficult. Her pretrial interview, as the court can see, was relatively short. I think it was 20 or 30 minutes. So we need to have a hearing. We need to have the court determine, or the court potentially could even do it from the transcript. Have the court just determine what she needs immunity for. At this point, a lot of the questions that we would ask her, she doesn't even need immunity for. She's just a normal witness. She's on the witness list. She's been interviewed. We put her on the witness stand. We ask her the questions, and she's required to answer them under penalty of perjury. There's no reason when she's posed a question, for example, was Mr. Baldwin attentive during the firearms training that you provided? How does that trigger her Fifth Amendment privilege? What did your firearms training with Mr. Baldwin consist of? How does that trigger her Fifth Amendment privilege? So this is just something that we need to get ironed out so that the jury can have all of the information that the jury needs, that the jury is entitled to, and we don't create a situation where Ms. Gutierrez's statements only come in with regard to the exculpatory value they have for Mr. Baldwin. They also need to come in with regard to the inculpatory value that they have with regard to Mr. Baldwin. Thank you.
Mr. Baldwin. I mean Bowles, sorry.
Your Honor, and as a preliminary matter, Judge, can you hear me?
Yes,
Judge, I want to make sure. Okay, I'm having poor internet connectivity, so I hope this doesn't affect it. Judge, I want to start by saying that first of all, the assertion of privilege was on behalf of Ms. Gutierrez-Reed, who wanted to assert her privilege. It wasn't on behalf of anybody else. She has a currently pending appeal, as this court knows, so she has a conviction that is not yet finalized, and the cases are very clear. She can invoke a privilege as to questions that may tend to incriminate her. I agree with the state. She cannot invoke as to all questions if those do not have a tendency to incriminate her. However, when Ms. Gutierrez-Reed invoked it on her own at the interview, Ms. Morrissey also said in the transcript, and she left that out in the interview, I think she can invoke that. So that's what happened there. That was May 14th. Your Honor, preceding May 14th, on or about May 8th, it was a confusing situation because Ms. Morrissey had told me that on a Sunday, an email that she would stipulate to unavailability, or thought she would stipulate to unavailability, so that the statements can come in through that exception. So I thought it was going to be a stipulation. Then there was confusion on the interview date. Then I had scheduling issues, so we got it set up.
Johan, we'll get
Next,
this in
Your
a
Honor,
second.
on May 14th, we got the indication from Ms. Morrissey that she wanted to file a motion to force use immunity, which under Rule 5-116, this court unquestionably has that authority and discretion to do that. Now, Your Honor, in a normal case, and the cases cited in that rule, Bellinger and some others, this court can force use and derivative use immunity, which I do not believe should be selective, as the state indicates, because the problem we get in there is that on cross-examination, questions may be asked, then Ms. Gutierrez-Reed may have to invoke in the middle of trial. If that were to happen, her testimony could be stricken. So I think if this court were to order use and derivative use immunity, it would have to be blanket as to the trial testimony and cross-examination, I would submit, to avoid those issues. But Your Honor, that's in the normal case. This will be most likely the most publicized trial in the history of New Mexico, or at least one of them. And because of that, we have submitted in our briefing, this is not the typical case. If Ms. Gutierrez-Reed testifies, there's no current restrictions about what could be asked of her, including on cross-examination. That testimony will undoubtedly be watched by millions of people. Currently, Ms. Gutierrez-Reed is set for trial in front of Judge Ellington in August. We have moved to continue that, Your Honor, but that is a separate matter involving alleged bringing a gun into a bar. There's no protections as to Ms. Gutierrez-Reed on that trial, because even if this court were to order use and derivative use immunity completely, that testimony she gives will be watched and heard by potential jurors, and there's really no way to prevent that. Now, the government says we can do a motion to change venue if there's an issue. But again, that raises the issue, Your Honor, this is going to be widely publicized across not only the state of New Mexico, but the country. So that's a very real concern Ms. Gutierrez-Reed has. She's also, and the state really didn't touch on the separate Ellington trial, Judge Ellington trial, but that is a very real concern of hers, that if she's asked on cross-examination questions related to that, it really imperils her ability later to defend herself in that proceeding. We also have the appeal, Your Honor, which we don't know what will happen on that, but if it's remanded, the state gets a complete opportunity to cross-examine or examine Ms. Gutierrez-Reed on matters she would have never had to say going into that trial. So while the court unquestionably has the discretion, I would submit, Your Honor, that because she is unavailable and statements can be introduced by both parties, there is another way the court can handle this and avoid the potential constitutional issues that may arise in the future with her right to a fair trial in front of Judge Ellington and perhaps in front of this court if the appeals court reverses this case. So I think there's another way this could be handled for the testimony to be obtained by both parties.
I'm going to allow the defendant to respond. I think that under State versus Brown, they can take a position. Let me read that case. All right, so I think that you can oppose the motion, and I'm going to listen to it. Go ahead.
Yes, Your Honor. So I will be brief. The issue that we have is with respect to the prejudice due to the timing of the state's request for use immunity. As the state has noted, Ms. Gutierrez-Reed was actually on the state's witness list as far back as February. She was also on the defense witness list. And the state could have made this application months ago, because the situation is that Ms. Gutierrez-Reed did not testify in her own trial. And so there were no new statements that were available to the state after the trial that were not already available to the state for the past nearly 3 years. So they were aware of the situation. And they even—
That's a really good fucking point. That's a really good point.
it sounds like from Mr. Bull's representations, the state even indicated that they were willing to stipulate to unavailability without taking her statement, which would have then, resulted in, the same position we would have been in without the grant of use immunity. But the state was aware of this. They were aware of this 50 witnesses ago. They were aware of this 3 years ago, and they had her listed. So at this point, the state now, as they're making all of these many numerous disclosures, they disclose us all of these, phone calls from Ms. Gutierrez-Reed, again, that we cannot possibly have the time to go through in advance of a pretrial interview of her, because what the state is indicating is they think she has much more information than the statements that have already been provided. Well, we don't have access to those statements. We would need to interview her. So she's effectively becoming a new witness that now we would have to interview and prepare for her at trial. And so the state had every ability to do this sooner. And we would ask that the court consider some of the items that were also in that I know were contained in some of the other filings that the defense has submitted with respect to the volume of new disclosures that the state has made, and the prejudice that the defense will suffer if we now have to approach this new, rather substantive witness when we're talking about just 10 business days before trial. Additionally, the state has indicated that they requested her interview right away and they weren't responsible for any delay. I think that needs some clarification, Your Honor, because the defense initially had subpoenaed Ms. Gutierrez-Reed for a statement. There were some scheduling issues based on availability. The defense actually was working with and contacting the prison facility, and we did have that set up, but then the interview had to be canceled based on availability of Ms. Gutierrez-Reed's counsel, and she does have a right to have counsel present. So that had to be moved. In the interim, as we were setting up the next one, Ms. Morrissey indicated that she wanted a deposition instead of a statement. And so she needed to file a petition before the court. The defense took no position on that, but informed Ms. Morrissey that if that's something that she wanted, she would need to petition the court for that, as is the appropriate criminal procedure under the rules. She did not do so, but that did cause part of the delay. And then ultimately the interview was scheduled with Ms. Gutierrez-Reed, did take place, and the defense also provided the information to the prison facility with the links for her appearance. And so we would just ask the court to note that there was nothing that prevented the state from petitioning this court for use immunity. And that is our sole objection at this stage, is the fact that they could have done this while we still had the time to conduct a full investigation of what her statements would be without prejudice to the defense. But now here we are in the 11th hour on the eve of trial, and the state is making motions for use immunity that will basically provide this witness who would be one of the most significant of the trial. And we are definitely prejudiced by this late request, and we would ask the court to deny the state's application for immunity, at least specifically with respect to the timing and the prejudice that this would cause the defense of Mr. Baldwin at this stage. And he is entitled to a fair trial and to an opportunity to prepare and present an adequate defense.
All right, before you reply, I have a question for Mr. Bowles. Is she going to use that use immunity, or does she just plan to not take advantage of it?
And Your Honor, I really apologize. It noted that my internet was having connectivity. I heard part of the court's question?
Does
think
Ms.
I heard all of
Gutierrez, all right, does Ms. Gutierrez, to your knowledge, have any intent to answer the questions if given immunity based upon that? I mean, I'm looking at the interview.
Nope, she's not going to.
She didn't cooperate.
Your Honor, she doesn't want to be cooperative in this case. I understand the court can order under use immunity, blanket use immunity testimony, but she does not want to answer the questions.
Reply, Ms. Morrissey.
Remember, her appeal's still pending.
Your Honor, if the court were to grant the motion for use immunity and Ms. Gutierrez were to refuse to follow the court's order, then she's held in contempt of court. Witnesses don't just get to refuse to follow the court's order.
That wouldn't matter if she wasn't in jail. She's in prison. You can't make this worse for her now, Carrie. That's the point. She's got more push than you've got time. You haven't cut a deal with her to cut her loose upon a pause, like exchange for a testimony. You're just immunizing her. You're not going to win this fight with Hannah Reed. And I honestly hope they don't.
She refuses. She's held in contempt of court. We will be asking for additional jail time. That's how this goes. I will start by, it's baffling to me, absolutely baffling to me, that there is a defense attorney in this hearing opposing immunity for his own client. If that is not an indication that he is acting as an arm of Mr. Baldwin's defense team, I don't know what is. And listen,
Your Honor, that's inappropriate.
Whoa.
I think it's absolutely true.
That's
Okay, let's move on.
It's
Keep going.
actually not.
it.
You all, it's her turn. Let's keep going.
She just made a salacious allegation like that. Bowles has the right to say, who the fuck do you think you are? Carrie, they're calling you out because you're full of shit.
Mr. Bowles has told the court, look, it's really complicated, Judge, for us to do it the right way, for us to put her on the witness stand and have her, outside the presence of the jury, or set a hearing and have her outside the presence of the jury, figure out what she can answer and what she can't answer. So you have to do it blanket. Okay, do it blanket. I'm not opposing that. Mr. Bowles' suggestion, if that's what he thinks is the best way to do it, you can absolutely issue blanket use immunity. She has to answer every single question under the court's authority. If she doesn't do it, she suffers the consequences of that. Mr. Bowles continues, even in the Baldwin case, to present information to the court that is patently false, and he's doing it again. He is in this hearing telling this court that these lawyers, the defense attorneys and the state, are going to be able to ask any question of his client. The rules of evidence only permit us to ask relevant questions of his client. Every lawyer who questions Ms. Gutierrez at trial will be subject to the rules of evidence, will be permitted only to answer appropriate, relevant questions, those questions that are determined by this court to be appropriate. The Ellington case is just a red herring. There is nothing about that separate case that is relevant to this case at all. I would be stunned if the court found otherwise. This is a completely different thing. It didn't have anything to do with her participation on the movie set. She was in the city of Santa Fe as just an individual. She wasn't working, and it's absolutely ridiculous. Not to mention the fact that Ms. Gutierrez has another case pending in front of Judge Ellington because of her own conduct. So we don't turn around and say, state, you can't use her as an incredibly important witness because she's got this other case pending. She has another case pending because she seems to have committed additional criminal offenses. That's kind of the way it goes. With regard to Mr. Baldwin's argument that there is prejudice based on the timing, let me tell you, Judge, I was not aware that I was going to need a motion for use immunity. I was not aware that Mr. Bowles was going to show up to a pretrial interview and instruct his client to assert her Fifth Amendment privilege to questions that do not trigger the Fifth Amendment privilege assertion. Now, Based on my experience with Mr. Bowles in the Gutierrez case, maybe I should have anticipated that, but I did not.
Ooh,
So I didn't
you're
learn
just
of that
talking shit
until
now.
we finally got the pretrial interview
Oh.
done. Ms. LeBlanc's statement about the short period of time that the state was considering asking for a deposition, that didn't create any delay at all. At that point in time, Ms. Gutierrez was already scheduled for a pretrial interview. That pretrial interview was never canceled up until Mr. Bowles indicated that he had scheduling difficulties. So the pretrial interview was scheduled. We talked briefly about having a deposition. We reached out to Mr. Baldwin's counsel. We asked for their position on that. They said they took no position on it. And I said, okay, I guess we'll set her for a deposition. Then they said, no, we're not opposing it, but we think that you need to get the court's approval. I'm not creating that delay. They're creating that delay. And at the end of the day, we said, look, we'll just go ahead and interview her on the day that she set, which was May 9th. Actually, I think it was May 10th. So we agreed we'd go ahead and interview her on that day. The interview was never canceled. Mr. Bowles canceled the interview. We got her scheduled on the 9th. Mr. Bowles canceled the interview. We were trying to get her reset. And because I sort of had this feeling like if you want something done right, you better do it yourself, I did it myself. And I finally ended up getting my pretrial interview, wherein Mr. Bowles unlawfully instructed his client to assert her Fifth Amendment privilege to nearly every single question that was asked of her. So to say the state should have just been able to anticipate this roller coaster ride is absolutely ridiculous. Now, with regard to the jail calls were provided weeks ago. I know how long it takes to listen to the jail calls because I've had to pay my investigator to do it. There are 2 lawyers on the state side. There are 10 lawyers on the defendant side, and they have at least 1 investigator. So if they can't get that under control relatively quickly, I'm not sure what to say. We are not, I want to make clear, we are not asserting that Ms. Gutierrez has a whole bunch of additional information that nobody's ever heard of. She is specifically being called by the state so that she can simply give the jury the information that she already provided to law enforcement and to OSHA with her lawyer's advice to waive her Fifth Amendment privilege. So those are the things that we're asking to get in through her testimony. There's one other statement that she made in a jail call that was specifically provided to the defense. They don't need to go listen to 300 and some of them to find that. We gave them the number. We showed them exactly where it was. Now, at the end of the day, when the defendant comes to court and says, Judge, we don't have enough time, we're prejudiced because we don't have enough time, I want to take the court back to the hearing that we had on February 20th, where we were talking about scheduling, and the court suggested that the trial be scheduled in October, and the state suggested that the trial also be scheduled in October, and it was Mr. Spiro, it was the defendant, who said, no, we need to have a trial in June. They wanted a trial last month. They got a trial this month, and they continue to come to court and say, Judge, we don't have enough time. They don't have enough time because they asked to have the trial set too soon in a case that has massive discovery. With regard to any of their complaints about all of these documents that have been provided, I have to tell you, Judge, you know, when they indicate in their arguments that they received this massive amount of discovery, what happened was we realized that not all of the lapel videos were in our possession and therefore were not in the defendant's possession.
That's a that's a violation of discovery. They're in your possession if the police have them. And you didn't turn over all your evidence then. Great. That's glad you admit that now.
So as soon as we realized that, We got those videos from the sheriff's department, we uploaded them, we provided them, and we realized that the vast majority of those videos were duplicative. So what was happening is 2 police officers were conducting an interview. The defendant didn't have the lapel camera from one of the officers, but they did have the lapel video from the other officer who was present for the interview. So a lot of their complaints about this stuff was coming in late, they're really over exaggerating any potential prejudice that they could have possibly had from any of that. And again, they asked for a June trial because of my objection. The court gave them a July trial when we were intending to have an October trial. So if they don't have enough time, there is a remedy. They can ask for a continuance. Thank you.
Ow, that was a tirade.
All right, the court makes the following ruling to be followed up by an order of the court to be filed next week. The state denies the state's amended opposed expedited motion for use of immunity for Hannah Gutierrez. It's pretty clear that she does not intend to cooperate. The court may grant use immunity pursuant to Rule 5116 if the court finds the testimony may be necessary to the public interest and the person
Wow,
has
I
refused or
thought
is
she was
likely to
gonna
refuse to
grant it.
testify. So it's really
Really?
the public interest portion that I'm going to address because she has indicated that she won't testify. You've indicated that
Ooh.
she possesses information about what she already told the investigators. I don't think that there is anything that, I mean, I haven't heard of anything that she might testify to that someone else could not testify to, even about her observations. Maybe,
Wow, I thought you
I
was gonna
mean,
let
maybe
that
the
in.
only thing is, the only portion
Good
is
job,
that
Bowles. You actually did a good
talking
job.
about how Mr. Baldwin didn't, didn't want to be trained, things like that, which
Neither
she
was
could probably
I.
answer without the use of immunity. But, the state says, well, the simple solution after she refuses to answer, even though she's been given immunity, is that you can hold her in contempt. I'm not going to do a mini trial within a trial. And I think that when all is said and done, if she's going to be an unavailable witness, then we're at the 11804 evidence rule on unavailable witnesses. So I think you should prepare accordingly.
If I could just ask a point of clarification.
Yes.
Given that the court is denying the motion, the state still can ask questions of Ms. Gutierrez that do not trigger her Fifth Amendment privilege. So we can still have her transported. We can still put her on the witness stand. Does the court want to deal with what questions she has? She has the right to assert the Fifth to prior to trial, or do you just want to wait and do it then?
Right. I mean, I'm forecasting based upon what Mr. Bowles is saying, based upon that interview, that everything is going to be a non-answer, and then there's the unavailability of the witness.
Well, and we certainly will be renewing our motion, but I hear your ruling, and I'm not arguing with it. Thank you.
All right. Thank you. We're in recess in this case. Do you all want to take a break, or are we continuing? I see nods, but I don't know what that.
I would like a break.
Whatever's preferable to the court.
Okay, we'll take a
Yeah,
what
take it.
time is it? 10. We'll be back at 11:15. Okay.
Oh, so we're gonna
Thanks.
take a
Bye-bye.
15-minute break. Okay. So what did we learn? Oh, there's Alec Baldwin's attorney, Luke Nikas. So yeah, I'm surprised at that. I thought the judge was gonna say, yeah, fuck it, here's your immunity. Have a great day. Yes, there's great points. Multiple people can say Alec Baldwin was acting like a dickhead. They could say multiple people can attest to how he was doing, how much he got trained. And like I said, what point does having Hannah Reid testify do? Specifically her. And there's some comments here I wanted to get to. Johan Naxos is saying, isn't estoppel, it's ESTOPPEL, not LE, but just so you know. States that use child support cases try to say the dude that got lied to about paternity for years still has to pay child support, even if it's not his because somebody got to pay. Pretty much, remember. The courts don't they make people pay child support so they don't pay welfare money. Although you'd think like, oh, the government's save money. Well, considering how they pay out welfare, isn't really saving money. I don't think so. But you bring up, it's basically called paternity by estoppel. Yes, if you jerk around on that, yeah, if you're not sure it's yours, get a paternity test. Guys, if you're not married, demand a paternity test. And thank you for the super chat, by the way. Thank you very much. I appreciate it. Jolly Jake Lovell saying 144p attorney at law. Yes. Charlie is saying, does the prosecutor get to decide what you plead the fifth to? No, but the prosecutor can decide what to immunize you and offer immunity for. And Michael's saying immunity for what? She's already been convicted. Remember, she had her appeal. If she admits to things, that could kill her appeal, number one. And then number two, let's say she wins her appeal and there's a retrial. If that testimony's not immunized, guess what? It can all come back in on her. So there are actual issues for that exist. But I think the judge did a great job just by saying, find other people. This is stupid. And I think that's a fair way of handling it. There's other people who could talk about Alec Baldwin being a fucking dickhead. Lawful Lucas is saying, I know Bronca likes his attorney, but she rubbed me the wrong way since the trial. Yeah. I mean, she comes off as an asshole. And then Cavatino Cavalryman Che. Very alliterative. Says, you put her in jail. Why would she help you without a deal? That's my point. If I'm Bowles, I'll give her immunity. For what? In exchange for what, Carrie? Nothing's free. Well, if you won't offer anything, of course she's not going to fucking help you. You put her in fucking prison. And I'm sure, yes, I'm sure she's been told if she keeps her mouth shut, she gets a payday at the end of it. I'm 100% sure that's true. So she's keeping her mouth shut for a couple mil. She probably gets $1 million if she shuts the fuck up. I get it. So the idea, though, that Carrie was saying Bowles is acting as a representative of the Baldwin team because he blew up all the immunity shit. I kind of get Bowles has been communicating with Luke Nikes and Baldwin's team and probably has been taking marching orders from him. But the fact she did it like that was such an asshole thing right there. Yeah, and she did great in the Dean Cummings trial. That doesn't mean she's not an asshole as a prosecutor. Charlie says, would it be legal to influence her that way of money? Oh, no, that's illegal as shit. That's witness tampering. But if unofficial comments have been made, remember, never in writing, always in cash. Guess what? I'm sure she's had promises made to her that there's money in a bank account waiting for her. Subi says, can she release Hannah early? No, but she could not only not oppose, but she could support a motion for early release. She can say to the judge, we'd ask you to modify its sentence and release her. We support this motion. That actually would probably get her released, especially the prosecutor supporting it. That's a big deal. But to sit there and say, fuck you, you're going to tell me what I want because I want to know it, that's not going to help. So she could pull some strings. Certainly, she would have influence. It wouldn't force the judge, but the judge would go, well, the state wants to do this. Cool. It would help. Dragon Cook is saying, she was an asshole at the Cummings trial also. Lol. Well, I mean, hey, it's her job to be an asshole as a defense attorney. So the motion to exclude witnesses is not happening. And the motion for immunity for Hannah Reid, not happening, which is very impressive. Like I said, I thought she, especially the second one, I thought she'd be like, yeah, good, have your immunity. But I understand, and here's the thing. I think Judge Summer now realizes, this, like, I thought Hannah Reed was a disaster. Alec Baldwin's trial is going to be 100 times worse. And it's going to be 100 times worse. Now, it's set for 8 days. That's interesting. It's interesting. We already know, apparently, the timeline. 8 days. God, why does my hair look off? What the fuck happened? God, it's so fucking... I hate it when it does that. It's annoying when it does that. It looks so fucking weird. Charlie says, I was hoping to see the Greek lawyer. Oh, Nikes. Luke Nikes. Push your buttons. Oh, don't worry. When we get to the bedhead, no, I don't really put product in my hair. That's its natural kind of flop. No, he'll push your buttons during the motions to dismiss. Don't worry. He's going to fucking get her. He's going to fucking get her. Sean's like, oh, girl, look at my hair. Looks cray. Yep, it does. Say, I think I'm set for get a haircut tomorrow, too. I got to check. Hopefully they call me. Dolly is saying, Carrie is pissed, and it's going to be a disaster. I can't wait. Oh, I think so. It'll be interesting. So we got a couple minutes here, guys. Let's see. Let's take a look at, if you guys want to know where you can find stuff. If you go to the New Mexico, courts, they actually have here, if you guys are interested in looking at stuff, the New Mexico courts, they have high profile cases. So they have the old Alec Baldwin case that got closed, State v. David Halls. If you like, for David Halls, you can look at all the stuff from David Halls' case. And then for Hannah Reed's, you can look at everything in Hannah Reed's case. But we're not interested in all that stuff right now. So let's look at Baldwin. Eric Barron's case. Because that's the big one. Alexander Ray Baldwin. Let's see where the orders are. There's an order for this. The state seeks to introduce prior acts. So what are they going to do? Well, they're going to try to point out that Alec Baldwin was acting like a dickhead with his gun. And I saw this before, and I thought it was very, very interesting. So between the days leading up to the shooting and the shooting itself, Alec Baldwin did a bunch of stuff. He used his gun as a pointer, directing crew members. He discharged the revolver after filming was over and cut was called. And he shot several scenes where he placed his finger on the trigger. Okay. Also, let me guys know if you can read it. I'm trying to make sure you can read it. He rushed the armor to reload and the crews to work at a fast pace. He was inattentive during the training conducted by Hannah Reed. He was distracted by his family. He engaged in horseplay with the revolver while making videos during his firearms training while using pull load blanks. So it sounds like he was fucking around with his gun and filming it. He displayed erratic and aggressive behavior during the filming of Rust. He displayed reckless behaviors related to use of the firearm, such as pointing it and firing a blank round at a crew member while using that crew member's line of sight as his perceived target, which that whole thing doesn't make sense. Why would you matter your line of sight? Oh, shit. Sorry, guys. Sorry here. Hold on. Sorry. So they're going to introduce prior acts or other acts of intrinsic evidence. So he used his gun as a pointer. He discharged it after cut was called, and you're not allowed to do that. Once cut is over, you shouldn't do it. You know, he had his finger on the trigger, and we've seen that where he's doing the draw. Every time he pulls it out, and he's like, and he's bumbling with the gun. His finger's on the trigger. He was inattentive. He engaged in horseplay while playing with the blanks. You know, he was erratic and aggressive. Yeah, we know that. We listened to those clips. He displayed reckless behavior. Hopefully there's more of this B-roll footage that's out there because it'll be very interesting. And after October 21st, was insistent that he not be required to follow the safety recommendations made by safety experts on the continuation of filming Rust in Montana. Interesting. Interesting. That's a very interesting setup for him. Should the screen bigger? All right, I'll try to hold on. Let me get bigger. You guys see that now? Try to make it bigger so it works. Are we covering Karen Reed today? Yeah, we'll try to work on that. We'll try to work on that. Thought Sean was doing it from memory. Oh, well. Let's see here. What else do we have? So these are some other interesting things that they apparently claim they could show that minutes before the 911 call was made reporting the shooting, Baldwin was photographed manipulating his prop gun. And we remember that lady was taking pictures, so hopefully there's going to be more pictures. His finger inside the trigger and his thumb on the hammer. Hannah Reed was not there to supervise it. Interesting. Prior to lunch, Mamie Mitchell took a cell phone video of Baldwin where he appears to cock the gun and possibly pull the trigger. That will be interesting to show. There's another video. Baldwin is asked to look at the camera and pull his gun and point his gun in the direction of camera left. Baldwin is then instructed to cock the gun, but he cocks the gun despite not being asked. Okay. So there's evidence he also pulls the trigger. Well, that just goes to show he's just not following the rules. He kind of acting on his own. There's another video where he can be seen exercising complete control and screaming at the crew to be quiet. I want to see these videos of him just screaming at everybody like, wow, wow, like, just shut up. I'm in charge. I think it's going to be great listening to him scream at people. Trying to make it bigger so it works. Yes. Reed was wrongfully convicted of an intentional act by Baldwin. No, I don't think so. Had Hannah Reed not done all the dumb shit she did, Alec Baldwin wouldn't have killed anyone. Hannah Reed was grossly negligent in her actions. Her actions were criminal at the end of the day. Playing with ammunition and like sitting in her trying to save money, so she's sitting in her hotel room playing with ammo and making it inactive. Like there, at some point, she should have known better, and the fact she didn't is still disgusting. But I get what you're saying, Barange. Lally is trying to be a tough prosecutor man right now. It's not working out well. He's a dumbass. So, but let's keep looking here. So Baldwin exercised complete control of his set by stopping the action sequence of filming of a scene with the minor child after his gun appears to become caught on his microphone wire. Baldwin can be heard cussing loudly while glaring at the crew. I hope we see that one. Oh, God, that's going to be great for that kid they hired. Like, yay, I'm working with Alec Baldwin. And he gets studied. It's like, oh, my God. Like, he just swears and screams at everybody. But yes, using his gun as a pointer, I want to see that one, too. He pointed his gun at the crew members while speaking them and fires his gun after a cut was called. Wow. Shooting blank rounds close to a camera operator. I think we saw that one. And he stops things due to his perceived error. So, yes, that shows he's truly in charge. Baldwin appeared rushing armor to reload a gun and other members to hurry. Yeah. I think that's the one we already talked about, where he comes out of the outhouse and he's just like, boom, boom, and he tries to like run up the hill and they all cut and you hear another bang. And then he comes back down hill. He's like, oh my God, we gotta hurry. I think that's the one they're talking about there. Biden can be seen Baldwin can be seen engaging in horseplay with his gun and pulling his gun when the scene didn't call for it. When he pulls his gun, the muzzle's pointed directly at another actor. Oof. Oof. Baldwin without the scene calling for action, Baldwin cocks and decocks his gun. So the camera operator asked to see the gun just so he could adjust the focus. Baldwin had his finger on the trigger. Jeez. Okay. When they say, is it working? He's saying, is that good for you? His finger's on the trigger. Which, here's the thing. Baldwin's story's got, remember, a good lie has some truth in it. So he was standing there saying, like, here is the gun good. Do you want me to hold it like this? Do you want me to hold it like that? How about this angle? How about that angle? Like this, blah, 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 blah. And the camera guy's like, yeah, it works for me like that. Cool. But in the meantime, he's got his finger on the trigger and he's cocking the hammer. Baldwin can be seen screaming intermittently throughout attempts at filming a scene, cursing loudly and rushing cast and crew. Yes, that's funny. The video taken by Sarah Zachary will be used to show Baldwin was having videos taken during his training. Okay. So these foregoing acts, which conform to a reckless mens rea, are blended with the factual circumstances of the charged offense. So once again, it's kind of like Hannah Reid. They're showing all the things she did show the mindset of she wasn't fucking serious about this. And they're going to show Alec Baldwin fucking around with the guns. He wasn't really serious about it. So that's how that's going to be used. How many drunken voicemails to his daughter? Yeah, well, that's... Yeah. I mean, here's the thing, though. Baldwin's admission he knew it was real is kind of a problem. Like, he knew it was a real gun. He knew it was a real gun. The argument is, guys, and here's the thing. Baldwin's not saying it wasn't a real gun. He's saying, I was told it wasn't loaded. That's the issue here. Baldwin understands it's a real gun, so don't get wrapped up in the whole prop thing. He understood it was a real gun. He's trying to say, they gave it to me and said it wasn't loaded, so it's not my fault. Bill says a prop gun still fires. Some prop guns do. Remember, not all prop guns are firing fully operational. I mean, remember, like, if this was on a movie set, this would be a prop. Remember, this is not a real one anyway. It's just for training purposes. That would be a prop. So, it was a practicing firearm, yes. Well, it was non-practicing, and then it decided to make the jump. People like 30 Rock, that's because Alec Baldwin is acting as the antithesis of who he is personally. That guy was meant to be like the Chad Big Dick Republican, and that's not who Alec Baldwin is. That's why people really liked it. Well, it took 1 second to see if it's loaded. Well, he's gonna open it up and he'll see the dummy rounds in it. So, oh, I check it, it's got dummy rounds in it. Click. So that's the issue. He's gonna say, I was told it wasn't loaded with ammunition. And in that regard, it should be fair because Hannah Reid is the one who introduced ammunition on the set. Now, his problem is you don't point fucking guns at people. That's his problem. And I don't know how he's going to overcome that. It's going to be tough. So, and they just point out that this evidence shows that he was criminal, negligent, and reckless. So there you go. That's what they're going to argue. And they bring it up, and it probably, I mean, I think all that's going to come in. I think that's going to come in, if I had to guess. So let's see here. Where is the trial order? Notice of hearing, request for hearing. Where's the order? Order. Here we go. There's a... What date is this trial again? I forget. I had it up earlier and I can't find it again. Let's see here. Is this it? Scheduling order. Yes, the local, so it's 8 days between, here, guys, trial is set for between, July 10th and July 19th, 2024. So July 10th and July 19th. I think I'll be available for almost all of it. So. Dead Tuba says, what I don't understand is why don't they have a duplicate deactivated firearm on set? I own a few of those revolvers. They're cheap. That's not the cheap part. The expensive part is it costs money because then you got to take it to a gunsmith who's going to have to do some welding. He's going to have to do some demilling of that gun. That costs time and money. It's cheaper for that prop house and those people. We're just use a real gun and not be, and they're going to say, well, we'll use a real gun and we're just not going to be fucking idiots with it. That's how they would do this. The problem is they were fucking idiots with it. So, yeah. Kimbo says, remember to like and subscribe. Thank you. Actually, it's my B-days that week. Cool. What are we looking for here? It's the whole competency crisis. Well, there's a competency issue, but it's also just in general. And it's weird because, like, it starts the 10th. The 10th. Oh, here we go. We're back, chattel.
I see that. I see that in Odyssey.
I gotta step away for a second, chat. But
The
I got
motion to dismiss indictment for destruction of evidence is listed twice. I think the first one is supposed to be the full and font.
That's our understanding too, Your Honor.
Okay, good. All right. All right. State's motion for in-camera inspection of joint defense agreement. State, under the court is ready. State.
Your Honor, at this juncture, I believe, this is Erlinda Johnson. At this juncture, the counsel for Ms. Hannah Gutierrez-Reed responded that there is no written joint defense agreement. And so unless there is a written joint defense agreement, I think that moots the state's request for the court to inspect any joint defense agreement.
So on the record, are you withdrawing your motion?
Yes, Your Honor, but we would like confirmation from the defense that there is no written joint defense agreement.
Well, notably I'm sorry.
So confirmed.
Okay, so confirmed. All right.
So the state would be withdrawing that motion at this time.
Okay, please prepare that paperwork.
Thank you.
All right, let's go into the full and font motion if we're ready. Are we ready?
We are, Your Honor, and I will be handling that with the court's leave for the defendant.
All right, thank you. All right, so the motion is, get my motions here. All right, this is the motion, Defendant Alec Baldwin's expedited motion for motion to dismiss the indictment for failure to allege a criminal offense. Okay, thank you. Go ahead.
Thank you, Your Honor. I haven't appeared before you before. My name is John Bash. I'm one of the attorneys representing Mr. Baldwin, and it's a pleasure to be here. One bit of housekeeping before I begin. I know we have a motion later today that involves witnesses. If you had a sense of when that will be, we can go ahead and start notifying the witnesses to be ready at a certain point in time, if that would be helpful to the court.
I believe after the lunch hour. This is probably going to take us to noon Mountain Time, this motion, or if it doesn't, we'll break at noon. And in other words, I'll call you back at 1, basically. Okay. Mountain Time.
Thank you. Thank you, Your Honor. And with that, I'll begin. May it please the court.
Yes.
We have moved under Rule 5601D to dismiss the indictment for failure to state a crime. And our submission, Your Honor, is pretty simple. Under State versus Henley, which is the New Mexico Supreme Court's authoritative construction of the involuntary manslaughter statute. That's at 2010 NMSC 39. In order to convict a defendant of involuntary manslaughter under New Mexico law, the state must establish the defendant's subjective awareness of a substantial risk that his or her actions could cause harm to another person. It's a subjective standard. It differs in that respect from certain other recklessness offenses under New Mexico law. And our submission, the state, and I think we will show this, has abjured any ability to show that Mr. Baldwin had a subjective awareness of a risk that the firearm in this case was loaded with live ammunition. Without that essential piece, the state cannot establish the element of the offense. It's not a question, Your Honor, of evidentiary sufficiency. It's not a question of how different fact finders can view the facts. It's a logical, legal question. The state has said that guns kill people. That's true. They kill people when they are loaded with live ammunition. If the state cannot even allege the essential piece that he was subjectively aware of a substantial risk that it was loaded with live ammunitions, they cannot prevail. Now, Your Honor, there has been a dispute between the parties about the extent to which the state is bound by its factual assertions in the Gutierrez-Reed trial, and I'm going to go into that in a little bit. But I don't think the court actually even needs to address that dispute, because the state's concession is on the face of the opposition that it filed to this motion. I direct the court's attention to pages 14 and 15 of that opposition. I think it was filed on May 21st. In response to our argument that they can't prove, and they haven't even alleged, that Mr. Baldwin was subjectively aware of a substantial risk that the gun was loaded with live ammunition, they don't say, yes, we can. And I'll get into this more in a second, but they say two things. They say, well, if he had done that, we'd be charging him with second-degree murder. That is a concession that they do not think he did that they cannot allege that, and they cannot prove that. Second, they point to a bunch of other stuff he did. And we'll talk about that, but none of that other stuff poses a danger to another person unless there's live ammunition in the gun. None of it does. They can't prove that element of the offense. They don't even claim to, and it's clear on the face of their opposition brief. So let me talk just briefly, Your Honor, about the Fool-and-Font standard, because I know you're intimately familiar with it, but the parties have joined issue to some degree on what that standard provides. And the state's wrong about this, and I just want to clarify why they're wrong about it. The original Fool-and-Font case back in 1995, as I'm sure the court knows, said there was a distinction between questions of fact and questions of law, and that a pretrial motion to dismiss under, I think back then it was 5601B, now it's subsection D, was only proper for questions of law. And the state kind of clings to this distinction between questions of law and fact. But critically, Your Honor, in 2016 and 2017, in the Pacheco and Platero cases cited in our brief, that's 2017 NMCA 83 and 2017 NMCA 14, the Court of Appeals rejected the distinction between questions of fact and questions of law. And you can see why. It's in any case where it's a question about the application of law to facts, you can always frame any particular issue as a question of fact or a question of law. So it's an unhelpful distinction. What the Court of Appeals said instead is take the undisputed facts in the case, whether alleged, whether the state stipulates to them, doesn't dispute them. Take those undisputed facts and ask, can the state on those undisputed facts satisfy the elements of the offense? And what the guidance that the Court of Appeals gave in Pacheco was that typically that inquiry will turn on this question. Can the state reasonably assert the availability of additional evidence to satisfy the elements of the offense? So it's no longer, Your Honor, an issue of whether it can be characterized as a question of fact or law. It's a question similar to motions to dismiss in the civil context of whether the undisputed facts show that the state cannot satisfy the elements of the offense. And just to tie the loop on that, the state suggests that mental state questions like recklessness, knowledge, intent can never be the subject of a successful Fool-and-Font motion. That is incorrect. In the published 2013 decision in Moreta, which we cite in our briefs and is at 2014 NMCA 60, the Court of Appeals did an intensive analysis of the facts alleged by the state to determine whether a full and font motion should be granted on a recklessness issue. There it was abuse of a nursing home patient by a doctor. So it is just not true that mental state can never be the subject of a full and font motion. It is true that it rarely is, but you rarely have facts like this where the state doesn't even allege that the crucial link between action and someone getting hurt, that the defendant had subjective awareness of that crucial link. That's pretty rare, and that's why this case is different. So, elements of involuntary manslaughter, and I don't think the state disputes this point. Under Henley, and the Henley case says this twice on page 108 of the Pacific Reporter, the defendant has to have subjective knowledge of the risk, of the substantial and unjustifiable risk that his or her actions will cause harm to someone else. I don't think that's disputed in this case. The state can correct me if I'm wrong. Critically, that's different than the way recklessness works under a lot of other statutes of this state. For example, the child abuse statute, which the Supreme Court just addressed a few months ago in the Taylor decision, has an objective standard. So it's what the defendant should have known. That's not true on involuntary manslaughter. The Supreme Court has been very clear about this. It requires subjective knowledge. What did the defendant actually know about the risk? So just putting those two things together, the full and font standard and the elements of involuntary manslaughter, the state's position cannot work logically. On pages 14 and 15 of their opposition brief, in addition to numerous statements they made on the record in order to secure a conviction of Ms. Gutierrez, their position is that no one could possibly know that there would be live ammunition on this set. They do not intend to argue, if their briefs and filings and statements are to be believed, that Mr. Baldwin had any subjective awareness of a substantial, not just any risk, a substantial risk that that firearm was loaded with live ammunition. If not, they can't show that he was aware of a substantial risk that whatever he did, whatever they allege he did, could kill somebody or could harm somebody. Because a gun does not kill people unless it has live ammunition. It just doesn't work. It doesn't make sense logically, and they have no answer to that basic problem. Now, we've given the court a number of cases from New Mexico and elsewhere analyzing involuntary manslaughter in the context of a particular weapon or object. And although the postures were slightly different, the basic question was the same. Can these facts enable a reasonable jury to find involuntary manslaughter? And the courts closely analyzed the nature of the object. In one case, it was a knife. In one case, it was concrete, and what the defendant knew about the object, and found and analyzed it that way. And the same analysis has to be done here. And if the state doesn't, as they don't, contend that he had any idea there was live ammunition in that weapon, he is not guilty. He's not guilty as a matter of logic and law. And the trial is not going to be able to overcome that. Whatever other things they alleged he did, if he didn't know it had bullets in it, he cannot be guilty. If he didn't know the substantial risk that it had live ammunition in it, he can't be guilty. Now, the state, Your Honor, essentially has three responses to this, and I'll just go over them briefly. One, the state links its position to an unpublished decision of the Court of Appeals in the Serna case. And in that unpublished and therefore non-precedential decision, the court canvassed a number of standards that it had previously used to resolve full and font motions. And the first one it canvassed or discussed was the question of fact versus law, and it said the defendant would lose on that standard, and the question in the case was recklessness in connection with reckless driving. But as I've discussed earlier, that standard has now been rejected in published decisions in Pacheco and Platero. So that is not a good standard. That was a non-precedential decision. It went on to apply the correct standard in the alternative, which was whether the undisputed facts show that the state cannot prove its claim. And there the facts were clearly disputed. The state disputed whether she had accelerated when she hit the pedestrian. There were disputes. Here, of course, at trial, we're going to dispute a lot of facts if it gets to a trial. But for purposes of this motion, we can take all of the state's factual assertions as undisputed, but they simply have not claimed that they can prove he had a subjective awareness of a substantial risk that the firearm had live ammunition in it. The second thing the state says, and they've said this a few times now, Your Honor, they say, well, if he had that knowledge, it would be second-degree murder. Okay, so a few things on that. One, they're just wrong about that. Second-degree murder requires a strong probability of death. If he knew there was a strong probability that there would be live ammunition in the gun and he fired it and pulled the trigger, which of course we dispute, that would be grounds for a second-degree murder charge. But substantial risk is a lesser standard. There's a significant delta between substantial risk and strong probability. So what they need to prove for this charge is that there's that he was subjectively aware of a substantial risk that the firearm contained ammunition. They don't even claim they can prove that. That's why it's not involuntary involuntary manslaughter. The other point on that, Your Honor, is that there's no rule that says any given factual scenario has to be able to satisfy every gradation of homicide. I mean, there are certain scenarios that are murder or nothing, based on the facts. And even if they were correct, which they're not, about the second-degree murder point, that would not establish that they can show involuntary manslaughter without showing anything about his subjective awareness with respect to the risk of live ammunition. What's really, I think, telling about the second-degree murder argument is what I alluded to earlier, which is that argument shows that the state does not contend it can prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. They said it in black and white. We would have charged him with second-degree murder if that's what we thought. They can't prove it. They don't pretend to prove it. As a logical matter, they simply cannot prove the legal elements of this offense. The last point they make, Your Honor, is they refer to a bunch of other alleged actions by Mr. Baldwin. And they say that those alleged actions are enough to satisfy the elements of the offense. So there's two things to say about that. One, none of those alleged actions pose a substantial risk to the life of another person if the gun is not loaded with live ammunition. They say he knew it was a real gun, okay? They say he pointed it and pulled the trigger. They say he didn't participate in a safety check. Again, this is not a civil suit under the ordinary negligence standard. This is not a suit for violation of the SAG guidelines. This is an involuntary manslaughter charge. And under this state's law, that requires subjective awareness that what he's doing poses a substantial risk that it could kill somebody. Pointing and pulling the trigger when you have no awareness
common sense
that the gun has live ammo in it, that there's no risk that it has live ammunition in it, does not pose that risk. Admittedly, this is an unusual case. Most people, when they encounter a gun in their home or somewhere, have reason to believe it might have ammunition, because ammunition typically goes with firearms. They're often preloaded with ammunition. In the typical defendant case, they're going to know that. But the reason the state won't allege that here is because it was a movie set, and this was a prop. And he was told by the people responsible for it that it was a cold gun. And the state told the jury, in order to secure a conviction of Ms. Gutierrez, that everyone on set believed it was empty. They told them that. They cannot come into this trial and say that he was subjectively aware. And to their credit, that's why they're not arguing that, because they can't. They know that's not true, and they know it would contradict what they said. So those are their three arguments. I want to briefly, and I just touched on it, talk about their prior representations. As I said, I don't think the court, to resolve this motion in our favor, even needs to get into that, because I think the state has effectively conceded in their opposition brief that they cannot prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. I think that's enough. But if the court does get into those prior representations, we've given the court a number of federal cases saying that it's a due process violation for prosecutors to take inconsistent views of the facts in two different cases arising out of the same event. Of course, there's exceptions if new evidence arises. For example, if they got an acquittal in the first case and they realized, no, we were wrong about that, we're going to take the jury's views to heart, and we're going to reassess our understanding of the evidence. That's not what happened here. They used a series of representations to secure a conviction of a person. And they sort of stunningly come into this court and say they're free to walk away from those and adopt totally factually inconsistent positions. I was head of a prosecutor's office for 3 years right across the border from El Paso to Austin, and I can't imagine us ever saying in a court filing we can take diametrically opposed positions on the facts of two criminal defendants. I would never have let an AUSA do that. We've quoted them in our brief, and I won't go on extended about all the ways in which what they're saying now is inconsistent, but just a couple, Your Honor. In their opening argument, and this is at Exhibit F of our motions in this case, they told the Gutierrez jury in opening that the prospect of live ammunition on that set was
This is more setting the
incomprehensible.
record for appeal.
You can't square that with saying that he had a subjective awareness that what he was doing could kill somebody. It was incomprehensible to everybody. They said it's a hard and fast industry rule that live ammunition should be miles away from a film set at all times.
Mm-hmm.
They said the gun was checked right before it was handed to him. This was in summation. Ms. Morrissey told the jury in order to secure a conviction of somebody that when Halls announced cold gun, that led everyone to believe the gun contained only dummy rounds. She said the crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job.
Mm-hmm.
She said, imagine I hand you a gun and I tell you it's basically empty and I walk away when in fact I put live ammunition on that. None of that is consistent with saying Mr. Baldwin had any subjective awareness that anything he did with that gun could hurt somebody else. It's totally inconsistent, and they should not be in the business of adopting factually inconsistent positions. Just a couple more, Your Honor, and then I'll get close to wrapping up my presentation because I know we have a lot to do on today. They've been inconsistent in other ways. In summation, the prosecution said it was completely foreseeable that Mr. Baldwin would manipulate the gun the way he did. But now they're saying that what he did was so out of bounds as to satisfy the standard of criminal recklessness, even though they said it was totally foreseeable on a movie set that he would do that. They said Ms. Gutierrez Reed had no supervisor when it comes to weapons and gun safety on the movie set.
Mm-hmm.
But now their claim is that Mr. Baldwin should have micromanaged her. At least I think that's their claim from these new producer theory allegations. So the state has been inconsistent.
Well,
as I said, Your Honor, I don't think you need to go there because I think they've made clear on the face of their opposition brief that they will not try to prove that he had a subjective awareness of a substantial risk that the gun was loaded. They just don't think they need to prove that. And they said, well, we would have charged him with second-degree murder if that's what we thought we had to prove, or if that's what we thought he did. Two other quick ones. A lot of their brief, Your Honor, is focused on the SAG guidelines. And it's a very, very strange sequence of arguments because they spend a number of pages saying that he was supposed to attend the check.
How is it? It's a weird thing. You're harping on the SAG guidelines too, man.
It's like Rule 12 of the SAG guidelines that are in the record. But I mean, if you just look at the face of this rule, it says the actor may attend the check. And if you look at the testimony they solicited from their own expert, Carpenter, at Gutierrez Reed's trial, he said this is just a dog and pony show, or it's to give a warm and fuzzy feeling to the actor. It's not necessary. And then you get about halfway through their brief, and all of a sudden they say, well, yeah, it's true. They don't actually require this. But this isn't a trial under the SAG guidelines. I mean, all that's right, but the SAG guidelines are totally irrelevant to this. I mean, whether he did the thing he can elect to do under the SAG guidelines has nothing to do with his subjective awareness that that gun in his hand could kill somebody. They also say, well, he's different than every other person on that set, every other producer, because he had the gun in his hand. Well, he's not different in the respect that matters for this element, which is, did he know that the gun in his hand could kill somebody? If anybody on that set knew the gun in his hand could kill somebody, they would have said, oh, stop. This is crazy. And that gets, I think, to my final point before I briefly address this new producer theory, which is that each of the actions, Your Honor,
is it really that new of a theory
that they say shows his recklessness and shows that they can satisfy the elements of the offense, pointing the gun allegedly at somebody and pulling the trigger, not attending the safety check, he knew it was a real gun, all those alleged facts that they assert in their motion. It's not only that they don't they don't satisfy the element of subjective awareness, it's that they cut exactly the other way. No one thinks Mr. Baldwin or anyone else on the set wanted to hurt anybody. The fact that they assert, some of this we can test, but the fact that they assert that he was pointing and pulling the trigger, that confirms that he had no subjective awareness that there was a live round in the gun. No one thinks he wanted to hurt anybody on the set. The facts they cite as satisfying their burden under that element show exactly the opposite. They show that they absolutely cannot show that he had a subjective awareness that that gun could kill somebody. No one thinks he would have pointed and pulled the trigger if he knew that, if he knew there was any risk of that. So the facts they cite show exactly the opposite of what they cite them for. Last point, Your Honor, they've raised this new producer theory. It's not totally clear to me exactly what they're saying, but I think they're saying one of two things. The first one is they might be alleging some sort of supervisory liability, even if Mr. Baldwin had no awareness. He was negligent in supervising Ms. Gutierrez-Reed. Now, there's a ton of factual problems with that. That wasn't his responsibility, but those are not relevant for this motion. What's relevant here is that there is no supervisory liability criminal statute. You can't establish the mens rea, the subjective awareness based on a supervisory theory. That can't possibly work. The other thing they might be saying is that he should have known the gun was loaded or something. They haven't articulated this, but it seems to be what they're saying. But again, it's not that standard. He must be subjectively aware. He must have subjective
They're not
knowledge of the
arguing
risk.
that.
And that's clear as day in Henley. That decision's controlling. And for that reason, they can't meet their burden on this. So we reserve time for rebuttal, of course, but we respectfully ask this court to dismiss these charges because Mr. Baldwin is innocent as a matter of law. Thank you.
All right, before the state responds, I have a couple of questions over some of what you presented. So you said that that you can take the undisputed facts under full and font. And I'm interpreting that to mean that you can ignore the disputed facts. And I don't read full and font to be that.
No, Your Honor, the way I would describe it is you
Guys,
give the
I'll
state
clarify this
everything
this
they're alleging. So some of those facts are undisputed and some of those facts may be disputed. So for example, there's a dispute about whether he pulled the trigger. Give the state that, obviously not at the trial, but for the purposes of this motion, give the state those disputed facts. Assume they can prove. The way Pacheco describes it is there a reasonable probability that they can obtain evidence to prove those elements? So if they, as long as it's not totally ridiculous, if they say this is a disputed fact, we think he pulled the trigger, give them that for the purpose of the full and font motion. Can they prove the elements even with that? And our submission is that no, they cannot, because they don't even attempt to allege that he had a subjective awareness of a substantial risk that firearm was loaded with live ammunition. So give them everything else they say. Give them the disputed facts. They don't dispute that. It's clear on the face, pages 14 and 15 of their op. They do not dispute that.
Guys, so what's happening here? They're making the argument that given all the facts, and they're basically making a summary judgment motion at this point. It's a 12B, it's not 12B6, but it's basically the same thing. They will say, for the sake of argument, we'll agree that everything they're saying is true, even assuming that, based on New Mexico law, he has not committed a crime. They're saying he had no knowledge the gun was loaded when he pulled the trigger, and that's the only way he could engage in risky conduct like that and commit manslaughter. The problem is the state, I'm sure, because I think they made this argument already, and I'm sure they're going to make it more exquisitely. You don't point guns at people. You don't point guns at people is going to be their argument. That's the dangerous thing. I don't think that's a Bible behind them. Maybe it is. I don't know. And some of you guys are like making points about the, if he just checks it and goes, yep, those are fake bullets. Okay, we're good to go. That wouldn't relieve him. I don't think it would relieve him anyway. You don't point guns at people because you can't be assured those are not live. That's why you don't point guns at people. I mean, we've gone over this before. What happens when people get shot? What is the number one response in the aftermath of somebody getting shot that wasn't meant to be shot? I didn't know it was loaded. That's why you don't. That's why you don't. Michael Stetson, they were firing weapons before the incident. No, they were not. Eric Huntley has actually been great about... David Hall said that he confirmed that in the New Mexico OSHA hearing, there weren't live ammo on set. The live ammo on set came through because Hannah Reed was fucking with ammo trying to make dummies. Eric was able to verify through his sources, and it's confirmed they were not doing live firing before the movie. Now, where those guns that came from, the Yellowstone 1883 stuff, yeah. Taylor Sheridan makes his people shoot guns. But on the set of Rust, they were not touching live firearms at all in any sort of coordination with the set. So there was no live ammo on set for that stuff. It's because Hannah was fucking around with all the ammunition that live ammo got on set. That's how that happens, it looks like, at this point. So, and Ron, they're saying people knew, there were people there who knew of Hannah taking people to shoot guns when they weren't filming. Like I said, speaking through Eric Hundley, that was never brought up to a trial. That never happened. That was a story that kind of got legs early on and kept going. And Eric Hundley was able to helpfully, through his sources, I'm pretty sure Seth Kenny, they quashed that and point out it wasn't true. Itaku saying, I think these arguments would be stronger if Alec kept his mouth shut. 100% they would be. By far stronger. Is he soapboxing now? Yeah, but you're also making a record for the appeal. Because all this becomes part of the appeal. All these hearings become part of the appeal. Not just the trial. So. Hubbleson says he had no way of knowing if they're real or fake bullets. Yeah, because the way Hannah did it, the dummies were like fully weighted. So like there was no way to know. Ron says Hannah did take some people out target shooting during a break when the filming was going on. From what I understand, that's not true. And if it wasn't done with the guns on set. They weren't using the ammunition. The live ammo came from Hannah Reed in her apartment or hotel room trying to make dummy ammo out of live ammo. I mean, if you have something to show contrary, I'm 100% willing to go with it, but we'll see. And hold on, what's this? Okay, yeah, so I'm just saying, like I said, I don't know. Based on what I know, they weren't doing that. Oh, Siobhan, you're talking about the lady who killed her girlfriend and she killed her boyfriend. Yeah, she got prison for that. Michael says, all I know is what I read and hear about it. I'm 100% willing to change my mind. No, I understand. That's why I'm trying to be nice. Like, look, guys, new facts have come in. So, anyways, let's hear what the state says. This is not going to succeed anyway. Baldwin's team is making arguments for the sake of appeal and for zealous representation, but this will not carry the day, guys. So let's see what happens.
What about the disputed facts? You talked about that they've raised additional facts. What about all the case law that says if you have disputed facts, it's for the fact finder? It is not for the court.
Your Honor, that's true only where the disputed facts, if resolved by the fact finder in favor of the state, could satisfy the elements of the offense. Our submission today is that assume the fact finder resolves every disputed fact in the state's favor. They do not contend he was subjectively aware that the gun in his hand could kill somebody, because they don't contend that he was subjectively aware that there was any substantial risk that it had live ammunition in it. So give them everything else they say. Give them they pulled the trigger. Give them he didn't attend the safety check. Give them all that for the purpose of this motion. Assume the jury resolves all of that in their favor. They still can't meet the elements of the offense. And that is the essence of a fool and fawn. I would call it a Pacheco motion, because Pacheco really refined the standard. But that's the essence of the motion presented to the court right now.
All right. Well, let me read from Henley, because you read a certain portion of Henley, but there's more to Henley. And it says, criminal.
And this, guys, here's what happens when you cite part of a case. I know we talked about this with Barnes, talking about how the standard in Minnesota for personal drug use. Like, yeah, and then remember what I showed you guys when I was on the mindset. There's a whole nother paragraph attached to that. They're going to point out, this is an issue here. Here we go.
Negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness. in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions. 14231. To be convicted of involuntary manslaughter, defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else. The SAG guidelines that they don't completely rely on, and I think you said that they rely on. If you said completely, they rely on them in part, and they're saying that as an actor, he, despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone, and there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to. So I'm curious as to how you have limited it to he has no knowledge because he got to rely on his armorer, he got to rely on David Halls, and you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements. And that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, Muriata, which you rely on very heavily, it says, State versus Muriata. Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Muriata in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide. So to me, and you did acknowledge that they have additional facts, and under the case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the core of whether the jury believes your facts about the armor and David Halls and that he had every reason to be able to rely on them, and the state's alleged facts that he was the producer, he knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false. I'm just wondering how you're reconciling these things.
Let me take a stab at that, Your Honor, and let me give you the short answer and then the slightly longer answer from both case law and the record. The short answer is add up all the facts that they say are disputed. Assume they win those. It still doesn't meet the legal elements of the offense. So you can imagine even easier cases than this, where something ridiculous. There's a murder charge, but the person's not dead. And no matter what else is disputed, they're obviously not going to be able to prove a murder charge if the person's not dead. It doesn't matter if there's disputed facts. In this case, and let me pick up on Henley. Your Honor quoted the carryover paragraph from pages 107 to 108
That's a good
in the
question.
Pacific Reporter. The very next sentence, the first full paragraph on page 108, gives the standard that's at the heart of our motion. It says, our case law has long interpreted the requirement of subjective knowledge into the requirement of subjective knowledge into the showing of criminal negligence required by our involuntary manslaughter statute. Later in the same paragraph, it says criminal negligence in the context of involuntary manslaughter requires subjective knowledge by the defendant of the danger or risk. So the parts that Your Honor quoted are the model instruction. We don't take issue with any of that. They may also have to prove objective knowledge, which is the should have known standard. But the subjective component, whether it's an independent component or part of what willful disregard and conscious disregard means in this context, it's clearly a requirement of the statute. I don't hear the state to disagree with this point. I mean, they can read the case just as well as anybody, and I don't hear them to disagree that subjective knowledge is a requirement under the statute. Now, Your Honor asked about these different factual allegations, whether the Halls check was insufficient and so forth. Our submission is that even if all those were true, just as a logical matter, if he is not subjectively aware of a substantial risk that there's live ammunition in that gun, and they don't allege he is, he cannot satisfy that element of the offense because the only way that gun can kill somebody is if there's live ammunition in it. They can allege whatever else they want about he violated the SAD guidelines or he did this and that. But if they can't allege that he has plausibly, that there was he was subjectively aware of a substantial risk that the firearm contained live ammunition, they simply cannot meet the elements of the offense. I know Your Honor asked about Moreta. That case in the quote Your Honor presented says generally intent is a question for the jury. And we have no dispute with that. I mean, in most cases, recklessness, knowledge, intent, that's going to go to the jury unquestionably. But where the state cannot allege, does not even purport to be able to prove an essential link, namely that the defendant understood that his actions had a substantial risk of hurting somebody else, it should not go to the jury. The rule 60, the rule 5601D standard is there because the judge is a critical gateway on allowing defendants to be prosecuted for things that are not crimes. What they have alleged here is not a crime. You cannot be guilty of involuntary manslaughter if you had no awareness of the substantial risk that what you were doing could harm people. And in the case of a gun, in this very unusual case of a prop on a movie set, where everyone, according to the state, believed it was empty, you cannot satisfy the mens rea for involuntary manslaughter.
Thank you. State's response.
Your Honor, as a preliminary matter, I want to ask the court. I know that the defendant filed a request for supplemental briefing, kind of along with a supplemental brief yesterday, and we provided our response to that at around midnight. Is the court permitting the additional briefing? I hear Mr. Bash arguing the law and the facts that are in the additional briefing. So I just want to know what I'm responsible for.
No, I did not see that, and it's late. So,
Okay.
Your Honor, can I just respond? Other than the brief mention of the producer theory, I don't think anything I argued had anything to do with the supplemental briefing.
So he's right, but that's important because he said the state's new theory of him being a producer. Judge, you even know about it, so it's not new because I believe it came out during the Gutierrez trial, and as we indicated in our response,
here's what we're doing. Here's what we're doing today. What I received and what I set for hearing. So a supplemental briefing that arrived yesterday is not on the table in my decision.
Understood. Thank you. I'll go ahead and proceed with my response. The circumstantial evidence that the state intends to present that goes squarely to this issue is Mr. Baldwin knew he had a real gun in his hand. Mr. Baldwin specifically asked for the biggest gun that was available. Mr. Baldwin knew and understood that dummy rounds look identical to live ammunition. That's the foundation. So before Mr. Baldwin has ever even encountered training by Ms. Gutierrez, that's where we are. He then arrives to his training with Ms. Gutierrez and doesn't pay attention. Not only did Ms. Gutierrez indicate that he didn't pay attention, Ms. Zachary actually took a video of him not paying attention. And it's one of the exhibits that will be used in the destruction of evidence motion later today. So he decided not to pay attention during his training. Then, and look, anybody who looks at Ms. Gutierrez understands that Ms. Gutierrez hasn't been alive long enough to legally own firearms. So there has to be some question about, is this person really qualified to have this job? Any reasonable human being would have that concern, and many of the crew members actually mentioned that to the producers. How can this lady be our armorer? She's like in her early 20s. So Mr. Baldwin certainly understood that. He had a bad armorer. She wasn't doing proper safety checks. His experience in the film industry is absolutely circumstantial evidence that he knew that when she was doing these safety checks that she wasn't following the rules. Absolutely, the court is right. He also understood that Mr. Halls was not checking the gun with Ms. Gutierrez every single time. We know that he knew that because that's what he said to law enforcement on October 21st. So we get to this point. Now let's take into consideration that there are two other actors on set that Mr. Baldwin can see dry firing their guns into the ground 10 times after the gun is handed to them by Ms. Gutierrez to ensure that every single round is inert. Are those actors on my witness list? No. Do I have plenty of other witnesses who are going to come in and say, we saw those people dry fire their guns into the ground every time she handed it to them? Absolutely. Plenty of witnesses are going to testify to that, and Ms. Gutierrez herself should be able to testify to that based upon the court's ruling, because that certainly wouldn't be anything that she could assert her fifth to. So that's where we find ourselves at this point in time. Now, what Mr. Bash is telling the court, which is absolutely false, what he's telling the court is, unless this gun has a live round in it, it is completely harmless. And he didn't realize that there was a live round in it. Patently false. Mr. Baldwin himself, as I recall, had a conversation with law enforcement, and I may be wrong. I've read a lot of transcripts. He indicated an awareness that if he is handed a gun that has a blank round in it, but also has a barrel obstruction, that is fatal. That can kill someone and has historically killed people. I believe that that is the circumstance of the death of Brandon Lee, that almost everybody who works in the film industry is familiar with. So Mr. Baldwin didn't necessarily have to know there's live ammunition in this gun. He had to understand that the gun is real. Real guns are dangerous. Dummies look exactly like live ammo. Even if there's not a live round on set and she put a blank in instead of a dummy and the gun had a barrel obstruction, Halyna Hutchins is dead. She's dead. And she's dead because he didn't participate in the safety check. And listen, we agree, and we have always agreed, that under the SAG guidelines, which do not dictate New Mexico law, the SAG guidelines indicate that that is optional. He chose not to participate, and I'm sure that's a decision that he's grown to regret. So he chose not to participate in that safety check. Then he decided to point a gun at a human being, cock it when he wasn't told to cock it. We have plenty of video of him cocking guns when he wasn't supposed to, when he hadn't been told to, when the scene didn't call for it. And then, of course, he pulled the trigger, killed a woman, and seriously injured someone else. So that's the landscape, and the court is absolutely 100% correct. The defendant has spent pages and pages and pages and pages arguing, we don't agree. We don't agree to the facts. There are really no stipulated facts. The state isn't stipulating that in order for that gun to have killed someone, it had to have live ammunition in it. Everybody knows that's not true. Now, let me clear up a couple of other issues. The reason that these safety rules exist, the entire reason that the SAG Safety Bulletin #1 exists, is because of the risk that live ammunition could find its way on set. If there was absolutely no chance that live ammunition could ever find its way onto a movie set, why have these rules at all? You've got two actors standing right next to Mr. Baldwin who certainly understand that there's a significant risk of live ammunition, or they wouldn't be firing their guns into the ground right in front of him. Now, our expert, Brian Carpenter, will testify, and testified before the grand jury, and I think he even testified during the Gutierrez trial, that as an armor, he himself has found live ammunition on a movie set. So what Mr. Bash alleges with regard to the distinction between involuntary manslaughter and second-degree murder, really, I don't think gets him where he needs to be. If I am an actor and I have reason to believe that I understand that there is a substantial risk that there is live ammunition on a movie set, and I take that gun and I point it at a person and I cock it and I pull the trigger, that is second-degree murder all day long. We can argue about that all morning, but that's not going to change. You know, I think that where the parties disagree here is when Mr. Bash was talking about the link, the link between the subjective knowledge and the offense, the link between the conduct, the subjective knowledge and the offense. We disagree on what the link is. Not only do we disagree on the vast majority of the facts, we disagree on that link. This motion by Mr. Baldwin absolutely cannot be granted by this court. There is a plethora of case law that says you can't do it. And what is happening here, which is what frequently happens in this case, is the defense attorneys are coming forward to the court and they're saying they're making statements that are not at all based on the evidence or the future witness testimony. One of those statements that was given today, of course, is Mr. Bash's statement, this gun can only kill someone if it's got live ammunition in it. Absolutely false. And Mr. Baldwin knew that was false. So we need to simply rely on New Mexico law. We have an extraordinary amount of circumstantial evidence that goes directly to this point. Some of that evidence you may see this afternoon because it's relevant to another motion. The court, if the court in Cerna, which is the unpublished case that the defense, that the state cited, that the defense was certainly aware of. They were aware of Cerna, they were aware of Gomez. They didn't cite him because they were hoping, I guess, we wouldn't find him. So when you look at Cerna, there's a video. There is a video of a person driving and a pedestrian stepping out in front of them. And the only dispute between the parties is exactly what Mr. Bash is bringing to the court's attention today, which is, with substantial risk, how can you get there when you look at this video and all this lady, she wasn't speeding. All she did was just kind of make this turn and hits this pedestrian. And for heaven's sakes, it was an accident. And in that circumstance, the court said, no, there are disputed facts. There are disputed facts here. And we are asking the court to follow well-established New Mexico law and deny the defendant's motion. Thank you.
Response,
Your
Mr. Bash.
Thank you, Your Honor. Much of what the government just said is incorrect, but as an umbrella point, much of what the government just said is waived. It appears nowhere in their opposition brief, the point about blanks, the point about what two other actors were doing on the set. There's been a lot of sandbagging in this case. It's not proper for when we make an important dispositive motion, the state not to present those arguments in their written submission and then to debut them for the first time at argument. The arguments are wrong, and I'm happy to address them. I will in a second. But a lot of the points you just heard are not found in the brief of the state, and that you can't raise something, an oral motion, for the first time without previewing it. So let me take each of those points in turn. Ms. Morrissey went over a lot of their allegations, and some of them just have obviously no bearing on the issue before the court. Whether he selected the biggest gun, whether Ms. Gutierrez looked too young for the job, that has no bearing on whether he had a subjective knowledge of a substantial risk that the gun in his hand could kill somebody. They've given a lot of facts. Let's give them all those facts. Let's give them all the jump balls. Let's say that they're right about everything they say. That does not establish the element of the offense. And we've been over some of those in the opening presentation, that he had the gun in his hand, that he knew dummies look like live rounds. The fact remains that they told a jury to secure a conviction that everyone on that set did not believe there were live rounds in that gun, and that it was inconceivable there could be live ammunition on that set. And everyone includes Mr. Baldwin. Now, they've raised two arguments. I guess they've realized that they have a big problem, because if they can't show that he had a subjective awareness that that firearm was dangerous in his hand, they can't prove their case. And so they've raised two totally new arguments, which were not in the opposition brief. Someone can correct me if I'm wrong. I'm doing it from memory, but I don't remember seeing these arguments in the opposition brief. First, they say that Mr. Baldwin saw two actors dry firing their guns, but they're not going to call those actors, but they saw it. I don't see that anywhere in the brief. Second, they say that it's not true that you need a live round. In certain circumstances, a blank could kill someone because there could be an obstruction in the barrel and it could go off. But no one contends, Your Honor, that he thought there was a substantial risk that that gun contained blanks, because as everybody knows, and I'm sure the court is very familiar after sitting through the Gutierrez trial, they look completely different than dummy rounds. Dummy rounds are the ones that look like live rounds. Blanks look totally different. And I'm not aware the state has ever contended that Mr. Baldwin was aware of a substantial risk that Mr. Halls or Ms. Gutierrez loaded blanks into that gun, which looked totally different. It's not even remotely realistic that that was a risk after two professionals loaded the gun, that they accidentally loaded it with blanks. So that is an argument that the state just made up at arguments. They didn't even include it in their written briefs, and it's completely preposterous in light of the reality of what blanks look like. It's an argument to try to get past a dispositive motion that doesn't actually have any weight. I would just add that I think they would have a huge problem with the foreseeability element if their theory was that he foresaw that there could have been obstruction that could have injured somebody, but actually what happened was totally different, and so he's guilty. I don't think they could satisfy foreseeability, but at any rate, the argument's waived, and it's factually ludicrous given that these things look different. There's no way he could have had a subjective awareness that there was a risk they were putting blanks into that gun. Ms. Morrissey referred to the SAG guidelines, and they say we have these prophylactic rules under the SAG guidelines because, there's some chance of live ammunition, and so you can never say there's no chance. Again, let's assume she's right about all that. I don't want to get into whether she's right about the purpose of the SAG guidelines. The standard is not no chance. The standard is a substantial risk. You heard it again. They can't argue substantial risk. They can't argue subjective awareness of a substantial risk. They would have charged second-degree murder if they thought they could argue it. So they moved the goalpost. And they've moved the goalpost to, well, we can't say there's no chance. I mean, there's always some 0.0001% chance of anything happening. But that's way far away from the element of this offense, which is substantial risk. She doesn't argue that properly because she can't argue that. She changed the goalpost. I heard her say something about the second-degree murder. Well, you're just wrong about that. Mountains of case law say you're wrong. There was no case law cited. There was no logical reason given. Second-degree murder in this state requires a substantial probability. If the state could allege that Mr. Baldwin thought there was a substantial probability that there was live ammunition in the gun and could satisfy all the other elements, that would be a different story. But what we're saying is they haven't even alleged a substantial risk. There's a big delta between strong possibility and substantial risk. And if they can't even allege that, then it's not involuntary manslaughter. It's an accident for which he's not criminally liable. I heard Ms. Morrissey say that there's a plethora of case law that says you can't do a full and font motion in these circumstances. There's not. They don't cite it. They just keep saying there's a plethora of case law. Moreta stands for the exact opposite proposition. It says generally they're not going to be successful. We have no truck with that. Of course, generally the prosecutors are going to be able to get intent to the jury. But this is an extraordinary case where they're charging somebody with an accident based on a movie prop when they told another jury that everyone thought it didn't have live bullets in it. This is an unusual case. And Moreta would have had one sentence of analysis if the rule was you can't succeed on a full and font motion on a question of intent. It didn't. It went very carefully through the allegations, and there was an attached affidavit, and it went very carefully through all that and said, okay, the state has enough here to prove the case. So they're wrong about that. And finally, I mean, Ms. Morrissey says, well, I know why the defense didn't cite Sarah because they're scared of it. I mean, it's an unpublished, non-precedential decision that alternatively applies a test that the Court of Appeals rejected in 2 published decisions. Okay, so it's not controlling. It does alternatively apply the correct standard, which is what the undisputed of facts allow the state to prove. And I mean, it was just a case with completely different facts. She said it's exactly the same thing. It's not. One of the facts disputed in that case, which was a vehicular case, a reckless driving case, was whether the defendant had accelerated at an unreasonable rate right before she hit the pedestrian. That was an actual factual dispute that goes to recklessness, and that could be dispositive. In this case, the state does not claim that he had a subjective awareness of a substantial risk that the firearm contained live ammunition. It's not disputed. For everything that Ms. Morrissey just said, they're not disputing that. She was candid. She did not sit here and say they can dispute that. There's a reason she didn't. They know they can't prove that. They know it would be inconsistent with what they told a jury to get a conviction of somebody else. They can't prove that. If they can't prove that, they can't establish the elements of the offense. And with that, I'll sit down, Your Honor.
Court makes the following ruling. The court denies the full and font motion of the defense. The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known. With respect to the inconsistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit, U.S. versus Gandon Negro, is on point where it's got to go to the core, prevail on due process claim. It's got to go to the core, and that it's got to be just so inherently contradictory. And I think that I think part of what the state's relying on is what Ms. Gutierrez didn't do. Okay, and the court will prepare that order as well. I will see you back here at 1 o'clock. Does that work for everyone?
Your Honor, before we recess, I just have a question. The defense mentioned that I'm going to be arguing the Trombetta motion. We have 3 witnesses. The defense indicated they have witnesses. May we ask who they plan to call for that? I don't know their witnesses.
Yes, Your Honor. As always, it somewhat depends in part on who the state calls. It may be that we don't have any witnesses if they're calling the same witnesses. So we notified Corporal Hancock, Mr. Ziegler, and Mr. Haig. But if that's the same set of witnesses that the state's calling, we, of course, will be efficient with the court's time and not recall people.
They are, Your Honor. Same witnesses.
Okay,
So
very
then
good.
we will, yeah.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Real quick, Mr. Spiro, are you referring to Michael Haig or Luke Haig?
Luke Haig.
Okay, all right, thank you.
All right. Thank you.
Thank you.
We're in recess.
All right, guys, we got through that. 319 people here, guys, watching. Hey, thanks for being here. you're new, my name's Sean. I'm an attorney in Cleveland, Ohio. Go by the name Potentially Criminal. And we are watching all these hearings or these motions for Alec Baldwin's case. Now, we're getting ready for trial. Alec Baldwin's set for trial in, let's see here. July 10th is the first day of trial. So we are we're about 2.5 weeks out. So almost 3 weeks. Alec is getting very ready to trying to get rid of this at the last chance possible. So that's why they're throwing out motion to dismiss, motion to dismiss, motion to dismiss. You heard also that was an interesting one, and I don't know if you guys heard it. There was an issue about seeing if there was a joint defense agreement. Now, that was an interesting thing because there were concerns that they were all working together. And if you guys hadn't seen this before, this is what happened. And this is part of the issue here. And I thought it was very interesting because this didn't get a lot of traction or a lot of news. Carrie Morrissey, the prosecutor, filed a subpoena, and a subpoena. Oh, God, why do you do this? I clicked on you. A subpoena duces tecum. Okay? Duces tecum, meaning all your stuff. And it's subpoena to Jason Bowles, not Jason Bowles, care of Hannah Reed. Nope, to Jason Bowles. And you're hereby commanded to bring to Carrie Morrissey the following: all documentation regarding communications between any employees or contract employees or agents of the Bowles law firm and Alexander Ray Baldwin, any attorneys or other employees of the Quinn, Emanuel, Urquhart, and Sullivan law firm. That's the big New York City law firm representing Baldwin. And any other attorneys acting on behalf of Baldwin and any representative of Baldwin or Baldwin's counsel. They were seeking any proof that there was a joint defense agreement for this. And they were seeking everything they could. Burranger saying, who was that one frame of Specs appeal? What? Not really sure. Okay. Well, 2.0 says I can't remember sleeping in my office. Is this the fat guy Katie yelled at while hauling cocaine? Well, I don't know if he was. I am the fat guy yelled at. I don't know what he was doing at the time. So, what is a joint defense agreement? Why is it important? Well, that becomes an issue of what are they doing? What are they agreeing? How are they working together? So that becomes an issue. That is a very, very, very interesting thing. And why is that an issue here? Well, and we'll get to that because the state explains that. And for some reason, this printed out on the screen horribly. This is not my fault, guys. This is the way the PDF shows up. The state is responding, and the state filed a response to Jason Bowles. And they point out that all the things that happened here, and this is where Jason Bowles kind of fucked up. When the state obtained the telephone records of Hannah Reed, remember where that happened. They got the telephone dump, and he didn't object to all the information they were getting. They got the download of Hannah's phone, and it contained messages between Jason Bowles, Thel Reed, and Hannah Gutierrez Reed when they were discussing things. Well, at that point, there's no longer attorney-client privilege because Thel Reed is a third party, so it's done. Now it's information that's no longer privileged. Remember, guys, to do attorney-client privilege, you can only have your attorney and the client. It's not attorney-client and everyone else. It's attorney-client privilege. So they discussed a phone call with Alec Baldwin placed to Mr. Bowles' office without the presence of counsel, and during which Mr. Baldwin, according to the summary that Bowles provided to Hannah Reed and Thel Reed, stated he was anxious to speak to Bowles and Mr. Baldwin stated he just gave an interview, the one to George Stephanopoulos, to talk about what he's been through. Baldwin continued that he wanted Bowles to know he wants to get to the bottom of this and explained he had no problem with Hannah, and then this happened. Okay. Now, we get through all that, and this Baldwin kept talking about, other things that he went on, said he doesn't understand what's going on. He is so sickened to not getting the truth. The police have right intentions, but he gave in the interview that he can't wait to solve the case. He had concerns. Baldwin's concerned that grows of people think he killed this woman, and he had to say something. So that becomes an issue then, because remember, Alec Baldwin's not represented at that point, or if he is, he's talking to a party he doesn't have privilege with. So all these statements are available. All this stuff became available. And then they point out that the court denied Hannah Reid's motion for dismissal or to suppress all the attorney-client communications and recusal of the prosecutors. Remember, they talked about all this. But Bowles set that like a bump on a log and didn't try to protect documents. So it all came in. Hannah executed a full consent of her cell phone and agreed to express or implied promise were never made. And the state requested documents relating to Mr. Baldwin's statements to Bowles, and as insisted that information is admissible. So that's what happened here. They have the right to do this. They have the right to do this. Bowles tried to use attorney-client privilege, but it doesn't work. They were arguing about a common interest doctrine or a joint defense agreement, as is more commonly known. Now, there are times where a joint defense agreement is where, in Miralist, you're asking about that, everybody agrees to work together. We're all agreeing to work together. We're going to pool resources. We're going to do everything necessary to make a joint defense agreement. Well, in response to that, Bowles said, well, we are. Okay, so show me proof you guys are working together. Because otherwise, there's no attorney-client privilege. Because remember, Bowles is representing Hannah Reid, not Alec Baldwin. But if there's a joint front there, the team, if everybody's working, together forever, if they're all working together, then yeah, there would be protections. But there's none because they aren't working together formally. That is the big issue here. So the way it works with privilege is you can't just claim privilege and walk away. You must claim the privilege and establish that there's privilege on a document by document basis. And that's true. If the state wanted my papers, well, I couldn't just say, oh, it's all privilege, fuck off. Now, ideally, a court probably would say that and agree with it. But that's where it becomes an issue. You have to prove what's going on there. And you have to prove that, yes, Judge, all this stuff would be protected. And very likely the court would go, yeah, I agree, it's all protected. So where is sort by? Let me see here. Open with, sorry. Oh, sorry, guys. Hold on here. What am I looking for here? Why is it not working here? Sorry, guys. Hold on here. Why did this thing go down? Okay. So as it relates to subpoena, the information doesn't retain privileged communications. It's just proving, do you guys have an agreement? They're allowed to ask for it and call it out. Because let's say Bowles tried to make that claim during trial. Well, Judge Summer's going to say, do you guys actually have an agreement? And he'll say, let me go. She'll like, go get it. Prove it. So that's the issue there. And here's the big thing for Alec Baldwin. He may waive attorney-client privilege by sharing communications with a third party, even if that's another attorney, because it's not your attorney. So that is the issue. And they point out that even if there was a common interest, that on December 1st, 2021, Baldwin had not entered into that agreement with Hannah Reid or her counsel. Even if Alec Baldwin had done so at the time, it doesn't apply to statements made by him to Bowles or his staff. You know, this rule protects confidentiality, this common interest rule, when it's from one party to the attorney for another party under the attorney-client privilege, where a joint defense effort or strategy has been decided upon by the respective attorneys. So that becomes the issue here. Is the privilege protects communication between an individual and an attorney for another when it's part of an ongoing and joint effort to set up a common defense. And they haven't done that. They haven't done that. So that's why they were talking about all that stuff. Do you think Bowles knows about the Baldo? No. But Muralist, I hope that answers your question. I hope that answers your question, Muralist. Robert Lawrence says, couldn't a person speak on behalf of someone to an attorney? Wouldn't that be privileged? It's going to be very important. Going to be tough. You've got to be careful with those things. So, for example, if Alec Baldwin's sitting there with his agent and the attorney talking, probably not. Now, if his agent contacts the attorney, I would argue that's probably, if it's clearly a fiduciary, like there's clearly that kind of setup, you might be able to get away with it. Still, that's going to be risky. That is going to be so risky that, you know, there's only so much they'd be talking about anyway. And you don't want that guy coming in there and saying, hey, by the way, Alec Baldwin told me he did it and he fucking enjoyed it. Like, you don't want that to happen regardless. So you'd limit. Are we doing the retrial later? Yeah, we're going to try it in a little while. We are going to try in a little while. And we got to get back to the next New Mexico thing. We have an hour chat. Oh, we got an hour. We've got an hour. So I know Kieran Reed's picking back up. If you guys don't want to sit here and wait for an hour. What we are going to do, because I did find it, we are going to watch Jensen Ackles' interview as much as we can get. So. All right, so here we go. We're going to watch Jensen Ackles' interview, if you guys have not seen this before. And this is from Crime Circus Cult. He's got it. I couldn't find the original here, because I'm going to try to back out, see if I can find it real quick. Let me see if I can. Police interview. Let me see. Yeah, there's no. Okay, well, and then it gets to the supernatural working with the FBI. Well, that's not what we want. So we don't have it. We're going to use this guy's thing just to make it easier, okay?
All right. You got my boost.
All right. So here we go. This is Jensen Ackles' interview. We're going to watch this for a little bit. I know some of you guys were curious, and he's going to be a critical witness, I bet, for the state. He's going to be a critical witness, I bet, for the state. So here we go, guys. Sorry, I just put that together. So we've got a little bit of time here. So Let's watch Jensen Ackles. I think this will be very, very interesting. I have not watched him all the way. Also, let's make sure I didn't miss any. Future Mrs. Martin 2.0 gifted 10 memberships. Sweetheart, thank you for your support and your generosity. Catnot Williams gifted 5 memberships. Thank you. Thank you very much. Oh, actually, here's a couple. Rotten Dark Rabbit saying, why is the judge making the argument? Isn't the state supposed to do that? To an extent, yes, but the judge is pointing out like your argument's not making sense, and she's allowed to point out if there's holes in an argument, and she already knows the law on an issue. She's allowed to do that. She's allowed to ask those arguments. So it's not really improper for her. It's not like she's arguing on behalf of the defense. So I understand what you're getting at there, but yeah, I wouldn't be too worried about that. I wouldn't be too worried about that. But then EDW Raptor again for 5 memberships. Thank you. Thank you. So I hope that answered your question, and I hope you're still out there watching on Twitch. Oh, let's see here. Rotten Dark Rabbit. So the state has access communications between Hannah and Alec. That would be, they don't necessarily have issues. They don't have the communications of that. But anything Alec Baldwin told Jason Bowles would be 100% discoverable. Because those are statements of Alec Baldwin. And Jason Bowles has no privilege to protect him. So everything he said there is going to be discoverable. Bella says, I DM'd you the video of Alec's earlier live fire accident. Is it the one I'm thinking of? Because if it is, we'll watch that too real quick. Thank you, Bella. Okay. Let's see if this is the one I'm thinking of here. Okay. All right. Yeah, this will be one we can watch here. All right. This will be Alec Baldwin actually doing the shooting here, and we'll see what happens. Ready? Here we go.
Now, wait a second. If I'm going to shoot right, you want to go on the other side of the camera? I don't want to shoot toward you. No!
I want to know who's doing all the grunting. That was really awkward.
You okay? Everyone okay? We're all good. Yeah, the camera. Let me see the camera. You all right? Yeah, all good. Let's stop. I'm getting nervous because do we want you? I'm going to follow you. Okay. So I want you to go along. I don't know why you're going up hills and all this other. You're going to break your neck. Yeah. So I want you to lead him on the nicest path. I would, but I'm no. I want you to go on the nicest path. Yeah. And I'm going to follow you.
Huh. Well, that was interesting. So let's get back to Jensen Ackles here. Thank you, Bella, for helping send that. Take the comment off the screen, please. Yeah, sorry. Yes, that's expensive. Don't drop that. Yes. Oh. The grays cannot be bought. Well, yeah, if you want to proudly be a gray, I guess. I don't know who would proudly be a gray. So here we go. All right, guys. This is going to be Dean Winchester, also known as Jensen Ackles. Talking to the police. Here we go.
Yeah. I guess all you guys gotta get that done.
Yeah. Did you just fly in this morning?
Literally landed about 45 minutes ago.
Nice.
Yeah.
Fly into Santa Fe? How do you like that runway?
I mean, I've flown some pretty sketchy runways at the time. That was fine. Actually, coming here for the film, I was flying from Telluride.
Yeah.
And the only way to get here was to drive to Montrose to Denver to Albuquerque, drive it. And I was like, hang on. I was like, I'm sure there's some old cowboy that's got a plane that can just fly me over. So I did. They found this little company, and I flew in this single prop literally next to the guy, like with the
Nice.
all the way over, and we landed. It was pretty sketchy coming in on that one, but that was fun. It was fun.
Yeah, I have flown in once into the Santa Fe airport, and I
Really?
like never again. Like
What's wrong with it? It's fine.
I know it wasn't fine, but I have a slight fear of flying.
Okay, my wife is like that too. Like she's not a big drinker, but if she's gonna fly, she's like, I need shots. Just get on the plane.
Well, yeah, I just feel like when I landed, I was like, this runway was like not level. It just seemed like a mess to me.
I remember I was flying into Atlanta one time, and it was for an event that they had chartered a plane for. So it was a jet. It was a small jet, and the wind shear was so crazy that we were literally coming in like sideways.
Oh, I've had that happen
And
too.
then at the last second, he was like, "Nope." When came around and tried it again. So the second time it was just like, "Oh shit."
Yeah.
All right, so the brace yourself.
That was pretty sketchy.
That's how on Friday it was so windy out here. Our like gas station pumps are kind of by the airport.
Yeah.
And that's how all the planes are coming in. They're coming in.
Just coming in sideways. Yeah.
Like,
So sketchy.
That's New Mexico weather.
Yeah. Well, you got the big crosswinds here too.
Yeah.
Big open plains, right?
especially now with
Not a lot of trees.
So let me just start with if you could spell your first name for me.
Jensen.
And last name.
Ackles, Ackles.
What's your date of birth?
1978. Which probably makes me the oldest in this room.
Hey, I'm born in March too. Also Pisces.
Pisces.
Yeah, heck yeah.
Fish, good people.
Yeah.
Gemini is not so much.
Oh, two sides to you, huh?
Yeah.
Yeah.
All right. So what is your role or your title as far as this production goes?
One of the lead actors.
Okay. Any other
No.
secondary type things that you do?
Nope.
Not a similar producer as well?
Nope. And I mean, I don't know, I'm sure you guys know this, but like the producer thing, often, I don't know as far as Alec goes, but you know, in this industry, they'll give kind of these ancillary titles to, you know, that's almost like a vanity thing,
Yeah.
you know, to an actor, just to like sweeten the deal, so they'll sign on to become like. I know that I wasn't offered a producer credit, but I was offered some producer points, which is kind of like a back end kind of thing. But it's like to sweeten the deal to get people to sign on to do it.
Kind of like a co-producer.
Yeah, like that. Like they would offer that kind of a thing in order to get a big actor to come on, but there's zero producing responsibility in that regard. So
Okay.
I did not have that title at all, but even if I did, I would have zero producing responsibilities. Yeah.
Okay. Let's just start with the day of the incident. Were you there?
Mhm.
Okay. Can you kind of go through the day?
It was a normal day. I probably I have to look at the day out of days, which is essentially the schedule for the actors and what days they're working, what days they're off. But I'd probably safe to say that I had worked more than the other actor up to that point. My storyline was kind of the heavy focus of the first part of the filming. Alec's story was they were about to get into his stuff and was going to be shooting with him primarily for the next 2 weeks, and I was almost done with the film. I think I had like 3 or 4 days left. So up to that point, I had been on set almost, you know, the full time that they were filming. I think I may have had a day or two off, and we had gotten into shootouts and stuff prior to this. So, you know, I handled a gun almost, every day. I mean, it was part of my costume. They would hand me a gun in the morning. I would check it. I would do my own checks. Just because I've been in the industry for 25 years. I've had a lot of onset and offset training for firearms. So my quick check is if they hand it to me, they show me all of the dummy rounds in the wheel, and then I just take it. And armorers hate this, but I just dry fire it into the ground 6 times. That's my own personal check. They're like, oh, don't do that. It's going to hurt the firing pin. I'm like,
That's what they're made to do.
so what?
Yeah.
I want to know that all of these are actual dummies. Not that I would ever think that a live round would be in a gun on a set. There's just not a world in which a live round should ever be on a set, period. Which is why this is so like crazy to me to comprehend how that's all I want to know. I could walk you through all the safety protocols, everything that I saw, everything that I went through. The only question I have, it's not like, oh, how did Dave miss this, or how did Hannah not get, it's how did a live round end up on a set, multiple rounds end up on a film set? It's just, there's not a world in which that should happen. But the thing is, the problem is if you look at a dummy round, it's made to look like a live round.
Mm-hmm.
You look at a blank, it's crimped, has no tip. It clearly looks like a blank, but that is a charge in it. So you're looking for a clay tip that is to look like a lead tip, or a crimped tip, which is a charged bullet, or not a bullet, sorry, a charged round. If I look into the gun and I see 6 clay tips, then I can just assume that they're all dummies, because that's all that should ever be on a set. If I see a crimp tip, then I'm like, whoa, we got a hot gun here. Like there's a blank in there. Get that out of there. Which is why I feel for Dave, because I feel like he could have looked at it, given it a visual inspection, and saw 6 clay tips and not known that one was a lead tip with a charge in it. But again, so there was clearly safety protocol that was skipped or missed, because it should have been caught. Every round that's loaded into a gun should be inspected and can be inspected. Anyway, kind of went off on a tangent there. Sorry. I don't know. Tell me if you get, like, if you need me to like move on or something.
No.
I haven't really talked about this since it happened.
Okay.
So I'm kind of going through this too. I mean, I tried to talk to my wife about it, but it kind of freaks her out.
Yeah.
And she gets pretty anxious about it, and she's like, I can't. She's like, if I'm watching the news, she's like, please turn that off. Please turn that off.
Right. So it's a traumatic situation.
It is for us that were there, and for people that are in proximity. So that particular day, morning went per usual. We were shooting up at the church. Actually, we shot some other stuff the morning of. We had a slight delay in the morning. In fact, so much so that we got loaded up into a van at base camp and we're headed to set. And they turned the van around. They were like, wait, we're not ready for you. Everybody go back to base camp, the cast. And I heard that on the radio. I was like, what the fuck? Like, that's weird. Like, maybe they had a camera, a lens issue, or the light wasn't right, but at least bring us up there. It's not going to be it's going to be a 10-minute fix, whatever it is. Little did I know that it was the camera crew that was walking, because they weren't, I mean, this is what I heard that morning from the producers. Cause I went in and I was like, yo, what's happening? And they were like, a camera is walking because we will put them up. I'm like, put them up where? What do you mean? They're like, well, they're set up in Albuquerque. They want to be in Santa Fe because it's a longer commute, it's less of a commute. They want a lesser commute. It's in the contract that they don't get that. They're still in the zone. And if we do it for them, then we have to do it for all of the departments. And we don't have that in the budget. It's a small budget movie. So they threatened to walk, and they walked. I was like, well, when did they threaten to walk? They were like, this morning. They waited until like one of our busiest days, and we have a big giant shootout. They knew we were just coming off a 2-day break. They could have said it. They could have done it like 2 days prior, given production 2 days to find replacements. Mm-hmm. But they didn't. They were smart. They're negotiating, and they showed up that morning with their equipment. They were like, so you gonna put us up? And production was like, no, we told you no. And they're like, okay, bye. And that's why they were like, send cast back to base camp. We don't have a camera crew right now. We got to figure some shit out. So we went back and we got it was a 2-hour late head start that day, which was, we moved pretty quick, especially for a low budget film like those tend to be high pace. So once BCAM, Reed, who was Halyna's guy from LA, he wasn't going to leave her, so he stayed, even though most people would have probably left in solitude or solidarity with the rest of their camera crew. But so we've got ACAM, BCAM. BCAM is usually a guy that can also double with Steadicam. So ACAM is more studio mode. Does this make sense to you guys? They left. BCAM stayed. The operator, the focus puller didn't. He left as well. So we lost like 6 out of the 8 camera people. Or maybe it was 7, I forget. But Reed stayed, who's an operator. So finally they wrangled some focus puller to come in that more like immediately. And we were able to continue the day with 1 camera. And so we started. First couple shots of me riding into town on a horse, hopping off, establishing shots, that kind of thing. And then we moved up to the church later in the morning. And the first few shots inside were facing me, so it was over Alec to me and my kind of deputy coming into the church, guns drawn, saying, you know, stand up slowly, drop your weapons, that kind of thing. And then he basically slowly takes his gun out, thinking that he's going to, you know, drop the weapon. And then he draws back on the hammer, jumps up, starts shooting at me. That's the scene. So we shot my coverage over him to me, both wide and both tight. And then we sort of turned around, broke for lunch. So we went to lunch, came back. The first camera shot back was kind of a close insert of Alec pulling the gun out. And so I was standing not immediately on set because they were just setting this particular shot up. It didn't necessarily include me, but I would have been coming in for off-camera dialogue.
Okay.
I was not on camera, but I would have been off camera for the, you know, telling him to put his guns down, that whole thing, which he probably didn't need me to do that, but that's just, you know, what we do. So I was standing just outside the church, right off the porch there when the gun went off. And again, they were just setting up a shot of him pulling out the gun and showing Halyna, you know, she was very kind of involved in every shot. You know, this is, I'm used to kind of directors being a little bit more of like, okay, I want to see this, I want to see this. But Joel was more of like, this is the scene. Halyna, how are we going to shoot it? And so she was really, for all intents and purposes, she was the meaning of director of photography. She was directing all of the camera shots, and she was very, very passionate and amazing at it. But she would get right in there. She would even like move me, like finding the light and stuff just right. So she was very, very hands-on. Some people don't do that. A lot of people don't do that. They'll just sit there, you know, chair it behind the monitor and just be like, you know, on the radio telling people to do things. But she was very hands-on. So she was standing right there next to Reed and looking at the monitor on the camera, asking Alec to show her what, you know, show me your action. So he was just showing her the action, and then it went off. I don't know if he was just drawing back on the hammer and his thumb slipped, and that was enough of a spring to get forward and hit that primer or what. But I'm sure he's told you. And so I heard the shot go off. There shouldn't have been any shot go off because it was a setup. There was no cameras rolling. There wasn't supposed to be around a blank to be shot in that particular camera sequence, and nobody yelled hot gun. So when it went off, it just sounded different. I mean, a real round sounds different than a blank, and I didn't immediately think that it was. I just was like, "What the fuck was that?" And so I spun into the church. I saw Joel down screaming. I saw Halyna seated, and I could see her back was to me, but I could see the blood pooling on her khaki jacket. And so I just started yelling medic. And then that was about it. then I stood back. I kicked myself for not running in there and doing something, but I don't know what I would have done.
No, I mean, you know, the medics are trained professionals and there was an on-set medic, so I mean.
There was, that's why I was screaming for him. And I know that as the reality started setting in at first I was like, oh, somebody, you know, a shot went off. But there's no way that would have caused that much damage. Like how are two people down and there's that much blood with a movie round? So I was just instantly like what? And then as it started to settle, I was like, that was a real round. I know that sound. That's a real round.
Is that what it sounded? Because you made a comment about how it sounded different to you.
Yeah. I mean, it sounded like a real round. It sounded like a 45. I have a 45. I know what they sound like.
Okay. Did you see what happened with the gun after it was shot?
No, when I stepped in there, I saw Alex seated in the pew, holding just like, you know, just in shock. Because it's also like a flashbang, right? I mean, that thing goes off. Everybody in there was deafened and they were disoriented. I mean, when Mamie came out, who's our script supervisor, she was stumbling out and she ended up being the one that called 911. There was another wardrobe person was in there. She came out, she was stumbling. She like hit her knees. Reed was still in there. You know, there was a few people that kind of staggered out, but it was disorienting. So I didn't go in because the medics were yelling everybody out, and Joel, our director, was actually yelling, you know, get the fuck out, get out of here. So people were quickly exiting that didn't need to be there. So I didn't go back in there because I knew it was, you know, I couldn't do anything at that point. So I just was standing back, and then I started helping move equipment to make way for responders.
Okay. Out of the church? Or
out of the way of the church. There was so much equipment around the front of the church, and we knew that everybody was going to need access. So we started moving barricades, we started moving camera equipment, we started moving monitors, and I just, you know, threw my jacket, my hat off, and started helping Grips and Electrics and everybody just start moving shit.
okay. I want to back up to the beginning of the day.
Okay.
Were you guys working with any of the firearms on the first half of the day?
I mean, like I said, we get handed our gun belt and our firearm in the morning, and it essentially stays on our person because it's part of our costume for the remainder of the day. If we ever are actually shooting it, then it gets taken. They load it with blanks. You know, we usually are using half loads, and then it's well announced that there's a live, you know, a hot gun, and you know how many rounds are hot at what load, what capacity, so that everybody's aware. But again, you know, there's the few of us that were in the movie. We get handed essentially a prop, you know, and it has dummies because I always personally check, and I was telling some of the other guys, I'm like, always check yourself. That's not why we're hired, and I was telling you this.
Yeah.
We're actors, and if it was left up to the actors to be the final like line of safety and defense, then I wouldn't trust 99.9% people I work with, percent of the people I work with. But again, just from using a lot of firearms on set and also having real training, I just always do my own personal checks, just because it's a smart thing to do.
Yeah, definitely.
Yeah.
What gun did you have in the morning?
I had it's 45. It's not the long Colt, but it's the one that has U.S. Marshal in the handle. I believe there are only two on set, but I think I don't know if it was, but I was told that was one of the ones you guys.
Okay.
was mine.
And did you check that in the morning?
I did. I always do that.
Did it have anything in it?
Dummies.
Okay. And did you take the dummies out or just did a visual check?
I did a visual check and did a click into the ground.
Okay.
And I also appreciate you walking us through the, what takes place during a film, because I mean, we're getting to know what actually takes place on film. This is a major case, and some people that we've spoken to have kind of walked us through what the procedure is. So I appreciate you letting us know what exactly takes place. We're starting to learn a lot more about what goes on in there.
Yeah. Any questions, and then I can, that I can shed light on it. I can do.
Well, so who handed you the gun in the morning?
That particular morning, I believe Sarah Proft handed me my gun belt, and Hannah handed me my gun. She was not 100% of the time, but most of the time, the person that was handling the firearms. Sarah would help her and had a license to help her. This is something that I learned later. I just was, it's like, because I asked her that day, I was like, did you handle the gun? She was like, no. I was like, are you even supposed to handle the gun? She was like, yes, I'm licensed to do it. So I would help Hannah out. But from my recollection, Hannah was handling the guns 90% of the time. There were times when I would at lunch, we would always take our gun belts off and hand our guns back to Props or to Hannah. So I would just take my whole belt off and hand it to either Hannah or Sarah, whoever was close by. And then they would take it and lock it up or do whatever they did with it at lunch. And then I would get it back after lunch.
During your time here during this whole production, has David ever handed you a gun?
No.
Or anybody else besides Hannah?
No. Well, Sarah, I think there were probably a couple of times where Sarah handed me the gun. Maybe I want to say that every morning Hannah would show me the rounds. She would pull the wheel lock back, slide the wheel, then show me each round, and then hand it to me. Then I would click into the ground, put it in my holster, and there it stayed until lunch.
Okay. And then did they outfit you after lunch the day of the incident?
Yes.
Okay.
And I can't remember if I clicked into the ground that day. So I know I did that morning, but I've been racking my brain trying to figure out if I did my safety check after lunch, and I can't remember. And maybe that's just because it was a pretty crazy event that happened after lunch, and I'm just trying to think of. It's like flashes. Like I know where I was standing, I know what I saw, but for some reason I'm like, gosh, because I'd never overly thought about it. I'm like, gosh, did I check my gun when I came back from lunch? Like I normally do. I always do, but I can't remember doing it.
Who handed you the gun after lunch?
I don't know. I can't say with certainty.
Okay. And it's okay if you don't know, because we don't want to say or
Right.
have something in mind that didn't happen. So if you
That's what I mean. Yeah, I mean,
recall
I could certainly, I could give a percentage guess, but it was, I don't know for certain that it was either Hannah or Sarah. It was one of those two.
Okay. And what about your belt?
It would have been the same person.
Okay. What did you do with it after the incident?
I took it off and handed it to Sarah.
Okay.
And she went and immediately, I saw her take it immediately to the cart.
Can you describe the cart?
It's just a rolling double-decker cart that has, a variety of props on it.
Do you remember the color?
No, blue maybe. Blue or black.
Did you see her set it down?
After the incident?
Yeah.
No, I handed it to her and then I went to work moving equipment.
Okay.
I said, here, take this. And then she was frazzled, and I saw Hannah on her knees, like head in hand, like somebody was consoling her. And I was like, take this, put her in a cart. And then I just started moving shit.
Okay. Did you see what happened with the gun after it was fired?
Alec's gun?
Yeah.
No.
Okay.
Dave immediately, I heard Dave yelling, where's the gun? Where's the gun? Because he wanted to inspect it. And Hannah and Dave were handling it. I did see that.
Okay. Can you recall what they did?
They were still in the church, and I just remember Dave yelling, where's the gun? Let me see that. Let me see that. And then I don't remember anything after that. I don't remember what happened after that with that particular situation.
Okay. Going back to Hannah, so you've been working with her since the beginning of the set. Can you, or is there any other time that you witnessed that she was being unsafe and not following protocol? Is there anything that stuck out to you?
She was, in my experience, she was saying the things that or an armorer would and should say. She was doing safety checks. There's levels, I think, to the intensity of armorers in our industry. I would say that the majority that I've worked with are like drill instructors and can scare the piss out of actors when they hand them any kind of weapon, whether it's supposed to be fired or not. I used to not like that. Now I'm thinking that I think that's a really good thing. So yeah, I would say that there wasn't that kind of intense fear that she was giving off. Again, like most of the ones that I work with are like very, they're either military, ex-military, ex-law enforcement. They've got a long history of gun handling and gun safety and gun training. And they do not care that you're a Hollywood actor or a name or anything like that. They are there to make sure that you know that this is a firearm that can hurt people, and you don't point it at anybody unless you are planning to shoot them. Aim it at a target. There's safety guidelines, and I think that's probably why I do things that I do with my prop. It's just because I've been dealing with armorers who are very strict and very experienced and very safe. I know that I was on a show for 15 years, and a lot of times I would have my gun on my person, but I wasn't actually firing off blanks, but I would have it, and I would need to rack it or do something in the scene. Well, the armorer, we don't necessarily need an armorer for that. Props on set props person is licensed to handle firearms, but they're not licensed to handle ammunition.
Okay.
That's when armorer is the special person. They are really responsible for the ammo. The gun is a prop. The ammunition inside the gun needs a specialist.
Okay.
And so my props person, on this particular project would literally come up to me and shake every bullet in front of my face and then load it. Shake, because there's BBs inside, empty dummy rounds. You shake it like that, you hear the little rattle, you know that there's no gunpowder in there.
Mm-hmm. And that was on this set or a previous one?
That was on a previous one.
Okay.
That never happened on this set. That being said, I don't know what is mandatory protocol for armorers. I just know what I've experienced, and I have experienced more safety measures on other sets than I experienced on this particular set. But again, I didn't feel unsafe.
Okay. And that was more, I mean, is there anything that you could point out that she did that was really like,
That was like being loose or cavalier? Not necessarily. I just know, like, me personally, I knew she was inexperienced. I could just tell, you know. I knew that she clearly learned the lingo and knew the verbiage and understood gun safety from somebody teaching her that. But she's also the youngest armorer I've ever even heard of. So I knew that there was lack of experience there, but how are you going to get experience if people don't take a chance on you?
right, exactly.
So I was cool with it. I was like, good for you. I was like, good for you, kid. Like, getting in there and getting jobs and in a predominantly male-dominated field. And there she is, like, so I was kind of like stoked for her.
Were you present during they call it the show and tell day of all the weapons? Can you tell me a little bit about that?
It was an afternoon. It was out on the set, out on the ranch. There was a big table set up with an array of weapons, handguns, long guns. And she was there there were boxes of blanks. And it was kind of a pick out your gun day. So, it was, because again, this was part of the character, part of the costume. It was part of that building character aspect. It was the same thing as going out and picking out our horse. We spent a day out. In fact, I did both those things in one day.
Okay.
I first went to the armor show and tell, picked out my gun, and then I went over to the horse ranch and picked out my horse.
Okay.
But in that show and tell, she asked me, do you have any, what level is your experience? And in kind of not a joking manner, but just kind of wanted to see where she was on the level. I said, let's just assume not much. And she said, okay, this is how you load it. This is how we check it. This is how, the gun works. This is the trigger. This is the handle. I'm like, okay, just kind of playing dumb. And she said all the right things. But it was more of just kind of an explanation. I don't know, there were a lot of safety measures that were explained to me, but it was just more of, this is what a gun is. This is how it works. And she goes, if this is the one you like, I'll load it up with some rounds and you can just fire it off into the hill there. I said, okay, great. These are dummies. These are blanks. We're not live rounds at all. So I think we were using half loads.
Okay.
And so I put my gun belt on and I took the pistol, and she took it. She walked it out to this, to the firing line, had me stand looking, facing downrange. And then she loaded in a full barrel, a full wheel, 6 shots, half loads. So I took it, put it in my holster, and then kind of a dick thing for me to do, but I did like a quick draw and just spun it and put it back in.
And the whole cowboy thing?
Full on. Even did the spin, spun the gun.
Like, what the
Well, she just goes, okay, asshole. Like, you could have told me that you knew how to handle a gun. And so we laughed at that. And then she basically was like, you're good. Get out of here. Give me your gun.
So when
that
you
was
guys went down to do the practice shots, was it just solo? Did you guys have any other people with you?
There was a whole group of people. There was a couple of producers there. There was props was there. Sarah and I can't remember the other, her assistant. I can't remember her name. She was there. Hannah was there.
But when you went down to shoot,
When I went to fire downrange, I was the only person. Everybody else was behind me at the tables.
okay,
So we stepped out around. I stepped around the table, walked out probably a good 10 paces, and then aimed away from everybody. They were all like 6.
okay. Who was watching the guns while she would take?
While she was with me, props.
Okay. And what about the ammo?
That would have been all sitting right there in front of them on the table. Nobody was touching anything.
Okay.
Do you recall on the table what the rounds, the blanks were in, and what color of box?
No, I want to say I saw a white tray with just, like a 50 round kind of tray of rounds. I know that she had a variety because she did say that she was like, you want to start with quarter loads or you want to do half loads? And I think I said, let's go full loads. And she's like, no, we don't have full loads. Those are too expensive. And I was like, ugh, low budget films. Because full loads are just funner. They're more fun. They just have a bigger blast, but they're also more concussive.
Yeah.
And did you watch anybody else go and practice with Hannah?
I kind of came in, there were a couple of actors there. Picking out their stuff as well. I don't think I saw anybody. I saw Travis shot one. Travis Femmel was there, and I think he popped off one round and was like, all right, I'm good. But he's also somebody who's got a lot of training.
Okay.
I clearly knew he was somebody who
Was comfortable.
around weapons.
Okay.
Some of the other guys I think weren't, hadn't had a lot of experience. Some of the actors, guns can be scary for people who aren't comfortable. Same thing with like a horse. I was seeing the same thing with the horses that I was with the weapons. Some people are like, oh my gosh, it knows that I'm scared. Why is it turning?
Of course they do.
And I was like, because it knows you're scared. Yeah, it can feel the fear through your legs. I could tell the way that people were handling some of their guns too, that they just were, it was awkward.
Okay.
But again, I never felt the need to like speak up and be like,
You're not following.
put your fucking gun down.
Yeah.
Don't point it at me.
Were you there when Alec was doing
I did not see him.
practice? Okay.
I know that the gun was there because somebody went to pick that and they were like, no, that one's Alex.
Okay.
We're saving that one for Alec, I think.
Okay.
Was what they said.
What about any target shooting?
Nope.
None?
Mm-mm. That was the only time that I ever fired a gun when the cameras weren't rolling for this project. Was that day.
And you didn't see anybody like take guns out during lunch or after production hours? Anything of the sort?
No. And I know that's being talked about because I've even got my wife is like, show him the text. I'll show you kind of what I received. Where is it? Hang on. Where is it? I don't have it. Yeah, but I did hear that that someone may have taken the guns and done some target shooting or something, and that just seemed crazy to me. Like nobody nobody messes with props
Right.
during production, unless it's scheduled.
Yeah.
Unless the producers are like, we need training for an actor. We need to take him out or take her out and teach her or him how to properly use and properly shoot. But this was a low budget thing that wasn't happening. We didn't really get the opportunity to do that, nor did, in my opinion, I didn't need it. Could there have been some actors that would have benefited from that? Maybe, but they knew what they were getting into. This is a low budget film. It's like guerrilla shooting. You got to get on that horse and hope it goes the way you want it.
It's kind of scary when it comes to horses, but.
And guns.
Yeah.
Yeah. I can't find that text.
Keep looking for it.
I'm just curious, and this is a little off topic.
Yeah.
I know the day of the incident, we went out there.
Yeah.
Were you at base camp when we?
Real quick, guys, I didn't see this earlier. Lucky Robot says for $5. Sub playa. Thanks. How you doing? The Bushmaster says, Sean, why do these people talk to the popo without a lawyer, even for stuff like this? I'm sure Jensen talked to his attorney before he went out there. And I think it's clearly, by that point, it had been clearly established he had done nothing wrong. I mean, if he had already talked to his attorney, he had already talked to the prosecutors, he is not being charged. I think it's, at some point you can tell your client, go ahead and talk. So I don't think that he necessarily did talk to an attorney. He just had an attorney with him. I mean, so this isn't necessarily problematic here, especially, you're clearly out of the woods. But this is a very rare situation where 100% you have no liability. So it's a bit of this is why you don't do it until it's been cleared out for you. That's why the attorney helps you figure it out. He's an actor. They're not smart. Well, there's that too. Barange says, why couldn't Baldwin get funding? Because the movie sounds like shit. I mean, it doesn't sound that good. I mean, what is this going to be like? Is this going to be better than Unforgiven? It's because it's a shitty indie movie. Why would Baldwin be in low budget shit? Because they stroked his ego and Baldwin's not getting a lot of movie jobs lately. So probably for that. It's a pretty crappy movie, yeah. I knew Jackson was Imholt, taken to the detective without fear of charges. Okay, guys. And ladies, are you done? Are you done? Can we mop up the floor now? Bella's like, all right. The sim session's over. All right. Mop it up, chat. Mop it up.
Arrived, or
No,
we
I
because
was-
we didn't see you there.
I was just standing back from set.
Okay.
I was still there. I know they told everybody to go to base camp, but
Mhm.
I don't know. It's not my MO to look.
We're still trying to gather everybody that was close to the incident to interview. And
Yeah, I was, I had moved away from the church, but was still in proximity, still
okay.
watching. In fact, I think I even took a picture just as things were unfolding. I don't know why I did this, but I did. But this was kind of where I was, in proximity. Like you can see the
Oh, okay, yeah, you can see the units and the
coming in, and so I'd probably moved about 100 yards away, and was just
Zoom in a little bit.
sure.
So all this equipment was the equipment you're moving.
Mhm.
Okay.
Yeah, and moving it back towards that,
The truck.
that box structure.
Okay.
So yeah, so as you guys were arriving, I was just kind of like moving back, and I walked back to the shuttle and was like gonna get in, and then I was like, no, I'm just gonna be pacing at base camp, wanting to see how they get Joel and Halyna out, because at that point they were still conscious and they were still like, I didn't know, never thought that this would have been a fatal wound. I was like, okay, they got here quick. They're treating her. They're treating him on site. They're going to get them out. But I was standing by waiting for updates on what was happening inside because I wanted to know what was happening with my director and my DP, who I've been
no, definitely.
working intimately close with for the past 3.5 weeks every day.
What time did the day start that day?
Every day started around sunrise and it ended at sunset. That was pretty much.
Do you know about what time you started?
I could go back and look, but I would have gotten there. I would have gotten there probably at 6:15, 6:30, somewhere in there, ready for 7:30.
Okay. And what time do you break for lunch?
6 hours after call. I think it was about, would have been 8 o'clock call maybe. So, yeah, to 1:30 maybe. It's usually 6 hours after call, whatever call was that day. And I forget what it was.
Okay.
I usually come in early, so that I'm ready at call. They bring the actors in to get them processed, which is hair, makeup, wardrobe.
Okay.
But yeah, lunch is 6 hours after call, and then we would wrap usually at sunset.
Okay. Do you know what time you came back from lunch?
Not exactly. I do remember it being, well, I'll show you right now. So this happened, that was at 2 o'clock. Yeah, so we broke for lunch probably around 1, just after 1 o'clock. And it was, I believe, like a half-hour lunch, and then we came back.
Okay.
I mean, I'm kind of guesstimating.
How?
An AD would be able to know, to tell you exactly, because they log all that stuff. Production reports have exact times on all that stuff.
How quickly after lunch did the incident take place?
It was the first shot, I keep saying shot. It's like, I gotta come up with a better term for camera shot. It was the first setup after lunch, the first camera setup after lunch. So they turned around, they were now facing the other end of the church, not the door, opposite of the door. And they were starting with a tight insert of Alec pulling the gun out. And then I walk in, I have my few words. I think they were going to pull back to see Alec. He just kind of pulls the gun out, does this, pulls back the hammer, and then jumps up and starts shooting at me. So it was the first setup. So they were setting lights, they were getting cameras, they were picking out lenses, all that kind of stuff. Halyna was right there.
Maddie's
Joel was
over.
right there. Alec was right there showing the action. This is what we do. And that's a very, very normal procedure when you're setting up a camera shot is the actor goes through the action, what they're going to do. Then the DP says, okay, then I need a light over here. I need a bounce right here. I need a
Hey, why are we
camera. I want
DPing on the
it to be right
set?
here. Let's put a 50 mil lens on. The director's like, okay. And then we go into a camera rehearsal, which is not rolling, just let's see all the action with the camera. If there's a camera move.
The funny thing
the
is,
action with the
Chinny,
camera.
and you use that term best boy. That's actually a position on a movie set. So it's funny you use that. Being the bestest boy ever. The best boy is a grip position.
Remove, boom. Okay, great. Let's roll sound. Let's do a take. So this was the preliminary setting up the shot.
Okay.
We weren't even into rehearsal yet.
Did you see who handed Alec the gun after lunch?
No.
What about putting his belt on, anything of the sort like that?
No.
Okay.
Because again, I was just outside the set. I was in there for a little bit, like watching him kind of like do some setup stuff.
Mm-hmm.
And then I was like, oh, okay, they're just setting up. So I just stepped outside to get some, air because it got pretty dusty. It gets pretty dusty in there.
Yeah.
During rehearsal, when Alec was sitting on the pew after lunch, was the gun supposed to be loaded with dummies, or was it no rounds in the chamber kind of thing?
It should have been loaded with dummies.
Okay.
Yeah, he was not, we weren't getting into the firefight at that, for that particular setup.
Mm-hmm.
I would imagine the next setup would have been we would have loaded our guns with blanks, and we would have gotten into to firing off our pistols. So this was supposed to be, it should have been full of dummies, because it was going to be a tight shot of the gun with those guns, because they're so old and rudimentary. You can see the brass. So you can see the brass, you see the tips, you see the bullets. So they would have been loaded with dummies to look like real.
To make the appearance of that it's loaded.
To make it look like it's loaded with real bullets.
Did you ever see the dummies on this set? Did you see what they look like?
I certainly saw the ones in my gun every morning.
Okay.
Because my gun was loaded with dummies every morning. But I never, I can't remember if I ever walked over them. I mean, yeah, I walked over to the camera, or I'm sorry, not camera card, the props card, to either receive my belt and gun, or to hand it off at the end of the day or at lunch. And I remember seeing ammunition boxes there on the card. But I wouldn't be able to tell you more than that.
Well, you had mentioned earlier that they had clay tips. Did the ones that you saw have clay tips?
I would have no reason to think otherwise.
Okay.
Without giving them in like a really intense inspection. I wouldn't. I would have looked at the tray of bullets. The tray of dummy rounds, and assumed that they were all dummy rounds, and you could have very easily mixed in a half a dozen live rounds in there, and I wouldn't have known the difference from a visual inspection. I would have had to take them out, either shake them or inspect the what they call the brass ring on the back.
The primer?
Not the primer. But yes, it was the primer. All dummies have punch primer.
All the punch primers.
Yeah. So yeah, which I've done before, but I hadn't really done on this project, nor I felt the need to do it.
If it's a clay tip, what color is it?
It's made to look exactly like a live round, so it would be that
So
gray.
it looks like iron. You had said that the guns were loaded every morning. Did you ever see who loaded them?
I only ever witnessed Hannah loading it.
Okay. Did you see her load them that morning?
I should remember. And I wouldn't be able to tell you what mornings I did and what mornings I didn't. I just know that if I was happening to walk by the props guard and seeing her at work, I wouldn't have really taken notice. It's just everybody's working, everybody's doing their job. People are setting up lights, people are moving boxes, people are, setting up their cameras. She's loading up her weapons. Like that was her job. So it wouldn't have stood out to me.
Okay. How many days prior to incident day did you guys do live fire? And by live, I mean the blanks.
Movie fire.
Defendant Alec Baldwin's motion to dismiss the indictment with prejudice based on the state's destruction of evidence. I'm not clear when we recessed it. I got the impression that.
All right, chat. We're moving on to part two.
Motion to just suppress because they were sort of talking about the state going first. What are we doing? How are we proceeding?
Yes, that was my understanding. The state would call these witnesses from the emails and the communications before the break.
Okay.
And that's not a problem, Your Honor. We're prepared to call them.
Okay. All right.
All right. So would you like us to proceed, Your Honor?
Yes, please.
All right.
And I assume
Remember,
for the
guys-
purpose of this, where I'm not going to have any objections to the exhibits that are part of the court record, and you don't have to lay the foundation or anything.
Remember, guys, this is about the revolver and the parts getting destroyed in the testing. And also, they're stipulating we're going to skip foundation. Let's just get to the exhibits.
Like that, they're all going to just be subsumed within the court record. I assume that's fine with all sides.
The state doesn't have any objection to that, Your Honor.
Okay. Thank you.
So the state will call Alexander Hancock.
I'm present.
She's got her duck
Will you
lip.
raise your right hand? Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. Please speak up.
May I proceed, Your Honor? Thank you. Good afternoon, Corporal Hancock. Would you please introduce yourself to the court?
Yeah, my name is Alexandria Hancock. I am a corporal with the Santa Fe County Sheriff's Office.
And how long have you been with the Santa Fe County Sheriff's Office?
A little over 6.5 years now.
And currently, what are your duties?
I am currently a corporal
Oh my God, she's talking through a fucking can in her bathtub.
assigned to the Graveyard Division Patrol.
And on October 21st, 2021, what were your duties with the Sheriff's Department?
On October 21st, 2021, I was a detective. I was assigned to the Violent Crimes Division in our criminal investigations.
Corporal, would you mind, I don't know if everybody else is having the same problems. I'm having a little bit of a problem hearing you. I'm not sure if you can adjust your volume or your mic.
You're somewhat muffled.
I can try to do it on a phone instead. I'm on my laptop now, so I can try to switch a device.
If you could just speak up and maybe turn the volume up, that would.
I don't have a
hopefully-
way to turn it up. I'm on a laptop.
Why is it's so muddled? Move it. Yeah.
Would you like her to change, Your Honor, or just proceed
Yes,
with this?
change it.
If everybody can hear. All right.
All right. So on October 21st, 2021, were you assigned to be the case detective involving the shooting of Halyna Hutchins?
I was not originally assigned as the primary detective, but eventually I did take it over, yes.
Was that shortly after the shooting on October 21st?
About a couple weeks after.
Tell me where this incident occurred.
It occurred at the Bonanza Creek Ranch in Santa Fe County.
And were you one of the responding officers to the scene on October 21st?
Yeah, responding detective.
And when law enforcement officers arrived on scene, was the firearm that was used to shoot Ms. Hutchins seized as evidence?
Yes, it was.
I'm going to show you what's been marked and admitted by stipulation as State's Exhibit 1.
I'm sorry. Just give me a second. I need to present that. I apologize. That came up faster than I thought it would.
What came up just faster than occurred? Her audio is worse than Joe's. Yeah.
Bear with me here. I'm just having a technical difficulty. I thought I ironed all these out last night. Stand by.
Dead
Well,
air,
let me
dead
proceed while
air.
you pull that exhibit up. Corporal Hancock, when you and other detectives arrived on scene, who did you understand was involved in this incident?
The, I guess, main parties that were involved, I was told that the shooter or the handler of the firearm was Alec Baldwin, and then the armorer for rest was Halyna Hutchins.
And do you know, or what is your understanding about where the firearm was seized by law enforcement?
It was, my understanding was that it was handed to Lieutenant Benavides from Hannah.
And what did Lieutenant Benavides do with the firearm once he took it into his custody?
He secured it in his patrol unit.
And I'm ready whenever you are.
Okay, go ahead. I'm going to show you what's been marked and previously admitted by stipulation as State's Exhibit 1.
Oh, wait, now it managed to go away.
God damn it, Carrie.
I had it right there.
This is so bad.
For what it's worth, this is obviously not a major point of contention from the defense, the photograph. So, or Linda, if you wanted to proceed, we're not going
Hey,
to
Fiery Red. Yeah, she got stung on the lip.
make an
by a
issue of
bee.
this photograph.
Thank you, counsel.
There
When
we
you have
go.
a-
Hang on, it's coming.
Any name tags? Hold on,
Do you
I'll move this
recognize
out of the way here.
Exhibit
Hold on.
1?
There's name
Yes,
tags
I
in the
do.
bottom
And what is it?
left corner. Hold on.
That is the firearm that Baldwin had used on Rust and the same one that was handed to Lieutenant Benavides.
If we can go back to Exhibit 1.
Chat, here's the name tag.
Does
for who's
Exhibit 1
talking.
depict the condition that that revolver was in when law enforcement seized it?
Yes.
And when law enforcement seized it, was there anything about the condition of this firearm that led you or other law enforcement officers to believe that it may be malfunctioning?
No.
Was there anything that was apparent to you upon looking and examining this firearm when law enforcement seized it on October 21st that it was modified or broken in any way?
No.
And you testified earlier that you understood that the person who was handling and utilizing this firearm when Ms. Hutchins was shot was Mr. Baldwin?
Yes, that's correct.
And as part of your investigation, Corporal Hancock, did you interview a number of witnesses?
Yes, I did.
Did any of these witnesses indicate to you or other law enforcement officers that this firearm had been malfunctioning either on October 21st or on the days leading up to October 21st?
No.
Did you also review statements provided by an individual by the name of Alessandro Pieta?
Yes.
And who is Mr. Pieta?
He is the manufacturer of this firearm.
And did Mr. Pieta provide information about his particular work as it relates to this firearm?
Yes.
What did he say?
That he, essentially that this gun is not modified and it is shipped as they produce it to the seller, or to the buyer, I'm sorry.
Did he indicate to the defense and the prosecution whether or not he was involved in the actual manufacture of this particular gun?
I don't recall.
Have you reviewed the transcript of the pretrial interview that was provided by Mr. Pieta?
Yes,
And do you have that in front of you?
I do.
And would reviewing that transcript refresh your memory with regard to what he said about his involvement in the manufacture of this firearm?
Yes.
If you could just take a minute and look at this, the transcript that was provided to you. And on page 41, if you can review that and let us know when your memories refreshes to what he said about the manufacturer.
Okay, I'm refreshed.
Okay. What did Mr. Pieta tell the parties about his involvement in the manufacture of this particular firearm?
He had stated that he was the one that configured that firearm.
Did he also indicate whether or not when this firearm left Pieta Firearms, it was working perfectly fine and as intended?
Yes.
You can take down Exhibit 1, Ms. Morrissey, thank you. Did you also review statements, or let me ask you about other statements Mr. Pieta made. Did he indicate who the firearm was sold to by Pieta Firearms?
He had advised that it was sold to Seth Kenny, but that they used their, I guess, distributor or company EMS.
And did you obtain information about whether or not EMF modified this firearm in any way when they received it?
No, it was not modified.
Now, you just testified that the firearm was eventually sold to Seth Kenny. Did you, during the course of your investigation and review of the different witness interviews, learn who sold the firearm to Seth Kenny?
Yes,
And who was that?
his name was Justin Neal.
And who does Mr. Neal work for?
He, I believe he's a contractor, but he, EMF is his client, and he essentially oversees all the sales of EMF.
So to your knowledge and based on your investigation, can you describe for the court up to this point the origins of this firearm up until it goes to Mr. Kenny?
Yes. So my understanding is that it went from Pieta in Italy to EMF, which I believe is located in California. I believe it's Los Angeles. And from there came to Seth Kenny.
Did you also review information or statements provided by Seth Kenny about what he did with this firearm once he acquired it from EMF?
Yes.
And did he indicate, meaning Mr. Kenny, whether or not he had modified the firearm in any way?
Not any modifications, just the
Sorry, guys, I wasn't even paying attention to that. My bad.
putting back in the firing pin.
I'm going to show you what's been marked as State's Exhibit number 6. And for the record, it's been admitted by stipulation as well.
Why did she have a panel on the ceiling for a cat?
Do you recognize that email?
Yes, I do.
And who is that from?
That is from Seth Kenny.
And does he discuss what he did with this firearm once he obtained it from EMF?
Yes, he does.
And what did
Portal to
he
fourth
state
dimension.
about what he did with the firearm?
Let's see. Sorry, give me just a second. So the removal, reinstallation of the original firing pin and retaining pin is not, in my opinion, a modification. Plus, the FBI tested and found it was functioning properly.
So Corporal Hancock, did you also interview Mr. Kenny about whether or not he had modified this gun?
Yes, I did.
And what did he tell you?
He stated that he did not modify it in any way.
What, based on your investigation, what did Mr. Kenny do with this firearm once he acquired it?
After he acquired this firearm, he had another individual working on the set of rest who was in Sarah Zachary is her name, had her go to PDQ Arm and Prop in Albuquerque and pick up this firearm and essentially retain possession of the firearm until it went to the set of rest.
And to your knowledge, approximately when did this occur?
I believe it was just a couple days before they started filming.
Was that in 2021?
Yes, it was.
Okay. And do you know how long Miss Zachary had this firearm in her possession?
I believe it was overnight until they could secure it on the set.
And then who, based on your investigation, who did Miss Zachary then transfer the firearm to?
To Hannah Gutierrez.
Did you also interview the defendant in this case, Alexander Baldwin, after the shooting on October 21st, 2021?
Yes, I did.
And at any point, did Mr. Baldwin tell you that this revolver had been malfunctioning or not working properly?
No, he didn't say anything like that.
Did you also review a statement that Mr. Baldwin provided to OSHA investigators about the revolver and whether or not it was working properly on October 21st, 2021?
Yes, I have.
And what did he say with regard to this revolver?
He had explained to OSHA that there was nothing wrong with the gun. He didn't have any issues with the gun while he was there, and that the only problem with the gun that day was that it was loaded with a live bullet.
Did you also review transcripts of a statement provided by an eyewitness to the shooting? The individual's name is Zach Sneesby.
Yes.
And during his pretrial interview, what did Mr. Sneesby say about his observation of what Mr. Baldwin did with the gun right before Halyna Hutchins was shot?
He said that he saw him unholster the weapon with his finger on the trigger. He actually said that every time he was rehearsing that his finger was on the trigger of that firearm.
I think we lost Ms. Johnson.
Uh-oh. Oh, no.
Ms. Johnson, can you log in again, please?
I'm going to send her a text message.
They got her, chat.
She says she's on it right now. She's trying to come back in.
Uh-oh, chat, they got her. Yeah, the ceiling cat got her, came out of the roof and just... They can't find the Johnson. Now, yes, they definitely have to dismiss charges. The prosecutor's gone, Judge. Dismissed. Yep.
I'm going to mute myself and have let me have a quick conversation with her. She's having some technical problem.
She getting flat. She got the Baldo in her house. Yeah. It's like, open the door. Land shark. Land Baldo. Boop. Right in her face. Like, I can't get it off. Oh, no. Oh, no. Is this live? Yes, this is live. This is live television, chat. Oh, hold on. We'll scoop
I think that's resolved.
We'll scoop the last couple of seconds.
Is
It's a
Ms. Johnson
contempt
back
to-
on?
It's a contempt to do a Denny's
There
joke.
she is. Okay,
Yes.
great.
June 13, how you doing, man?
Okay, continue, please.
Your freezer just died. Ooh, that's a
Technology, I
shitty weekend
apologize.
for that, man.
Excuse me,
Full of
Corporal
red
Hancock,
grenade.
we were talking about the statements provided by Mr. Sneesby and his observation. Did he also indicate whether or not he saw Mr. Baldwin pull the trigger?
Yes, he did say that he observed Mr. Baldwin unholster the weapon, point it, and then pull the trigger.
As part of your investigation, did you request that the FBI conduct any testing or analysis of this firearm?
Yes.
And why was that?
We wanted to ensure that this it was the gun that was used in the shooting. So essentially confirmed that, and yeah.
And was there someone from the FBI office in the Santa Fe area that you were dealing with?
Yes.
And who was that?
His name was Special Agent Jose Cortez.
And what was his role?
He acted as a liaison between the Santa Fe County Sheriff's Office and then the FBI lab in Quantico with our evidence testing.
What testing did you and your department initially request that the FBI conduct?
For the firearm, it was initially, I believe, DNA testing.
Was there anything else besides DNA testing with regard to the firearm initially?
And functionality of the firearm.
I'm going to show you what's been marked and admitted by stipulation as State's Exhibit 2. While Ms. Morrissey's pulling up that exhibit, let me ask you, who sent the request to the FBI for assistance?
I believe it was the sheriff that ended up drafting the request for assistance on behalf of the Santa Fe County Sheriff's Office.
Did the sheriff or anyone at the Sheriff's Department initially request that the FBI conduct a test called the accidental discharge test?
No, that was not in our initial request.
Was an initial request made for any destructive testing to be conducted on this firearm?
No.
We have State's Exhibit number 2 up. Do you recognize that?
Yes, I do.
And what is that?
That is the letter that was drafted from the sheriff requesting assistance from the FBI for evidence testing.
Anywhere in this letter, does the sheriff ask for destructive testing to be done on this firearm?
No, he does not.
In fact, at the time that you and the Sheriff's Department requested assistance from the FBI to conduct functionality testing and DNA testing on this firearm, were you aware that they could do an accidental discharge test?
No, I wasn't aware of that test initially.
When did you become aware of the test?
I'm not sure the exact date that we had become aware of it, but it was later on in the investigation.
And who brought that possibility or that option to your attention?
It came from the FBI.
And what were you told about this accidental discharge test?
We were made aware that if we proceeded with this test, that it could result in damage to the firearm.
And did you and your department approve this test?
Yes.
And did you initially, but did you request that other testing be done before the final accidental discharge test?
Yes, we had discussed that with the FBI, that all of the other testing would be completed before we moved on to the accidental discharge.
Did you request that the FBI photograph and examine and preserve the condition that the gun was in before they did the accidental discharge test?
I don't think that's something that we specifically requested. I think that, however, they process is how they probably have their own policy and procedures on that.
What was your understanding with regard to what the FBI was going to do before they did the accidental discharge test, as it relates to documenting the condition of the gun before they got to that last test?
So I believe that was part of the functionality test, was that we wanted to ensure that the gun was operating properly prior to them doing the accidental discharge testing.
Do you recall approximately when this testing was done by the FBI?
I don't recall the exact date.
From October 21st, 2021, up until the point that the FBI suggested this accidental discharge test, had you been asked by Mr. Baldwin or his attorneys to conduct independent testing on this revolver?
No, we didn't have any other requests.
Were you notified, or anybody in law enforcement, to your knowledge, notified by either Mr. Baldwin or his attorneys that the gun may have been malfunctioning prior to October 21st, 2021?
No.
What did when you interviewed Mr. Baldwin on October 21st, 2021, did he tell you that he did not pull the trigger?
I don't believe he stated one way or the other in regards to pulling the trigger.
Did he use any terminology when he was describing what happened right before the shooting or when the shooting occurred?
I'm sorry, can you ask that again?
Did he explain to you how the shooting occurred?
I think the statement that he made was that the gun just went bang, or just went off. I'm sorry, I don't know the exact words, but something to that extent.
Did you interpret Mr. Baldwin's statement that the gun went off to mean that the gun was modified or altered in any way?
No.
Did you interpret that to mean that he did not pull the trigger?
No.
During your investigation, did you have any indication from either Mr. Baldwin, any witnesses, or his counsel that this gun had possibly malfunctioned?
No.
In examining or in looking at the gun when it came into your custody, did you have any indication to believe that there were any mechanical defects with this gun?
No.
Did you have any indication that the gun could have or previously had fired without a pull of the trigger?
No.
Why did you approve the accidental discharge test?
We had decided to proceed with that test due to Mr. Baldwin. He conducted an interview, a public interview, and I forget, I believe it was with, sorry, I don't remember the gentleman's name. But during that interview, he had made a statement that he didn't pull the trigger on that firearm, which is why we proceeded with that test.
What was your goal in requesting that test?
So the goal of the accidental discharge testing was to see if, in fact, the gun would fire or discharge without a pull of the trigger.
Did you approve the accidental discharge test so that the revolver would be damaged?
No.
May I have a moment, Your Honor, to confer with counsel? I think I'm ready to pass the witness. But if I could just have a moment.
Yes.
So they're just trying to show nobody asked us, nobody cared, before we did it, nobody got in the way of it. So, yes, that woman, Erlinda Johnson, is on Carrie's team. She's one of the prosecutors. So that's who we're getting
At this
to.
time, Your Honor, I have no further questions.
So now it's going to Luke Nikas.
All right, cross
Thank you.
exam.
Yes.
Or Alex Spiro.
Good afternoon, Corporal.
Good afternoon.
Can you hear me?
It's Alec Baldwin's
Yes.
attorney, guys.
Okay, great. When you first described getting to the scene, you referenced Mr. Baldwin and you said he was either the shooter / handler of the firearm. Do you remember saying that he was the shooter or handler of the firearm?
Yes.
And the truth of the matter is, at the time of the destructive testing that we're here about, you weren't certain that he pulled the trigger of that firearm, true?
That is what I was told that he had pulled. That he was handling the firearm.
No, that's not exactly my question. My question is, at
I
the time,
missed that answer. I missed that answer.
you want to repeat the answer? Sorry, Corporal. It was a little hard to hear it for me too.
Yeah. So my knowledge was that he was handling the firearm.
Right. Simply that he was handling the firearm. You were not certain at the time of the destructive testing that he had pulled the trigger of the firearm, correct?
That is correct.
And in fact, at that time, it was quite possible in your mind that the gun had just gone off and that he hadn't pulled the trigger, true?
That was the theory that we were testing, yes.
Now, you talk about the moment that the gun was recovered, and you sort of traced from that moment of the firearm all the way through the different phases that the firearm went through, the hands it touched, whatnot. You recall that part of your testimony?
Yeah.
Okay, I want to go back to the very beginning when you talked about, observing the gun being recovered. You didn't see the gun being recovered, did you, Corporal?
I wasn't present there, but through lapel video.
Oh, okay.
I missed that answer. Through the what?
Lapel video, Your Honor.
Yeah, I just wanted to clarify that for the court, Corporal, because when you testified before, and it may have been the way the question was posed to you, but you indicated that you saw the recovery, as I understood it, of the firearm. Did you not?
Not physically. I was not physically present there.
Okay. And you didn't inspect the firearm when it was recovered either, right?
That's correct.
Right. So when you're telling the court that you first found this firearm, recovered this firearm, and that you saw no modifications, that whole testimony, you didn't actually do that yourself, did you, Corporal?
No, not myself. It was learned through the investigation.
Okay. And that's sort of the same with everything that you said regarding the tracing of the firearm through its different phases here. You weren't in Italy with Mr. Pieta when he says he manufactured this firearm, correct?
Correct.
Right. And it goes from Mr. Pieta in Italy to EMF in California to Mr. Neal. I don't know if anybody knows where Mr. Neal is. Do you know where Mr. Neal has his shop?
I do not know where he resides.
Yeah. So it's to someplace nobody knows. To to Seth Kenny in Arizona, I think, right?
New Mexico.
Was he in Arizona though when he got the firearm?
I'm not sure exactly where he was.
To Sarah Zachary in Albuquerque, right?
Yeah.
Spent the night in Albuquerque, right? The gun,
Yeah.
Sarah Zachary. Yeah. And then it ended up with Hannah Gutierrez Reed on the set of a movie film, right?
Yeah.
And then it was there for any number of days, weeks prior to the incident, right?
Correct.
Right. And you don't have any specific knowledge, frankly, about anything that occurred during any of those various stops with various people in various places around the world, do you?
I wouldn't. I'm not present, but that's, it's part of our investigation is that we learn that.
Well, certain people told you certain things, Corporal. You don't really know what happened with that gun in those various places at those various times, do you?
That's correct.
Had you submitted a firearm for testing in a homicide prior to this case?
Yes, I have.
In the homicide that you were lead detective on, that prior to this case, okay? Was that a homicide that involved a firearm?
I have been involved in a couple homicide investigations involving firearms.
As I understand it, prior to the investigation that brings us here today, there was only one homicide prior to this that you were the lead detective on that led to an arrest. Is that accurate?
That's incorrect.
Okay. How many were there? I apologize if I have that wrong.
There was at least two that I was involved in that I can think of off the top of my head where the individual used a firearm.
Yeah, sorry if my question was clear. I'm asking when you were lead detective, when you were in charge of the case file.
At least two.
At least two. And what two were those?
So, I mean, what specifics are you looking for? I don't.
What cases were those? What were the names of those cases?
So one I had up in the Sanai area, and I don't recall the name of the suspect in that case because he is deceased. And then the other one that I had was a case here closer to Santa Fe, and the last name of that case was Grabe.
And the circumstances, just in one sentence, of that case?
It's ongoing.
He didn't really flee
Pardon?
the scene, though.
It's still
Not really.
active.
No, right, but just the circumstances. Were the
Right.
parties known to each other? Was it a gang shooting? Just a sentence about what that case was. Just
Yeah,
one sentence.
they were all known to each other. Yeah.
Was it domestic?
One of them was.
The second one you're talking about, where the defendant is not deceased?
I mean, I wouldn't say it was a domestic matter. It was more infidelity matters.
Okay. But the parties were known to each other.
Yes, sir.
It was not an accidental shooting.
Correct.
In this case, why did the gun get submitted to the FBI as opposed to state police, DPSO? Can you just explain that to me?
At the time of this case, we had just explored options with the different labs. Our lab at that time had a pretty extensive backlog in evidence testing, so we were just exploring options to see if we could find somewhere where we could get results a bit faster.
And what was the priority involved in this matter?
Because it was a high-profile case.
At the beginning of a week or so into this, as you're beginning to send things off for testing, and I see that your name is on the testing paperwork,
Jeez.
the DA's office, the prosecutors were already involved in this matter,
He is fucking running circles around her.
right?
That's correct.
And they were involved in deciding what evidence to process and what follow-up interviews to do, correct?
Yes, they were.
You were meeting with the DA, then you'd meet with the FBI and your technician, Marissa Popple, correct?
Yes,
You met with the FBI virtually and in person, right?
that's correct.
And nobody limited your resources at that time in terms of what you could or could not test, fair?
Yes.
So I want to now fast forward to April 2022 and sort of give the court a snapshot of where the investigation was at that point. I think I heard you say that, Mr. Baldwin never asked to test the gun. Did you say that? Did I hear that correctly?
Correct.
Okay, but Mr. Baldwin did volunteer multiple times to you to come back in and to answer any questions that you had, correct?
Correct.
And in those text messages with Mr. Baldwin, you never told Mr. Baldwin that you were going to submit the gun for destructive testing, correct?
Correct.
And the prosecutors were in touch with Mr. Baldwin's counsel, and they never told Mr. Baldwin's counsel that they were intending to present this gun for destructive testing, did they?
I wouldn't know the conversations between the prosecutors and the defense.
They never told, I apologize. They never told you that they, don't worry about the fact that the gun is destroyed. We told Mr. Baldwin's counsel so they had every opportunity to view it, right? They never told you that, did they?
That was not relayed to me.
Okay. And so in April of 22, at that point, you have not conclusively determined how the live ammunition got on set, correct?
Yes, that's correct.
And you turned back to the gun in April of 2022 to do this further testing, correct?
I don't know the actual date, but if that's what it states, then.
And at that point, as we talked about it, as the examination opened, there were sort of two possibilities. One is that Mr. Baldwin pulled the trigger and discharged the weapon, and the other one is the possibility that the gun went off and you were attempting to use your words, disprove Mr. Baldwin's statement that the gun had just gone off. True?
I think I needed to further elaborate on what I had meant by that.
So we needed to figure out how to disprove that theory or that statement. And that was the way that was proposed to us and what the FBI could do. Fair?
Right. Like I said, I think that what I had said there was probably not a full statement or explanation in what we were trying to do.
Well, that's the statement that you gave.
I understand that that's the statement that I gave. However, I needed, if, you know, I had given time to further elaborate, or if I was able to further elaborate, then what would have been explained was that we were testing the theory due to the statement he made that he did not pull the trigger.
That's fine, Corporal. And I don't, I'm just going to break that down a little bit, though, just so that the court understands, right? That's what you said under oath, true?
Right.
Okay. And Miss Morrissey was the one asking you questions. She didn't cut you off or anything, did she, Corporal?
No.
Okay. And that was the statement you gave under oath at a trial where a person was facing homicide charges and ended up going to prison, true?
Yes.
Okay, this wasn't some casual conversation. You were testifying under oath in front of a jury in the very courtroom you'll be testifying in this manner, correct?
Yes.
Okay. Now, you talk about this statement that Mr. Baldwin made on national television where he denies pulling the trigger. You talked about that, right?
Yes.
Okay. What I've always wanted to understand is if he made that statement in December, okay, of 2021, why did you wait until April of 2022 to order the destructive testing?
I don't know when it was actually ordered or when that conversation came about.
I want you to assume for the sake of this, okay, that the interview, which was broadcast all over national television, in which he adamantly denied ever pulling the trigger, right, happens in December of 2021 and is a matter of record, okay? I want you to assume for a second that the order for destructive testing is April 2022, okay? Can you explain to me why all of a sudden in April of 2022 there was urgency or need to order the destructive testing?
Again, I think there's a lot of factors that go into that, though. Where the FBI was in their testing, when we found out that this test could be performed, it's not, I don't think it's as simple as he made the statement in December and then in April it was ordered. There's a lot of factors that go into that. It was an evolving investigation still at that time. And, I can't even recall the day that we were made aware that that test was possible.
Okay, well, we're going to pull up that email in a minute, but rather than talking in hypotheticals, can you give this court any information about why the delay actually occurred? Right? You said, well, they could have been backed up on testing, or we could have not known about the testing. When did you, lead agent on this case, begin to explore the possibility of the destructive testing? How long after the very public interview that Mr. Baldwin did?
I would have to know when that option was presented that could be done.
And I think I understand your answer. So what you're telling me is, until somebody gave you the option of a destructive test, you did not seek out that option. Is that am I understanding you correctly?
I did not know that option existed.
Okay. And as we talked about before, you had supervisors working with you, Sergeant Zook, Lieutenant Martinez, right?
I do believe that they were the supervisors at that time.
Right. And you had the DA's office working with you, right?
Correct.
And you had their investigators working with you?
Yeah.
Right. You weren't the only one that came up with ideas and things that could progress this investigation, Corporal Hancock, right? You guys were making group decisions and talking about possibilities to further this investigation. Isn't that true?
Yeah.
Now, you say at the moment that he denies this, that he ever pulled the trigger, which is this December national broadcast statement. Have you reviewed that statement?
I have, yes.
And you reviewed it when it happened, right?
As he was giving it?
In the days and weeks that followed. You reviewed it contemporaneously, right?
Yes,
You've reviewed it many times, fair?
several, yes.
And you would agree with me that he adamantly denies pulling the trigger, fair?
Yes, he does.
And you knew, and I'm going to go back to before the accidental discharge. You know, when you were being directed by the prosecutors, some of the information you were providing to the court is stuff that you've learned in the past weeks, right? It wasn't all information that you knew at the time of the destructive testing, fair?
That's fair.
Right. So at the time of the destructive testing, you said, and in sum and substance, that there was no body and no information about a potential gun malfunction that was available to you. Right?
Right.
Okay. But Mr. Baldwin had said that he didn't pull the trigger, right?
In his interview, yes.
He had never told you yourself, Corporal, in sum and substance, that he didn't pull the trigger, that he didn't volitionally fire that gun?
In my interview with him, he didn't state either way. So,
You knew there had been accidental discharges on the set, true?
yeah,
You knew that those had included accidental discharges with revolvers, correct?
yeah,
You knew that Seth Kenny provided those weapons and confirmed to you that there were accidental discharges with those weapons, right?
I'm not sure if he's the one that confirmed it, but
Hey.
through interviewing the people that
Hey, Dolly, I'm
were
gonna
around
be
at
right
the
back.
time, they confirmed it.
And in your mind, as you've already testified, there was a possibility that the gun had just gone off, right?
And that's why we tested the theory.
Right, but in terms of this concept of whether or not there could have been a malfunction, and this is your word, the word malfunction. Mr. Adiago had told you that from his vantage point, the gun had just gone off, right?
I don't know his specific wording.
Duran Curtin had told you the gun had just gone off, right?
I don't recall interviewing either of those two people. So,
Well, when you were talking to the prosecutor, you used information that not only you yourself learned, but that you had learned during the course of the investigation, Corporal. Don't you know that the witnesses the night of the shooting pretty much uniformly said that the gun just went off?
that's potentially, but your statement was that they told me that. They did not tell me that.
So let me withdraw the you that, okay? Again, that's when you were testifying on direct and you were saying how you recovered the weapon, there didn't seem to be an issue, but that's fine. You understand from reviewing police paperwork that the witnesses that were interviewed the night of the 21st, okay, indicated that the gun just went off, true?
If that's what they said, I don't know their exact statement.
Okay. Are you aware as you sit here whether any of the witnesses the night of said verbatim, the gun just went off?
I think that's kind of in the
Your Honor, I'm going to
common.
object. It's been asked and answered, and counsel's getting argumentative with the witness.
She appears to be able to answer this. Let her answer and then we'll move on.
You are aware that witnesses that night indicated to members of law enforcement that the gun just went off, true?
I think that's been a common phrase used. Yes,
It was a common phrase used, correct?
right.
It was what?
A
A common phrase used.
Oh, common phrase.
And Hannah Gutierrez Reed had told you that if you touch the trigger, it'll just send the hammer down. He told you that, right?
Yes, that's how they would
She
operate.
had, she had also told you that she had trouble loading a firearm on the day of the incident, right?
Yes, she did state that.
And people had told you or law enforcement that the firearm had a quote unquote hair trigger. True?
I'm sorry, a what?
Hair trigger.
I don't know if that was the phrase used, but that's what they said.
And that it was a sensitive gun, quote unquote.
I don't recall that phrase either.
You knew that the gun was an important piece of evidence. True?
Yeah.
Hey, Dolly.
Hey, Dan.
And in deciding whether or not to go forward with the test, who was involved in making that decision?
Prosecutor only.
I don't have specific names, but again, it was discussed with members from the sheriff's office, our
So,
evidence team, the
so Dolly, and I know if people are new, Alec Baldwin's filing a motion to dismiss because when they destructive tested the revolver, they broke parts of it. And
Yeah.
therefore they're arguing all the original evidence has been destroyed and it's not reliable. So that's where we are. And this is Alex Spiegel just grilling Corporal Hancock. And it's just different quality of attorneys just grilling her and lighting her up. And she is not hanging in there very well.
No.
No.
I mean, she could handle bulls pretty well.
Her 110 PSI lips. So,
Good Lord.
all right, guys, let's keep going.
FBI and the district attorney's office.
And who ultimately made the call?
Again, it was a group or a collective effort in proceeding with it.
Did you do any research into the ramifications of this testing?
I was made aware that the test could damage the firearm.
Did you look into other options?
No.
Did you confer with any experts? You were the prosecutor.
He does. He wants to feel this is a crusade. I don't think it's going to go anywhere.
Anything else at this point that you did?
Yes, her eyeliner's awful.
To answer this question in your mind of whether or not to move forward with this test?
I'm sorry, can you state the question again?
Sure. At this time, when you decide to go forward with this test, is there anything else that we haven't talked about that you did to help answer the question in your mind of whether or not to go forward with this test?
No, because that was presented to us, so that's the option that was discussed.
Did you provide the FBI with any of the actual real life circumstances of how this incident occurred?
What do you mean by real life circumstances?
Well, you know that the FBI tested the gun by smashing it with a mallet, right?
Yeah.
Okay, I presume you did not tell the FBI that's what occurred in this case, right?
That's correct.
Okay, and you didn't tell them that the gun went off by being dropped either, did you?
Correct.
Okay, but did you describe to them the circumstances of how it actually went off?
I didn't know the circumstances of how it went off. That's why we were testing functionality and then potential for accidental discharge.
You didn't know 6 months into the investigation, any of the surrounding circumstances that might have informed the FBI's testing?
I'm not sure I'm understanding your question.
Okay, well, you had the ability to communicate with the FBI, right?
Correct.
There was nobody put a restriction on your ability to share information, right?
That's correct.
Okay, and they were deciding what test or tests to perform on this firearm. You understood that, right?
Yeah.
Okay, and so I'm asking you at that point, did you explain in any way, shape, or form the circumstances surrounding either the pulling of the firearm and what happened, the motion that Mr. Baldwin did, or any of the circumstances that led to the incident? Did you describe any of those to the FBI?
There was actually very limited information given to them at when we had first started using the FBI for evidence testing. They weren't given all details of the investigation because it was still being learned.
Well, at this point in the investigation, you had a case file, right?
Yeah,
Okay, and in your case file, you had the SFSO reports from the night of 10/21, true?
I don't know exactly when they were done. They took quite a while to produce reports from this.
You don't know whether within 6 months the reports from the night of were done? You don't know that as you're sitting here, Corporal?
I'm sure that some of them were done, but the case was still under investigation at that time.
I agree with you that the case was under investigation at that time, but I'm asking you, the reports from 10/21, the night of, those were already in your case file as of April 2022, 6 months later, fair?
I would think so, but
Okay.
there were a lot of people working there.
If we could pull up what's going to be defense one, which is the exhibit that I want to talk to you about next, which is the email chain, as we're getting it up, between the FBI and Mr. Ziegler, who tested the gun, and of course you and Ms. Popple. And if we could blow up that top page. You see, it's April 21st, 6 months after the incident, right?
Correct.
Okay. And the email indicates
He may have been likable, but he's
from
getting the
Mr.
job
Cortez, who was your liaison at the FBI, right?
Yeah,
I spoke with Detective Hancock. That's you, right?
correct.
Okay. And you would like to request the below, and we can go down, right? And it indicates, I think on direct examination that you said that the test could, was the word you used, could result in damage to the firearm, right?
Yeah,
Okay. But if you look down at this third paragraph here, it says, second sentence, we're tracking that this will alter the firearm and it will not longer be in the same physical condition that it was seized in. Do you see that?
yeah.
And this is an accurate representation, I have no doubt, of what the FBI understood at the time. True?
Objection, Your Honor, calls for speculation.
Sustained.
This is an accurate reflection of what you understood at the time, right?
Well, the statement here is that it will alter the firearm and not be in the same physical condition. It doesn't state in here that it will be damaged.
Okay. But you do agree with me that you understood prior to the testing that it will alter the firearm and it will not longer be in the same physical condition. You did understand that, right?
Right, as it states here.
Okay. And you're copied on this email, of course, right?
Yeah,
And it says, enhanced test fire to verify if the firearm functions without pressing the trigger. Is that a fair assessment of what you were trying to accomplish?
yeah.
Okay. And at this point, you end up authorizing, you and the team end up authorizing the destructive testing, true?
Accidental discharge, not destructive.
Okay. The testing that ended up being destructive, you want to call it the accidental discharge test? That's fine. You ordered the accidental discharge test. Okay.
Yeah.
Okay. You do not ask the FBI to disassemble the firearm and to take pictures of it, do you?
That's, again, I don't know their processes on how they run their testing. So it's, I don't believe it was specifically requested from us.
You did not ask the FBI to videotape the testing, right?
I don't believe that was in the request.
Okay. You didn't tell them, we need to notify defense counsel of the target, right?
Correct.
You didn't go to a judge or anything like that, right?
No,
Okay. You didn't tell them to come back to you as the testing progressed and to check back in with you, did you?
no,
You didn't tell them to preserve what they were doing in any way, shape, or form, did you?
no.
And you understood, or you understand as you're sitting here now, that the test did alter the firearm, right?
Yes,
It did make it so that it's no longer in the same physical condition, right?
yes,
And no one will ever be able to bring it back to the condition that it was in when it was recovered, right?
Objection calls for speculation.
If you know.
I'm not a firearms expert, so I don't think I can testify to that.
How were you informed that the firearm had been destroyed or broken? If you want the word broke, if you don't like the word destroyed, broken.
I believe through their report, through the FBI's report.
That you eventually received.
Yes,
Nobody called you afterwards and said, just so you know, the firearm in this case is destroyed.
I don't recall ever receiving notice.
And you, as the case agent, never made any other request to the FBI for any further testing of this firearm, true?
That's correct.
I have nothing further for this witness at this time.
Redirect.
Yes, Your Honor, briefly. Corporal Hancock, on October 21st, 2021, did you believe that that gun had fired without a pull of the trigger?
I didn't know at the time.
Did you have any indication or any reason to believe that that gun on October 21st had fired without a pull of the trigger?
No,
Did you have any indication that the gun was malfunctioning on October 21st, 2021?
no,
Have you watched Lieutenant Benavidez's lapel camera video or dash camera video as well?
yes, I have.
Okay. And is it on that video where you watched him taking custody of this particular revolver?
Yes,
Does Lieutenant Benavidez do anything with the gun after he takes custody of the gun, other than put it in his vehicle?
Objection if she knows.
If you know.
I'm sorry, can you state the question again?
Based on your observation, well, let me ask you this way. Based on your observation of the lapel video and the dash camera video from Lieutenant Benavidez, did you see him do anything with this gun other than take it from where he seized it and put it in his vehicle?
That was all that I observed.
Now, Mr. Spiro asked you questions about communication Mr. Baldwin was having with you after October 21st, 2021 via text message. In any of those text messages, did Mr. Baldwin tell you that gun may have been broken or may have been modified or altered in any way because it fired by itself?
No, I don't recall him ever making that kind of statement.
And at the time that this accidental discharge test was authorized, was Mr. Baldwin charged with a crime?
No,
And is it your practice as a law enforcement officer to tell the defense what investigative steps you are taking in an investigation before
No.
they're charged with a crime?
no,
Now, you were asked questions about your statement that you made when you testified in Ms. Gutierrez's trial, that you were trying to disprove the theory, that theory or that statement, I believe is the words that were used. What did you mean by that?
So essentially what I had meant was that there, was statement that the trigger was not pulled when that gun discharged. And to, check the facts of the validity of that statement, we did need to test that theory.
Now, you were asked questions about the December 1st, 2021 televised interview that Mr. Baldwin gave to one of the networks. And do you recall the date of Mr. Baldwin's interview with the OSHA investigators?
I don't recall the date of it.
Would reviewing the transcript of his OSHA interview refresh your memory as to the date of Mr. Baldwin's OSHA interview?
Yes, ma'am.
If you would please, and let us know when your memory is refreshed.
Okay.
So, guys, at the end of the day, I don't think this is going to be the gun had its agency and its own truth to tell.
Okay, I'm refreshed.
This is not going to end.
When did Mr. Baldwin give an interview to the
OSHA?
OSHA investigators?
He gave the interview on December 8th, 2021.
Yes, no one likes it.
And was that after the ABC interview or the network interview Mr. Baldwin gave that Mr. Spiro asked you about of December 1st?
That is after.
What exactly, if you could please testify and tell the court, what exactly did Mr. Baldwin, 7 days after his interview, where he disavowed pulling the trigger, what did he tell OSHA investigators about this particular firearm?
He had told the investigator that nothing was wrong with the gun, and that the only thing that was wrong with the gun was that there was a live bullet in it. He said he hadn't had any issues with that weapon.
Are those his words verbatim?
It's not verbatim.
Would reading the transcript at page 42 refresh your memory as to exactly what Mr. Baldwin told OSHA investigators?
Yeah.
If you would, please.
Okay.
What exactly did he say when he was asked about if the gun had any mechanical defects?
He said that it didn't. He said the problem didn't have to do with the gun, it had to do with the bullet. And that he said that there was no mechanical defects of the gun.
Now, you were asked by Mr. Spiro about 2 other accidental discharges that had occurred on set. To your knowledge, based on your investigation, were either one of those with the gun Mr. Baldwin used?
To my knowledge, no, they were not.
Did you understand the phrase "went off" to mean Mr. Baldwin did not pull the trigger?
No.
Did you? I'm sorry, go ahead.
I would just interpret that as the gun discharged.
Did you understand the phrase "went off," that the gun malfunctioned?
No.
Were you offered any other options by the FBI after they did their functionality test and other testing? You were offered the accidental discharge test, is that right?
That's correct.
Were you offered any other tests by the FBI?
That is all that I can remember them offering.
Now, was it your understanding you were asked questions about an email from, I believe, Agent Cortez? Did you understand that the accidental discharge test would definitively break that firearm or that it might just possibly break it?
That it would possibly break the firearm.
Your Honor, at this time, I have no further questions. Thank you, Corporal.
I have very brief follow-up, Your Honor.
Any objection?
Your Honor, they had cross-examination. I would object. We have 2 hours for this hearing that the court has allotted. We have 2 other witnesses waiting to testify.
All right, no, okay. This witness is excused. All right, we've got another witness waiting to come in.
So I don't like the red ceiling. Yeah, but
All
honestly,
right, is
guys,
this your next witness? Where'd he go? Ziegler. Is this your next witness?
Yes, Your Honor. Mr. Ziegler?
this
All right, please raise your right hand. Do you swear affirm under penalty of law
guys,
that the testimony you'll give in this case will be?
you guys need to, like, there's no way he's winning these motions.
Yeah.
Especially Alec runs around and says, you know, like, oh, I was playing with a hammer and there's no way it could have worked. Well, yeah, they did. They were testing their theories. Ultimately, is this theory that this is a prosecutorial witch hunt? No, it's not. This is, once again, these are very highly competent, highly skilled attorneys doing their job.
Yeah.
So, you know, that's where we are at this point.
Be the truth, the whole truth, and nothing but the truth? You're on mute.
Hey, Sean's testifying.
Yes, Judge, I'm here.
I do, Your Honor.
All right, thank you. Go ahead, Ms.
Thank
Johnson.
you. Thank you. Mr. Ziegler, would you please introduce yourself to the court?
Yes, my name is Bryce Ziegler. First name spelled B-R.
You guys remember these are the same people from the trial.
Yeah.
Remember him. Also, guys, if you're trying to figure out who's who, down here will be their name. So there you go.
Y-C-E. Last name spelled Z-I-E-G-L-E-R.
And how are you employed, sir?
I'm currently employed by the Federal Bureau of Investigation within the Laboratory Division, and specifically, I'm a forensic examiner in
Yes,
the
he's a
Firearms
bad
Tool Marks
guys.
Unit
How long have you been employed by the FBI lab?
since 2011.
And what is a forensic examiner in the firearms unit?
So essentially, I am my main duties are to receive evidence that's relevant to my discipline, perform the requested forensic examinations on those items of evidence, issue my results in a formal laboratory report, and testify to those findings if requested.
And those essentially are your duties as a forensics examiner?
That's correct.
What is your educational background, Mr. Ziegler?
I received a Bachelor of Science in Forensic Science from the Pennsylvania State University.
And did you go work for the FBI after obtaining your degree?
Yes, I did.
Okay. And did you receive any specialized training to become a firearms examiner?
Yes, so I had to complete what's called the Forensic Examiner Training Program. And that training program is for all forensic examiners at the FBI lab, but it's specific to the unit that that person is seeking a qualification in. So I had to complete that program in order to be considered a qualified examiner.
And how long was that program?
It took me a little over 3 years.
And since completing that program, do you continue to obtain educational classes and continuing education?
Sure, there are some continuing education requirements, and there's also proficiency testing that I must continue to do as well.
And after you finished the initial training, did you then receive on-the-job training as well?
I would say that on-the-job training really occurs during the training program. So I'm working with qualified examiners. I had a mentor that I worked with. I actually worked cases while in a training status, but all my work would be reviewed by a qualified examiner. So I'd say that on-the-job type training occurs prior to the qualification.
Does the FBI lab have protocols and standard procedures as it relates to firearm exams and firearm analysis?
Yes, we do.
And is there a standard protocol for each test that you conduct in the firearms unit?
Yes, there is. Some of the examinations are combined into a single protocol. Others have their own independent protocols.
And do you follow those procedures when you're doing your firearms examinations?
I do.
Approximately, in your career with the FBI, approximately how many firearms have you examined?
I would estimate that number to easily be in the thousands of firearms.
Let's talk about your examination of the evidence revolver in this case, and we'll refer to it as the evidence revolver. Were you asked to examine and conduct tests on the evidence revolver in this case?
I was, yes.
And what were you, who asked you to conduct these exams?
Right. So typically evidence is submitted to the FBI lab from a special agent. So in this case, that person was Jose Cortez. So he submitted evidence to the laboratory, and essentially that evidence comes with a request, a written request on what the contributor would like done.
And what was your understanding about whether or not this was an FBI request, or was it a local law enforcement request?
It was my understanding that it was a local case. However, sometimes locals come to the FBI to ask for assistance.
And is that routine?
It does happen. Yeah, I'd say it's fairly frequent.
What were you initially asked to do as it relates to this firearm?
So specifically with the firearm, I was mainly just asked to assess its function. So that includes things like, are the safeties working correctly? Do I notice anything about the firearm that I may determine that I feel it may be unsafe to fire? So things like blockages in the barrel, bulges in the barrel, potential weak points within the firearm. So things along those lines.
And is part of that function test also doing a test firing of the firearm?
Yes, it is.
Okay. And who did you receive this firearm from in your particular unit?
So when evidence at the laboratory is transferred from one unit to another, it gets dropped off in my unit at a secure storage location. So that's a location that it's badge access only. So people have to have the proper, badge access in order to pick up those items. And then once it's dropped off in our unit, we receive a notification, and either myself or a technician will retrieve those items from that location to begin either taking notes or conduct the actual examination.
Do you recall when you received the evidence revolver?
I do have my notes. I'd have to refer to that.
If you would please refresh your memory with your notes, and then let us know when your memory is refreshed.
Yes, so I can tell you that the exams, and when I say the exams, I'm talking about initial documentation. So just things like photographs, annotating the make, model, caliber, things of that nature. They began in April of 2022.
I'm going to show you what's been previously marked and admitted by stipulation as State's Exhibit 3. Do you recognize that, Mr. Ziegler? If you can scroll up a little bit.
Yes, I do.
What is it?
So this is a case notes worksheet. It's a firearms function worksheet. So this is exactly what I was describing to you before. When a firearm comes to my unit, it typically gets photographed, and then some of that kind of background information, make, model, caliber, things of that nature are recorded on this standardized document.
And the photograph that's depicted on Exhibit 3, is that the evidence revolver we've been talking about?
Yes, that's correct.
And does that photograph accurately depict the way that that evidence revolver looked when it was received in your unit?
Yes, yes, it does.
Was there anything about that evidence revolver when you received it in your unit that indicated to you that it may not be working properly or malfunctioning, or that internal components were modified?
No, not in the condition it was received.
And you testified that you did an initial inspection of the gun?
That's correct.
And upon doing that inspection, did you note any defects or alterations on the gun?
No, that initial inspection is basically a safety inspection. And as you pointed out, if I notice anything odd about the firearm or something that may give me cause for concern that it may be unsafe to fire. So I didn't see anything of that nature, so I felt it was safe to fire. So at that point, we did the test firing.
So that was your next step in the process, was the test fire?
That's correct.
Can you describe the test fire for the court, please?
Yes, so I can take this firearm to one of two locations at the FBI laboratory. We have a 25-yard range, and we also have what's called a water tank, which allows me to retrieve fired bullets. So it's a large metal box filled with water. You shoot into the port, it takes away the energy of the bullet, and I can collect the bullet if I need to do so. So I took this particular firearm to the water tank, and I used laboratory ammunition. I loaded it in the way it's designed to be loaded. And while I do this, I'm checking the positions of the hammer. I'm ensuring the safeties are operating correctly. I'm assessing if the internal parts, so things like the trigger connection with the hammer, if those internal operations appear to be functioning normally. And after all of those things, I would actually physically fire the gun.
Before we get to your test fire, you said that you checked the position of the hammer. Did you do that in this case?
Yes.
And can you explain how many positions that hammer has?
This hammer has a total of 4 positions.
Can you describe what each one is?
Yeah, so in its most uncocked or at rest state, that's when the hammer is fully forward. It's as far forward as it can be, and it's essentially resting up against the frame of the gun. Now, as you start to cock the hammer, there are notches, and you can't see them in this picture, they're on the inside. But there are notches in this hammer that as you cock it, the rear portion of the trigger, which is called the sear, you can hear it click into those positions. So if I have my hammer at rest and I start to cock it, I'm going to hear the first click. That notch is called the quarter cock. Sometimes it's also referred to as the safety notch. If I continue to cock it further, you'll hear a second click. That's the sear dropping into the half cock notch, which is sometimes referred to as the loading notch. And if I pull it fully to the rear, I'll hear a third click, and that's where the sear is sitting in the sear notch. At this point, that is the position where this firearm would be ready to fire if the trigger's pulled.
I'm going to show you what's been marked as State's Exhibit number 4. Do you recognize what's depicted on 4?
Yes, I do.
And what is it?
These are photographs that I took depicting the 4 hammer positions that I just described to you. So you see how far it gets cocked back in each position from the side view, which is the column on the left, and from the top down, which is the column on the right.
When the hammer was in the full cock position, did you experience at any point that the gun discharged without the pull of the trigger?
No, so when the hammer's in the fully cocked position, as I mentioned before, the sear is sitting in that final notch. So essentially, for this hammer to fall, that sear has to move out of the way. So however that is achieved, that's what has to happen. Now, if this firearm was, as you mentioned, if there was an issue where the hammer was falling just on its own, if you look at the bottom 2 photographs here, this hammer is currently in the full cock position. I'm not holding it with my finger. My hands are nowhere near this firearm. So it's sitting in that full cock position on its own. So it has proper engagement. It's not falling by itself. And again, this is how it was received. I wasn't noticing any of those types of failures in the condition it was received.
Can you explain?
Guys, I'm really sorry. This is basically him redoing his testimony, but I thought there'd be a little more fireworks in this one.
How this revolver fires as opposed to, for example, a semi-automatic?
Sure. So a semi-automatic does a lot of the work that the shooter has to do for you. So it's automatically going to extract, eject the fired cartridge case, chamber the next available cartridge, and then essentially the shooter just has to pull the trigger a second time. With a firearm like this is called a single action revolver. Single action refers to the shooter must manually cock the hammer each time they intend to fire. So there are other types of revolvers called double action where the shooter does not have to manually cock the hammer. They can pull the trigger and it performs that action of cocking and releasing the hammer. However, in a single action revolver, the shooter has to perform that one action manually.
And what position does the hammer have to be in order for it to fire, or the trigger to be pulled and it fires?
Right, so this firearm is designed to fire with the hammer in the fully cocked position. So the bottom images that you see here.
You also testified that you inspected the trigger connection with the hammer.
Yes.
Did you find any defaults or any problems with the trigger connection?
Right, so just to be clear, I did not disassemble the firearm prior to test firing it, so I don't have any visual type of indicators whether there was an issue there or not. However, if there was an issue, I would have expected to see that during the test firing. So whether the hammer would not stay in the full cock position, whether it would be falling on its own, I would have expected to see something if there was some type of malfunction with that connection.
And do you need to disassemble a firearm to determine whether it functions as it's designed or properly?
No, not necessarily. If I go through essentially all the steps to check the safeties, check to make sure the action appears to be functioning correctly, and I physically test fire it, and I don't see any abnormalities that occur during that test firing, then no, there's no reason for me to then disassemble it if nothing odd has happened during that test firing.
And how many times did you test fire this revolver?
I test fired this particular one 12 times.
And during each one of those 12 times, did you observe any of these issues that you just mentioned that would cause you concern that maybe this gun could malfunction?
No, there was nothing odd or abnormal about this during the initial test firing.
And when you did the test firing, did you check the different hammer cocking positions?
Yes, I did.
Okay. And at any point during each one of those 12 test fires, did the gun discharge by itself without a pull of the trigger?
No.
And you testified that you checked the hammer's quarter cock hammer position, right?
That's correct.
Did the firearm fire when it was in the quarter cock hammer position?
So that portion of the testing I did during the later phase of accidental discharge testing. When I say that I checked the quarter and the half cock positions, those positions are designed so that if you are cocking the hammer, and if I cock it past the quarter cock notch, and if my thumb slips off the hammer, that quarter cock is meant to catch the hammer before it falls and makes contact with the cartridge. So when I say that I checked those positions during the function assessment, what I mean is I pulled the hammer past those notches, released it, and ensured that that safety mechanism was actually working correctly. So I did that for both the quarter and the half cock positions.
And were the safety mechanisms working correctly?
Yes, they were.
When you had the hammer in the full cock position, did it hold in that position until you pulled the trigger?
During the initial test firing, yes.
What were you able to determine after you conducted your physical examination of the gun, the examination of the trigger of the hammer, and the 12 test fires? What did you determine?
So the end result in relationship to the function exam is just that it functioned normally. And again, that means I didn't see anything abnormal, odd. There were no apparent either damage or modifications that would have rendered this firearm unsafe.
Would you say it functioned as designed?
Yes, it functioned normally as it's designed.
And what does that mean when one uses the term function as designed?
It's basically what I just described. So while I'm conducting my checks of the firearm and physically test firing it, nothing out of the ordinary happened during that testing. So if I had a discharge without pulling the trigger, or if I noticed that the sear notch was not engaging properly, that's something that is out of the ordinary. So that would not be functioning normally, and that's something that I would have annotated in my notes and the report. So I wasn't seeing any of those things. So that's what function normally means.
And as part of your examination, did you also conduct measurements of the trigger pull?
I did.
And what is that? What is that intended to measure?
So in my laboratory, when I do a trigger pull examination, it is not to determine the exact amount of force that is required to pull the trigger. At my laboratory, it is designed to establish a range. So at the lower end of that range, I'm confident that that is not enough force to pull the trigger. And at the upper end of that range, I'm confident that essentially that amount of force or weight will cause that trigger to pull every time that I test it.
And how did you conduct this trigger pull test?
So essentially, if you picture a wire coat hanger, so I have a long wire with a hook on the top, and I would orient the firearm vertically, so the muzzle will be pointing straight up at the ceiling. I would hook this, essentially the coat hanger portion of the hook inside the trigger guard, resting on the trigger, and then I kind of add static weights to the bottom of that wire. So I can continue to add weights until I reach the point where it's starting to pull the trigger as I pick up on the firearm. So the amount of weight that's added, that's going to be the amount of force that's required to pull the trigger.
And what amount of force was required to pull the trigger for this evidence revolver?
So in my note taking and during my exam, I measured that amount of force to be between 2 and 2.5 pounds.
And what does that mean?
Can you elaborate?
Well, does it mean that it would take 2 to 2.5 pounds of force to pull that trigger?
Somewhere in between those values, yes.
Would that be considered what people call a hair trigger?
I personally would not consider that to be a hair trigger. When I think of a hair trigger, I think of either very high performance hunting rifles, things of that nature, where the amount of force on the trigger, I don't have a specific number for you, but it's extremely light, where you just barely have to touch the trigger to fire the firearm. It's typically, you see them in hunting rifles.
Did this particular revolver fire at any point with less than 2 pounds of pressure on that trigger, based on your exam?
Right, so I can't answer that question because I don't know the exact amount of force that I'm using while I'm doing the actual test firing. I can just tell you that when I did the measurement with the static weight set as I described, it would not pull with less than 2 pounds of pressure.
When you were conducting the trigger pull measurements, was there any indication to you as a forensic examiner that this trigger had been altered?
No, there was no indication. I feel this range is very common for this style of firearm.
When you're doing the trigger pull measurements, do you also engage the hammer?
Right, so in order to test that, the hammer would have to be in the fully cocked position, because that's how this firearm is designed to fire.
And so in the fully cocked position, the amount of pressure during your measurements that it took to fire this gun would between 2 to 2.5 pounds?
That is correct.
Did, after you conducted your physical exam of the gun, the trigger, the hammer, and your test fire, was another test conducted on this firearm?
Yeah, so I did do some other exams with the ammunition, but if we're focusing specifically on the firearm, the next test is what's called accidental discharge.
Before we get to the accidental discharge test, were the exams that you just testified about, were those conducted according to FBI procedures and protocols?
Yes, they were.
So what is an accidental discharge test?
So in my laboratory, the accidental discharge test, it seeks to determine if I impart a certain amount of force to this firearm, is it even possible for this firearm to fire without pulling the trigger? And the way it's done in my laboratory is essentially I would take a rawhide mallet and I would strike the firearm on 6 planes. And when I'm referring to those 6 planes, if you pictured a cardboard box sitting in front of you, the 6 planes would be the front of the box, the rear of the box, the left side, right side, top, and bottom of the box. So those are the 6 planes. And essentially when I'm striking this firearm with a rawhide mallet, the goal is to determine is this amount of force, this vibration, this shock, is that enough to cause the inner workings of the firearm to disengage and actually allow the hammer to fall and fire the shot? So this test is really designed to mimic if the firearm's been either banged into something, or maybe hit with an object, or maybe even dropped or something of that nature. Some type of force has been introduced to this gun.
Now, before we get to your accidental discharge test that you conducted in this case, did you document, photograph the condition of the firearm before the accidental discharge test?
Yes, so all the photos that you've seen so far were prior to that test.
And prior to the accidental discharge test, did you have any indication that this revolver was altered or modified in any way?
There was nothing that jumped out at me now.
So once you got to the point of accidental discharge test was the next
Oh,
test that
God,
you were going to
it's
conduct.
basically the
Did
trial.
you contact
The third time a
the
testimony.
local law enforcement?
Holy shit for this guy.
I contacted the special agent Cortez, the case agent.
And was it your idea, or did you suggest that there was this test available?
Yes, I did.
Now, to your knowledge, have other firearms examiners at the FBI lab conducted the accidental discharge test in other casework?
Yes, I've seen them do it while I've been in training.
Now, is there a procedure and protocol that the FBI has in place for conducting the accidental discharge test?
Yes, there is.
Did you receive authorization to go forward with the accidental discharge test?
I did from the case agent, yes.
Now, can you describe for the court how you did the test in this particular case, where you had the firearm and how you went ahead and conducted the test?
Sure. So to actually do this examination, I use what's called a remote firing platform. And essentially, you could think of that as a padded vise designed specifically to hold firearms. So it essentially has a vise, but it kind of has rubber on the inside. And I clamped this firearm into that device, and then I continued with the testing as I previously described, striking with a rawhide mallet on 6 different planes. And I also wanted to test this firearm in all 4 positions of the hammer. So I wanted to kind of exhaust all efforts for any condition that hammer could have been in.
Now, was the rawhide mallet that you used, was that affixed to another device, or were you using that freehand?
No, that was me physically holding it.
Now, can you describe, if you could use your hands and demonstrate to the court how you applied the force with the mallet, the force to the gun with the mallet?
Right, so it would depend on which of the 6 planes that I was working with at that time. So I don't know if I could give you one description that would encompass all 6 of those planes, but I would liken it to similar to hitting a nail with a hammer, something to that effect.
And were all those in a straight line, or could some of those come in at an angle?
Right, so I'm a human being, so there's a good chance that there's going to be some variability in each of those strikes. So sure, it's certainly possible that not all of them were completely perpendicular to the firearm.
And when you're doing the accidental discharge test, did this revolver discharge when the hammer was in the quarter cock position?
So because of the design of this firearm, in the 2 intermediate settings, the quarter and the half cock, I did not have to do the striking with the mallet test.
So was your test then done with the hammer in the full cock?
Yes, I did the striking with the hammer at rest and in the fully cocked position.
At rest, did it discharge?
It did.
And when the hammer was in the fully cocked position, did it discharge?
So I did have one event where it discharged with the hammer in the full cock position. And what occurred is I struck the hammer directly with the rawhide mallet, and the hammer fell. And when we do this testing, I use a primed cartridge case. So I remove the bullet from the cartridge, I dump out the powder. So it's just a case with a primer in it. So that's obviously done for safety purposes, so I'm not firing a shot if there is a firing event. And then I can audibly hear if the primer is detonated. So I struck the hammer fell, and detonated the primer during this one event. And what was interesting to me is I thought it was odd that the quarter or the half cock safety notches did not catch the sear as the hammer was falling. So this led me to believe that there was some type of damage that occurred during that event.
But you had to apply a good amount of force for it to discharge, is that right?
Right. I can't quantify what the force was.
Now, was the discharge with the hammer in the resting position, did you expect that? Was that something that was expected?
Yes, this is a known issue with a revolver of this design. In fact, if you would read the owner's manual for this type of firearm, you would see warnings not to carry this firearm with the hammer at rest on a loaded chamber.
So can you describe what eventually happened as a result of this accidental discharge test?
Sure. So as I mentioned, I had some suspicion that something occurred inside that allowed this hammer to fall that was not normal. So eventually, after this testing, I took the firearm apart and I was able to find 2 locations that had actually fractured during that striking event. So it's my opinion that the firearm would not have fired unless those 2 pieces fractured like they did.
Were you able to fire the firearm after these pieces fractured?
No, it was no longer operable in that condition.
Now, let me go back just briefly to when you offered this test to local law enforcement. What did you tell them about the possibilities of what could happen during this accidental discharge test?
All right, so this is actually written in our standard operating procedures. This test is considered potentially destructive. So in order to do this test, I need to inform the contributor that I may be imparting some damage to this firearm in doing so, and that it potentially may not be operable as a result of that testing. So I had to explain that to the contributor and allow them to make an informed decision.
Well,
now, did you tell them they would definitively break the gun, or just that it could potentially
you're
break the
smacking
gun?
with a hammer. Yes,
No, it's a possibility. There's no
ruin it.
way that I could have known for certain that the firearm was going to break.
I mean,
And when you
sure,
conducted
probably
this
did.
accidental discharge test, did you do it according to FBI protocols and procedures?
Yes, I did.
Now, Mr. Ziegler, let me ask you, so even assuming that maybe some internal component of this revolver was modified before you received it in the lab, did the gun fire without a pull of the trigger before you got to that accidental discharge test that broke the gun eventually?
That did not occur during my testing at the lab, no.
At any point before the accidental discharge test, did that gun fire without a pull of the trigger?
Not during my testing.
Was there any indication that the gun did not function as designed before the accidental discharge test?
No, there was nothing odd or noteworthy about this firearm.
As a forensics examiner for the FBI lab, have you had experiences in the past when conducting your scientific testing, evidence you've examined has been either modified in the process of the exam?
Sure, that can happen.
Can you give us an example of that?
Sure. So one example could be if I'm asked to do microscopic comparisons on, say, a fired bullet, and there's also ammunition that's sent in with the case. And initially I would do test fires with laboratory ammunition. However, sometimes it's best, as far as how fired ammunition components are marked. Typically, the best ammunition that you have is going to be the closest to what was used in the actual shooting event. So there may be times where the ammunition from the laboratory is just not reproducing the same as the ammunition in the case. So I may reach out to the case agent and request their permission to consume some of the evidence ammunition to collect additional test fires. So I need their permission to do that because I'm permanently changing those items of evidence. I'm taking a live cartridge, I'm physically shooting them, so I'm detonating the primer, I'm consuming the powder, and I'm forever changing the bullet and the fired cartridge case. So they've submitted ammunition, but they're going to receive a fired bullet and a fired cartridge case in return. So that's just one example where, I may be permanently changing the evidence to do my examination, and I would need their permission in order to do so.
Did you conduct this accidental discharge test to damage this gun?
That's not the goal of the test, no.
May I have a moment, Your Honor, just to review my notes? Now, just the one last question, Mr. Ziegler. The damage, let me show you what's been previously marked. I believe it's State's Exhibit 5. Do you recognize State's Exhibit 5?
Yes, I do.
And what are they, or what is it?
All right, so this is rotated 90 degrees, but this is a photograph that I took, and this was after the accidental discharge testing, after I disassembled it, and this is depicting the parts in the condition after that test, and it's depicting the 2 locations that I found where portions of these parts actually fractured off.
Now, prior to the accidental discharge test, did you have any reason to believe that these parts were in this condition as we see them on Exhibit 5?
No, if they were in this condition, I would not have expected to function correctly.
Are these pieces still available? The ones depicted on Exhibit 5? I mean, or when they left your lab?
Right, I returned everything, you know, it in the correct packaging and all that. So as far as I'm aware, yes.
I have nothing further. Thank you, Mr. Ziegler. I pass the witness.
Cross-exam.
Thank you, Your Honor. Good afternoon, Mr. Ziegler.
Good afternoon.
When you have this case on your desk, you have your case file and your comms log. Those are the 2 large packets of documents that you provided. Is that fair to say?
The one is called the 1A. That's essentially the document repository, but that includes the comm log.
Understood. And that includes the request for lab examination. Fair?
That's true.
Okay. And any other information that you get about the case, you traditionally get from the customer, the person requesting the testing. Fair?
That's typically the way it works, yes.
Wait, did they provide you, they meaning the Santa Fe Police Department or the prosecutors, any additional specifics about replicating what had occurred in real life when you perform these tests?
No, sir.
What about from the media? Did you learn anything about what happened ostensibly before you performed these tests?
The only thing that I was aware of was that the defendant was stating that they did not pull the trigger. I don't know any of the specifics surrounding that event.
Exactly right. And the reason that you went forward with the testing that ended up destroying the gun wasn't to test for malfunctions, right? It was to verify whether the firearm would go off without him pressing the trigger. True?
So my exam is specific to the firearm, not necessarily the defendant and their actions. So my exam is just to determine what are the capabilities of this firearm. Is it possible for this firearm to discharge without pulling the trigger?
Right. So what you are testing for, though, just to be clear, because this word malfunction keeps getting thrown around, what you're testing for is whether or not the firearm will function without pressing the trigger. Fair?
Specifically for the accidental discharge, yes, that is the goal.
Right. And the reason you have to do that is because the physical exam that you spent some time describing and the little test where you just shoot it 12 times in the lab into the water or whatnot, that doesn't answer that question, does it?
Which question is that exactly?
The question of whether the gun is able to fire without pressing the trigger.
Right. Again, I can only tell you about the results of my testing. So initially it functioned normally, and then the accidental discharge testing, you know, beyond that.
Sure, but you wouldn't have suggested and ultimately performed a test that led to the destruction of the firearm if the physical exam and the functional 12 shots into the water were sufficient to answer that question, would you have?
That's a question that's up to the case agent. So I can provide them the information. I could tell them we have the capability to do this examination, but they're the ones that need to make that determination.
The risks of malfunction, I take it that this expression, you're talking about manufacturing defects, modifications of the weapon, or any other damage that could have occurred inside the weapon because of an accident or a drop. Is that what you mean when you say malfunction?
Oh, it could be a variety of things. It could be age. It could be the firearm hasn't been taken care of, so it's rusted and corroded. It could have been laying in the bottom of a lake for the past year. So I know nothing about the history of this gun. So while I'm doing those initial inspections and I'm doing that initial test firing, when I speak about malfunctions, that's what I'm speaking of.
And so when you look at the gun from the outside, you can't always identify if the gun has something wrong with it, can you?
Not visually, no.
Right. And neither could a random actor on a movie set, right? They would have no way to know by looking at a gun, right?
So-
That you're aware of?
Objection, speculation.
Yeah.
Can
If you,
can
if you want to
anyone,
rephrase it, okay, thank you.
is it possible to know just by physically looking at a gun whether or not it's capable of malfunctioning?
I would say no.
And even if you've test fired in your laboratory into the little water bucket a bunch of times in that sort of stabilized environment, just because that works and there's not a catastrophic explosion of the gun or something like that, that doesn't mean that it's impossible that there's a malfunction, does it?
That's correct. I can only tell you that it functioned normally during my testing.
And you didn't at that point, before you went into the accidental testing that led to the destruction of the firearm, you didn't disassemble and look at the inside of the gun, did you?
No, at that point, there was no reason for me to do so.
Well, nobody asked you to.
That's correct, but I also did not see anything that would give me cause to do so.
And not only did you not disassemble it, but you obviously didn't disassemble it and take photographs or video of the inside, true?
Prior to the accidental discharge testing?
Right.
That's correct. I did not do that.
And you have disassembled very similar single action revolvers in your career, have you not?
Yes.
You didn't videotape any of the testing that you have discussed here today, correct?
That's correct. We do not videotape our examinations.
Nor did anybody ask you to videotape your examination, true?
Not in this case.
And I take it the way that you're able to.
That is one spot I do kind of feel like they probably should have done is videotape it, but you know, that's just me. That's just me. That's just how I do.
Recount what you're telling this court is because you took notes and you have worksheets that wrote down what you did and when you did it. Is that fair?
As well as the standard operating procedures, but yes, you are correct.
Well, but there's different points in this case where you weren't sure whether you did the function test and then sought permission from the state's prosecutors to hit the gun with the mallet, or whether you waited to do all of the testing until you got permission. Isn't that fair that you're not sure about the order of this?
No, I disagree with that.
Okay. You're quite confident that you did the visual and functional test before asking for permission before they asked you to do the accidental discharge test. Is that your testimony?
I see your question. No, I can't tell you exactly when I did the function test, if that was before or after that conversation. However, it was before the accidental discharge test.
Right. So I just want to make sure that you are correct. That's what I was getting at. I just want to make sure, that's clear to the court that despite your worksheets and the best of your memory, you don't actually know at what point you asked, or rather they asked you to perform the accidental discharge test. True?
I do have messages in my comm log for the dates that I had those conversations.
Right, but but as you just testified to about a minute ago, you don't know the order of what occurred when, as you sit here, do you?
You specifically asked me if I knew if I function tested it prior to that conversation. So my answer to that is no, but I do know the order that I conducted the examinations in.
Sure, I know that you conducted the functional test prior to the accidental discharge test, because after the accidental discharge test, the gun wouldn't function. Fair?
True.
Now, and the way you do keep track of this, even though you don't.
And remember, guys, we also learned it was just like that little nub on the one piece of the gun they had to replace.
you don't obviously know the exact order compared to the phone call with the prosecutors and the detective or any law enforcement interaction you had, is you take notes as you're doing this. Is that fair?
That's correct.
Okay. And you take in the thousands of exams that you've done. You're a note taker. Fair?
I'm not quite sure how to answer that. We have standardized note sheets that have mandatory fields that I have to populate.
And in all of those examinations, the thousands you've done, the almost decade you've had at the lab, have you ever performed this test on a firearm?
In a actual case?
In an actual case.
This is the first time. First and only.
First and only. And the firearm cannot be tested now in the condition that it came to you in. Fair?
Not in the condition that as a result of my testing. That's true.
And it's not just, you've also said, by the way, that this examination and the report were fairly complex. Is that fair?
I'm not sure where you're getting that from.
Well, I'm asking you. We can refresh your memory, but I'm asking you, was the examination report here fairly complex?
You wouldn't see the word complex anywhere in my report.
Not in your report, but what about in an email transmitting your report? Saying that sorry for the delays with the report, this was fairly complex.
I would have to see that message.
Okay. Do you dispute that the examination and the report were fairly complex?
I'm not sure what you're referring to because that could be speaking to the entirety of the evidence in the case, which was almost 200 items. So yes, I would agree that is a complex case.
The information we've discussed so far, you mentioned on direct examination that there's a manual that comes with this firearm, right?
That's correct.
And this concept of the firearm going off without pressing the trigger is something that's actually discussed in the manual of the firearm. True?
As far as I'm aware, that circumstance is only in that manual with the hammer in one particular setting.
Sure. Thank you for that clarification. But it is true that the manual discusses that this firearm can go off without pulling the trigger. True?
Specifically with the hammer at rest, you are correct.
And you've said this isn't some phenomenon. This is something that's known about the design of these firearms. True?
With the hammer at rest, you are correct.
And well, in the owner's manual also says that a blow to the hammer resulting from a fall dropping of the gun can also cause the gun to discharge. True?
With the hammer at rest, you're correct.
Okay. Or if the hammer slips from the shooter's thumb, right?
I would have to see that line to see what that is referring to.
The manual also says that the person should not even touch the trigger because of this concern and sensitivity of the hammer falling. True?
I would attribute that to general firearms safety.
But it's in this manual. True?
I don't specifically know that.
Objection, Your Honor. Calls for speculation. And if he's referring to the manual, I'd ask that he give Mr. Ziegler an opportunity to review the manual.
I'm not required to do that in cross-examination. He said he reviewed the manual. I'm asking if he knows that.
What was the question that she's saying is speculation?
He's saying, I don't know.
I guess that I just asked him, does the manual say that don't even touch the trigger because the hammer can slip in this firearm? Does the manual say that? Do you know that?
May I answer?
Yes, but you're assuming that he remembers. So
If he doesn't remember, I understand that he may not remember it. It's in his report and it's in the manual. So I'm just asking.
All right. Thank you.
I do not know that the answer to that.
If the trigger is held in, okay, while you're cocking it, and the hammer falls, that can set off this firearm. Isn't that true?
Depending on how far the hammer is cocked, because you have to keep in mind as you're cocking the hammer, the cylinder starts to rotate. So again, depending on the position of the cylinder, If the hammer falls and does not make contact with the primer, it won't fire. However, you are correct. If I hold the trigger in and I cock the hammer and I let it go, you may fire a cartridge in that method.
And the manual says, and you know from your own experience, that you shouldn't load every single chamber on one of these revolvers because it's at risk. Fair?
And that is referring to the hammer being at rest on a loaded chamber. Yes.
Now, I understand you keep saying that, Mr. Ziegler. Were you prepped on that point before you testified here today?
Objection, Your Honor. Argumentative.
I'm allowed to ask a witness what their preparation was on a topic. Were you prepped on that topic before today, Mr. Ziegler?
No, sir. I keep reiterating that because you appear to be insinuating that this firearm can fire with the hammer in every position, and you're using direct quotes from the owner's manual when those quotes refer to a specific hammer setting.
So you weren't, well, I'm asking you a different question now, which is, were you prepped on the issue of whether or not this gun could fire without pulling the trigger before today?
We certainly had trial prep.
Mechanism that we're describing, which you obviously can describe more artfully than me, is not the same on every modern firearm. Not every modern firearm can go off like what we're describing, true?
That is correct.
And there's actually examples of firearms similar to this firearm, right? And you've said you've disassembled very similar single action revolvers before, that if the sear was defective, the gun could accidentally discharge, true?
That depends on many factors.
Sure. I'm just simply asking you, is it possible that if a sear is defective on one of these firearms, it could accidentally discharge? Is that possible?
It is possible, but there are also safety mechanisms within the firearm, to include this firearm, that would prevent that from happening.
And I'm assuming that there's a caveat on all of these answers, but I'm asking just simply, assuming all other caveats, is it possible that, for example, that if the main spring on this firearm was loose, or there's a loose screw, it could accidentally discharge?
I don't agree with the example you just used.
What about if the notches are worn?
That is a possibility.
And we talked about, or you talked, I guess, on direct about the trigger pull. And just to make sure it's clear, at least in my mind in the courts, the trigger and the hammer, they interlock so that if one is moving, it has an impact on the other. Is that fair to say?
That's correct. The hammer has notches and the trigger sits within those notches. So as the hammer is being cocked, the trigger is moving within those notches.
Okay. And you would agree that the trigger weight on this firearm was on the low end of the range of trigger pulls. Fair?
Amongst all firearms?
Amongst all firearms, amongst all single action revolvers, whatever denominator you want to use.
As I testified previously, that I feel this range is in line with this type of firearm. Now, if you compare that to a double action firearm or some completely different firearm, then sure, it is lower than what other firearms are.
Well, let's go to that easier example of a double action revolver, which is what many police departments use. Is that fair?
I don't believe many people use revolvers anymore.
Well, is a double action revolver a firearm that would take 10 to 15 pounds of pull force?
Yes, I agree with those numbers.
And isn't it true that the FBI's own website indicates that the standard trigger pull on a single action revolver is 4 to 6 pounds?
I do not know that.
Okay. Well, while we're continuing this exam, we can pull up and see if it won't refresh your memory. But if it was 4 to 6 pounds, that would be double or triple the pull force required on the gun you examined in this case. True?
It would be approximately double, yes.
And the pull, the amount of trigger pull weight required, you don't know the genesis of that. Assume for the sake of this question that the trigger pull weight was lower on this weapon. You don't know how that occurred, right? You don't know whether that was the manufacturing or somebody altering it and customizing it. True?
Can you rephrase that question? I don't quite understand that.
Yeah,
Sure. While I'm doing that, if we can just show
it's gonna be.
Defense Exhibit 2, just to refresh your recollection to the witness. Are you familiar with this?
I have not seen this before.
Okay.
He's reaching
well,
hard.
maybe,
He's trying.
Because we could.
He's basically articulating, you mess with this gun, you ruined the trigger pull. The trigger pull was really light. You didn't actually test the amount. What was the amount for a gun that's in this measurement? But he's saying all this stuff. It's not working, but he's trying to make the arguments. So he's trying real hard, chat.
Are you familiar with the National Institute of Justice, Advancing Justice Through Science Institute?
Yes.
Okay. And if you look down at trigger pull measurements and you look at the single action revolver, do you see that under typical trigger pulls, it indicates 4 to 6 pounds?
I do see that.
Okay. Does that, do you think that that is a fair number and characterization?
Generally speaking, for single action in general, I would say it's typically between about 2 and 5 pounds.
So you're saying that you disagree with this?
To me, there are many types of single action revolvers. So it is my testimony that this type of revolver, I feel, is in line with the 2 to 2.5 pound force that I measured.
Did you measure the distance that the trigger has to move?
I did not.
Okay. Do you know the distance that the trigger has to move in this firearm?
No, sir, I do not.
That's getting into the engineering of the firearm, dude. Like, and also from what point? The tip, the pivot.
Now, when you do the accidental discharge
The
testing,
travel for the
the
trigger.
goal of that test is to simulate the firearm in a way as if it was bumped or banged into something.
Welcome back.
Isn't that right?
Thank you.
That's correct.
Are you enjoying this?
And
I am.
if you have the ability, the accidental
It's nice being
discharge
a real
test
attorney,
should
isn't
replicate
it?
the
Yeah.
real world situation as closely as possible, right?
So the accidental discharge test, how we do it at my laboratory, it is lined out in the SOP.
Okay, so discharge, you go,
And then
"Ah!"
beyond that,
and
if
is
there
it
is some
accident or
type of
not?
extenuating circumstance that the examiner feels they also need to test, they could then go and do that. However, this is the way that I did it, the method that I use.
And that's going to fail
That's what our SOP dictates.
defense-wise.
Well, when you say dictates, it also provides the examiner some discretion as
Hey,
in
Wouter.
regards to how that is believed to have occurred in the real world, doesn't it?
Again, this is at my laboratory following my SOP. That line, I believe, follows the accidental discharge testing. So it's written as in if there is any additional testing that the examiner feels that they should do.
Right. So, and you've testified previously that if I had a gun leaning against a door and I'm saying that the door opened and the firearm fell, I would try to replicate that situation. Haven't you said that?
That was in regards to, I was being asked about a drop test.
Well, if you knew that that's how a firearm had gone off, in your discretion, wouldn't you have tried to replicate that test?
That's a conversation that I would have with the case agent.
Okay, but you didn't do that in this case, did you?
I received none of that background information, so no, I did not.
But as you did this test, you had no reason to believe that the prop gun on the movie set had been hit with a hammer, did you? You didn't think that that was the real world, correct?
No, sir. I explained the test.
Right. And you didn't believe that the gun had been dropped and fired after being dropped, did you?
I had no background knowledge.
This is Gil.
And there was no reason why, and no reason provided to you by the Santa Fe Police Department why you couldn't do, for example, a push-off test prior to the destructive testing. Nobody gave you a reason why you couldn't do that. True?
That's true. That did not come up in conversation.
No.
And again, just like on your emails to them, your email address, your phone number is there, and you were having communications throughout this case with both the Santa Fe Police Department and the liaison, Special Agent Cortez, true?
Special Agent Cortez was my main point of contact. However, yes, there were some email chains where the detectives were also included on them.
And when you do conduct the test that ends up leading to the gun breaking, what you're trying to see is if the amount of shock or vibration that's being introduced to the firearm is enough energy on that particular firearm to cause it to fire without touching the trigger. Fair?
That's correct.
And you knew from your experience, the manual, the light trigger pull, you didn't think it was impossible that the test would come back showing that this gun was capable of an accidental discharge without a pull, right? If it was impossible for this to happen, you wouldn't have done a test that jeopardized the weapon, would you have?
I'm not quite sure how to answer that. It's not so much as whether I think it's possible or not. It's just, is there an investigative question, and do I have an examination that can assist in answering that question?
Right. But if on the one hand, right, there's no possible value to this test, and on the other hand, the test was going to lead to a likely damaging of the firearm, you wouldn't have conducted the test, would you have? You wouldn't have recommended the test.
That was not my decision.
And did you consider any other tests, like the push test, before embarking on the test that led to the destruction of the firearm?
Objection asked and answered.
I didn't ask that question before.
Yes, you did. Sustain.
Okay. There were 2 times during your testing that this firearm fired without pulling the trigger, as I understand it. Is that fair?
That's correct.
Okay. So why don't you just explain those 2 times to the court, the 2 times that it fired without you pressing
2.0's
the
on
trigger
camera,
anyway?
Sean.
So the first time was when the hammer was at rest on a loaded chamber, and by striking the hammer with a mallet, that provide a sufficient amount of force for the firing pin to detonate that primer. So this is the same issue we keep talking about in the owner's manual. The hammer being at rest on a loaded chamber is inherently dangerous with this type of firearm. So that was an expected result.
Hey, Dolly.
The
did you say
second
something?
time was when the hammer was in the fully cocked position, and I struck it with a mallet.
Dolly, did
The
you say
internal
something?
parts fractured,
Oh,
so that hammer
Athena
fell
was on camera.
and fired the cartridge.
Oh, yes. Yes. No, I know.
didn't know
We
she-
here.
Okay.
After this testing, I think I understand your worksheet to indicate
Yep.
that you
Gino's
continue
there.
testing the firearm at the half-cock notch.
Right. The trigger sear, even though it was broken, it was still engaging at the half cock notch.
You did it again.
So as I described, I had to test all 6 planes, and I had only tested 5 of those when the breakage of the hammer occurred. So I still felt that if it was possible for me, if it was feasible for me to test that 6th plane, which was the bottom, that I should do that in the condition that I was able to.
And when the Santa Fe Police Department and the prosecutorial team gave you the original directive, they didn't tell you, hey, if something goes wrong as you're testing, if some damage occurs, come back to us, check in with us. They didn't give you any limitation like that. Fair?
I don't recall that occurring, no.
So when there was a little bit of damage done to the firearm, or some damage, if you don't like the phrase little, at that point, you did not do anything other than continue to strike the firearm again with a mallet. Fair?
The damage that you're referring to, those internal parts had already fractured at that point.
Well, do you think that the final mallet strike might have done further damage?
Not necessarily.
Well, I know not necessarily, Mr. Ziegler, but it's possible that it did, is it not?
Hello, Brent.
Objection asked and answered.
I don't believe I asked that question either. Isn't it possible, Mr. Ziegler, that the following sixth hammer strike caused additional damage?
I should answer. Yes, that is possible.
When you were striking it with the hammer, you gave some testimony that you could have hit it not straight on, diagonally. Do you remember that testimony you gave on direct?
Yes, just me being a human being, there is the potential that there's some variation there.
But it's fair to say you were trying to hit it straight on in the various planes as indicated in the SOP. Fair?
I was following the SOP. It doesn't necessarily dictate it has to be at exactly 90 degrees for each of those blows. So I followed it to the best of my ability.
But you weren't intentionally striking it diagonally, were you?
Not necessarily, no.
In your amended report, you removed the phrase with a pull of the trigger. With a pull of trigger.
That's correct.
Can you just explain to me why you removed the phrase with a pull of trigger?
Right, so that statement is in regards to the testing I did with the hammer in the quarter and half cock notches. And as I previously spoke about, the design of this firearm allowed me to test the gun with the hammer in those two positions without doing the strikes. So I could test those two positions by actually pulling the trigger, allowing the hammer to fall, and seeing if it was even feasible for the hammer to fire the cartridge in that position. So I actually tested it by pulling the trigger, and in my report, I mistakenly wrote that I tested it without a pull of the trigger. So the end result was the same. It still did not fire, but I felt the description of the process was inaccurate.
And who brought that issue to your attention?
I actually found that issue when I was in preparation for a previous trial.
After you broke the gun, that's when you take it apart for the first time, fair?
Yes.
And there were several parts internally of the gun that were damaged and broken.
That's correct.
And you don't know if the gun had any internal damage before you did the test, correct?
I can't verify that. I can just tell you that it had no effect on the function of it when I received it.
And you don't know if the gun had been modified before you ran that test, correct?
That's true. I do not.
You also noticed that the full cock notch was flatter than the other two notches, fair?
Yes, I did.
It didn't have as much of a claw shape to it, correct?
That is correct.
And you have no way to compare the condition of the prop gun now to the condition before the test, do you?
That's correct. I cannot.
And even after performing the test, you don't know whether it's possible for the gun to have fired without the trigger being pulled, correct?
Can you repeat that?
Sure. You can't say, as you sit here, whether or not it was possible for that gun to have fired without the trigger being pulled.
Right. So I can only testify about my exams. So my results, how it performed in my laboratory.
And you know that outside experts can't examine this firearm in the condition you got it in, correct?
Right. It would be different than the condition that I originally received it.
And you also know, well, let me ask you this. As you looked at the state's Exhibit 5, the broken pieces of the gun, right, you don't even know for sure that you got every single fragment of the broken firearm as you transferred it on, do you?
That is possible. We're talking about very small pieces of metal, very thin pieces of metal. So yes, it's certainly possible they could have fallen out of the gun at the time. They could have fallen out in transport. Again, these are very tiny pieces, so you're correct. It is possible that I was not able to account for everything.
And even under the best of circumstances, you did this in the lab. You can't account when you're doing these tests for every variable that might occur in the real world on a movie set, right?
That's fair, I would say, yes.
How did you inform Detective Hancock of the breaking of the firearm?
I don't specifically recall that.
And from the moment of the destruction of the firearm in 2022, April of 2022, were you ever asked to do any further tests in 2022, 2023, 2024?
In regards to the firearm,
Yes.
there was never nothing was ever submitted. There was never a formal request. No.
And were you ever asked during that period of time to meet with any other firearm expert in this case, or speak with any other firearm expert in this case?
No, sir.
Even up until today?
Just kill us now!
I did have a pretrial where another firearms expert was present. I didn't consult with them regarding my examinations.
Ah!
You just happened to be sitting in the same room during the pretrial?
No, it was virtual.
You just happened to be sitting in the same virtual room during the pretrial?
I'm not sure I understand your question.
Well, you said you weren't consulting with them. What were you doing sitting in the same room with them?
It was preparation for trial, and I believe the prosecution team chose to have individuals there to, I guess, see if what I was saying made sense to other people who had experience with firearms.
And that was the first time they asked to do that in all of 2022, 2023, and 2024 was the first time they asked to do that was this week?
No, sir.
Was this week the first time that you were in a room discussing the facts of this case with another expert witness? Yes or no?
Safa!
Oh, another expert witness? Yes, that was the only time.
Okay. And so I think I won't ask it again. I think it's clear. And
sorry, I thought you said another examiner. That's where my confusion was.
I apologize if it was my fault. That individual that you met with, who was that?
I thought this was going to be a lot better, Charlie. I'm sorry. Because Alec Baldwin's attorneys are really fucking good.
Yeah.
And Kerry Morrissey's fucking awful. So I thought it was going to work out.
I understand it's virtual. I understand you're not calling it a consultation. But while you and another expert witness on this case were in the same virtual room together, who was that other expert witness?
Right. This was a preparation, a pretrial, and it was Mr. Haig.
Who else was present during that?
Miss Johnson and Miss Morrissey.
Anybody else?
Also a representative from my laboratory, OGC, Office of General Counsel.
I see. Ever in any of the thousands of guns that you've ever tested, have you ever had a pretrial meeting with another expert and the prosecutors and somebody from the FBI General Counsel's office all present in a meeting? Has that ever happened before?
To the best of my recollection, no.
And what did you all talk about?
It was essentially preparing for this testimony here.
Can you give me a little bit more information?
It's general trial prep, going over my results, how this process is going to unfold. This is the first time I've done a hearing like this.
Do you have any notes from that meeting?
I did not take notes.
Did you speak to anybody else after the meeting about the meeting?
Probably just some coworkers. That would be it.
Your supervisor?
I share a lab suite with my supervisor, so yes, he was aware of that the meeting occurred.
And was this the meeting? And you know now from meeting with the state's expert, Lucian Haig, that he believes there to have been no purpose for this test, right? You know that, don't you?
I understand.
I'm sorry, objection. He's asking him to comment on what another witness believes. I think that's improper, and it's also calling for Mr. Ziegler to speculate.
I'm asking if you know that from having met with him. I'm not the one that put them together 3 days before his testimony for the first time in 3 years.
Oh.
What was the question?
The question is just that it goes to his state of mind, and it goes to what happened at that meeting 3 days before his testimony and his preparation, that he has been informed that that other expert believes that there was no beneficial purpose to the test that he performed.
No beneficial purpose to the test that Mr. Ziegler performed?
Correct.
All right, I'll allow that question.
Yes, I'm aware that is his opinion.
And you're aware from that meeting that Mr. Haig had issued a report that indicated that he thought that this firearm had been modified in some way outside of the FBI lab. True?
I am aware he's authored a report. I do not know, I haven't read that report, so I don't know the content of that report.
But you understood in that preparatory meeting that that report was an issue that you all needed to discuss. Fair?
I'm aware that he saw marks that he was trying to figure out how to explain. Again, I don't know the content of his report. I don't know what his conclusion was.
Well, you were aware that you were being called in to try to give Mr. Haig more information to deal with the issue of this report. True?
That wasn't necessarily the purpose of that meeting. That is something that occurred as a byproduct of that meeting.
Well, but you didn't need to have that meeting before you testified at Hannah Gutierrez-Reed's trial, did you?
I did not have that meeting.
Right? No prosecutor told you before this trial, we really need to have this meeting with another expert. That's never happened before in your career, right? Nobody said that.
No, but it is customary to have a pretrial meeting with the prosecutor, which this is what that was.
Sure, but it's not only unprecedented, it's not only unusual, but it has never happened in your entire career that at such a pretrial meeting, another expert is present asking questions and bringing up issues about the report that they authored. True?
Objection, Your Honor. That question contains facts, not an evidence, and it assumes speculation. It's asking Mr. Ziegler to speculate on what this other expert believed or what he opined. He's already said he has not read that report.
Overruled.
At the transcript and you looked at the questions, I think it's a natural follow-up question.
Can you repeat your question, please?
I will do my best. I don't have a real-time transcript, so I will do my best. Okay. What I'm asking you is, I understand that it is common to have pretrial preparation with prosecutors. I believe you've already testified that never before in your career have you been brought in to have a pretrial interview where another expert is present asking questions about their report. True?
That's correct.
Okay. And you called it a byproduct of that meeting. One of the topics of importance at this meeting was the report that Mr. Haig issued, in which you understood generally he did not think it was your mallet hammering that caused the modification of the firearm. You knew that and you discussed that at that meeting, sir. True?
Your question is partially incorrect.
Well, why don't you tell me what's correct and then you can tell me what's incorrect.
So you posed that question as though I knew that's what the purpose of this meeting was. I did not know he was going to be a participant in this meeting until the meeting occurred. So no, I didn't know that was going to be a topic of conversation.
And once you were at the meeting, it became a topic of conversation, correct?
That is correct.
Okay. And this is the first time withdrawn. And you understood from this conversation that the questions being posed to you were trying to elicit information that helped explain Mr. Haig's report, which was in sum and substance that the FBI was not how the firearm got modified, but rather that the gun was modified by somebody other than the FBI. You understood that, right?
I can't testify to Mr. Haig's intent or what his goal was.
Okay, but can you understand? I'm asking what you understood, sir. You understood that part of what occurred at that meeting was trying to understand, right? At that meeting, did you demonstrate how you use the mallet?
He asked me a series of questions to gain an understanding of how I conducted that test.
Including a demonstration of how you use the mallet?
I don't believe I physically held my arm up into the air, but I explained it just as I did here today, that I would liken it to in a similar fashion to hitting a nail with a hammer, something to that effect.
And a nail with a hammer, you're trying to hit straight, right?
I suppose so.
And you know that his report, what he found so unusual and why he thought the gun was modified by something other than your test was because the lines were diagonal. True?
He did mention that.
Okay. And that is when the testimony, that is the first time that anyone opposed to you in this entire case for 3 years, well, couldn't you have hit the firearm diagonally, right?
That is the first time I was asked that, yes.
I have no further questions for this witness at this time.
Redirect.
Briefly, Your Honor, thank you. Mr. Ziegler, did the Sheriff's Department initially request the accidental discharge test when they requested testing of this gun?
No, they did not.
Now, as the FBI lab, is it your practice to learn the facts of a case before you conduct any sort of scientific testing?
No, not necessarily. When evidence is submitted, it's typically submitted with a written request. We call that an EC, or an electronic communication. And sometimes that request has background information, sometimes it doesn't. It just depends on the person who is authoring that request. But it's not something I would go and seek out. And most times I would typically prefer to have less information. I'm just asked to examine the evidence, not necessarily take into account external information.
So it's your practice as a scientist to have less information because you want to focus on the evidence. Would that be accurate?
Yes, I believe that's true.
So if this particular gun was able to fire without putting or pulling the trigger, excuse me, would that have been something that you would have noticed during the exam before the accidental discharge test?
Sure. If it was doing that during my function evaluation, yes, I definitely would have noticed that.
Now, Mr. Spiro asked you questions about why you suggested the accidental discharge test. Were you concerned that this gun fired without a pull of the trigger, and is that why you suggested this test?
It's not something that I detected. It's that I had been made aware that statements were being made in national news that the trigger was not pulled. So I felt I had a duty to inform the case agent, this is a test, we have a capability to conduct this examination, explain the test, explain the caveats, and then leave it up to them to decide if they want to pursue that test or not.
Now, you were asked some questions about disassembling this gun. Why didn't you disassemble the gun before the accidental discharge test?
As I've stated before, there was nothing abnormal or out of the ordinary during my function evaluation and test firing. So if something was occurring, if the hammer was falling, or if otherwise maybe the cylinder wasn't aligned, if something was occurring to where this gun was not functioning normally,
at this point.
then yes, I would have wanted to take that apart to try to figure out what was causing this. But because nothing like that happened, I had no reason to disassemble it.
I want to go by
Now, do you always, or is it protocol or SOP for the FBI for you to videotape your exams?
No.
And in this case, you were asked about the sequence of the testing. Was the accidental discharge test the last test you conducted?
On the firearm, yes.
Yes.
Yes, on the firearm. That's what I'm referring to. Okay.
Suffer.
Now, you were also asked about the use of the word complex. Was the exam on the firearm, just the firearm, a complex exam?
Not necessarily. I would say it's routine, and again, for each of these exams, I followed my standard operating procedures. So pertaining to just the firearms exam, as far as the function and those sorts of things, those are fairly routine. So no, I wouldn't necessarily consider that to be complex.
Now, you were asked some questions about the manual for this particular revolver. Does the manual say that the gun can fire without a pull of the trigger if the hammer is in the full cock position?
Not that I'm aware of.
Now, you were asked some questions about the trigger pull and whether or not the trigger pull measurements you obtained were in line with this type of single action revolver. Are they in line with this type of firearm?
Yes, in my opinion, they are.
Now, even if this gun, assuming, let's assume for a minute the defense position, even if this gun had been modified when you received it in the lab, would you have had problems or did you have any problems firing it?
I did not have any problems. So even if the hypothesis is true that, let's say hypothetically, this gun was modified in some fashion, it had no effect on its function in the condition that I received it.
Did it have any effect on the full cock hammer holding without a pull of the trigger?
Not in the condition I received it, no.
Now, you were asked some questions about this meeting where Mr. Hague was present. Did you explain to Mr. Hague how you conducted the accidental discharge test?
Yes.
Now, as an expert witness, is it unusual to discuss or talk to other experts?
As I've stated before, it's not something that I've done in the past, so I don't feel I can really answer if it's typical or not.
To your knowledge, other FBI examiners, have they discussed their results with other experts, even within the FBI?
Sure, definitely within the unit. Yeah, there might be things that come up that you may want someone's opinion on, something of that nature.
May I have a moment, Your Honor?
Yes.
I have nothing further. Thank you, Mr. Ziegler.
Thank you.
All right, this witness is excused. We're going to take a 10-minute bathroom break. We'll be back at 3:50. Okay? Thank you.
Thank you.
What else? Why? Why?
I think they have one more.
Oh, fuck. God damn it. Her eyes are saying, kill me. Yeah, we all are thinking that, guys. All the while watching Legal Eagle. All right. Well, anyways, guys, real quick. Dolly, how are you doing, man?
I
It's been a
am
little
good. How
while.
are you? Yes, it
I'm
has.
doing great. Doing great. Guys, wanted to let you know Hella has a birthday party tomorrow. She's doing a birthday stream tomorrow night at 6:30. And then, obviously here Safe for Days and all that fun stuff. Nick Starro is doing a midsummer show for 7,500 subs. And after we're done here, I am going over there to say hello. And then tonight, Jeff is doing Fuck It. Well, wait, is it this weekend or not? Hold on here. Yes. Fuck It Friday tonight, starting at 8 for Jeff. So busy shit tonight.
Yes.
Yeah. So Dolly, did you, what do you think?
I thought he made some good points, but I don't think the judge will grant it.
Well, I think ultimately when he's making good points, and he's like, well, you did this after. It's like, yeah, I heard about it because it's all over the fucking news.
Yeah.
Like, if there's no way you couldn't hear about Alec Baldwin shooting this lady. Like,
Yeah.
I really wish he would have said something like that. He's like, well, of course I heard something. Your guy fucking shot that lady. Like, I would love that if that was the answer. And it's like, oh, it's like, yeah, you can't do that. Like, bruh. Do you guys saying it's unlikable? You know what, though? Here's the thing. You know what? Bowles is likable. Bowles sucked.
Yeah.
Like, guys, and speaking of that, we got to get through some chats and comments here. Natasha says our audio visual is worse than Mindset's toilet. Yes. Super Friendly Man says maybe I should get himself a charming judge lady. 2.0 is an amazing woman, so I'm all set. I appreciate it though. Barange, yes, he's implying the detective believed that Baldwin never pulled the trigger until pressure from the prosecutor. Yes, but it also became an issue because Baldwin then offered up a story that contradicted the evidence. The only reason why they pressured about the trigger pull is Baldwin himself going out there saying, I never touched the trigger. Well, at that point, you're forcing them to investigate further. So I think ultimately that's going to fuck him in this when it comes to the end of the day. Blade saying this lawyer is forgetting this case may be the only thing on his team of lawyers' plates. No, for a guy like Alex Spiro, dude, he's in like a top 10, like top 5 law firm in the world. This isn't the only thing. This dude is like, think about it, if you've watched Suits, he's like Harvey Specter type thing. He's out there doing shit all day long, all kinds of things. Like, this is not his only client. Hold on here. Let's actually bring it up because we looked him up before. He's actually got a pretty decent history of stuff.
I'm sure he's probably
so
very
he's
expensive.
He's their he's the co-chair of their white collar defense. He does they get hired to do investigations. Like companies will hire them to do internal reviews of like sexual harassment issues, things like that. They do government compliance and enforcement. He's not just a one random guy. Like, they're not paying him just for that. Yeah. I'm sure this helps his billable hours though. But it's practice areas. I mean, this guy does all kinds of. He just he does a lot of shit. So,
but doesn't sound like a lot of criminal though.
Yeah, he does white collar criminal defense practice in his biography. Okay. I mean, he he worked in the Manhattan DA's office. So he's not a rum dum. And I mean, he does a lot of white collar defense, litigation representing plaintiffs, which can mean anything, tax disputes. He deals with the government, SEC defense practice, all kinds of shit. So he's got a lot of involvement. Like, he's pretty good. I mean, it's a good attorney to have.
Yeah.
None of the defense or state like this detective. No, they fucking hate her. I'm sure they all can't fucking stand the woman. But you're stuck with what you got. You're stuck with what you got, Chad. That's not a hair trigger, but it's light. Yeah, Jake, but it's within the range for the revolver. And single actions are going to have a light trigger anyway, so it's well within the mechanically designed range. Otto, am I streaming tomorrow? Yes, I just don't know the time yet. Nick says, how's it ever been answered how a bullet got on the set? Yes. So there weren't enough dummy rounds to be used on set.
Was that officially confirmed?
Oh, I mean, it's not officially confirmed, but it's easy enough to draw the conclusions.
Yeah.
They didn't have enough dummy rounds. They didn't have a lot of money. They had a lot of there was a lot of ammunition available. And in Hannah's hotel room, they found her messing with all that, and then she had
and
she had all the ammo, and she had one of these, a bullet puller. So what was she doing? And they found a bunch of deactivated rounds of ammunition in her room. Okay. So taking live ammunition, smacking it, pulling the bullet apart, pouring out the powder, reseating the bullet, and putting them in the tray for for dummies. Well, what happened? She probably mixed up and put some live ammo in there, and that's how the live ammo got on the set. I mean, that's not at all impossible.
Yeah. And the guy that testified for the state, he was simping over her the entire time she was in New Mexico. And she basically afterwards, she just ignored him and ghosted him.
Oh, you're talking about the guy in the hotel? Yeah. He's like, well, I thought we could hang out more.
Yeah. Yeah, I have their text messages, and he's so simpy.
Oh, I'm sure it's disgusting.
Yeah.
You're saying, is it just unfortunate lighting, or does Spiro have an Australian painter mustache? It's just the lighting. And remember, guys,
is Gurman Donk? Can you hear me?
Their offices. I'm just going
to. We're all known to each other.
I'm just gonna pause it real quick.
It's my understanding that
The way their offices work, like they don't know, like when they're going online or when they do a video hearing, they don't have streaming set up. So they're using the camera on a laptop or something like that. Normally, if they go to court, they go to court. So that's why his shit just looks weird. It's all the lighting's wrong. And Jake is saying part of it will be it's a poorly designed gun. Yeah, but Lucian Haig, the firearms expert, is going to come on and say, no, it's fully operable. It's been sold. It meets the requirements of like it's sold in Europe. And this is a gun that's even legal in California. So
And
it's
it's
not
only-
poorly designed. It's just
And it's
you
only
know,
like 2 years old, right?
the Pieta. Well, the gun
Baldwin.
itself, that gun itself may have only been made within the last 2 years, but
Yeah.
no, Pieta and the
Oh, yeah.
Italians love cowboy guns because it's one of the few things they can own easily. But they also love their spaghetti westerns. So that's why Uberti, Pieta, Pedersoli, those are Italian companies. They make cowboy guns. They're the best. So yeah, it's gonna be if he tries that, Jake, it's getting into products liability, and I think the judge will quash that. But we have some gifts we got to get through real quick. Darcy for 20 memberships.
Wow.
Darcy, thank you so much. Otto gifted 5. Otto, thank you. Vodka Blood gifted 5. Thank you, Vodka Blood. And then Otto's a new member again. Thanks, Otto. And then I Can't Remember has been a member for 1 month. Thank you. And guys, thank you for your support and your generosity. And then Vicky Hatherley for 0.99 of a pound sterling. The King Sterling. Super sticker. Well, thank you, Vicky. Thank you. Was the gun relatively new? Yeah, it wasn't a high use item. It was bought within months of the movie going down. So
Yeah.
yeah. Oh, Otto says I'm green, never gray again. I know. We're genociding the grays here. We're trying to get rid of them. My chat shall be pure with green. Yes, and yep. Hella is 6:30. Yep. Yes. So, anyways, let's get going here. We got the next part of the hearing. Oh my God. Hopefully this is better.
that Mr. Haig is trying to join
Oh, here we go.
the meeting and is being denied. He's coming in by his email address. I don't think his name is on.
Oh my God. Lucian Haig is going to be able to fight back against Spiro. This will be really good, though, chat. Lucian Haig is that old guy that the prosecutor had who
yeah.
talked about the guns. Not the other boomer. Not the other boomer.
That pointed the gun at
whatever
the
the
judge.
information is that you're receiving.
Oh, it's not on screen.
Can you be sure
Not
to let
yet.
him in?
We'll get it over.
Okay.
Yep.
Can you see? I see your text. Can you see if that's him? Just ask if he's Luke Haig.
Luke. Hella says you're gonna come, right? Yes, Hella, I'm gonna come.
Do not come. Do not come. What the hell's going on now?
Just send me a reminder before it starts. So
Thank you.
2.0, I
Appreciate you,
don't forget.
Haven.
Oh, somebody's saying your stream is set for 6:30 a.m. on the 23rd. Hella.
I just DM'd Hella about that.
Oh, Hella, you
She's
just said that was your doppelganger, Hella. Actually, if you think about it, that was your doppelganger there. Yeah.
Oh, wow.
There you go, Hella. You're fucking Hella. Do you have a
You're simping for yourself, Hella.
Hella? Where's your answer the question, Hella? Why do you have a cousin looks like you?
Can you hear me?
Now I can.
So we're
Oh my God! Is that his? Hold on.
Mr. Haig, can you hear me?
Now I can.
Now I can.
That's awesome. That is a dope studio. That's a dope
Oh, wow.
office. Nice.
That is
Nice.
based.
Yeah.
So we're on a bathroom break. So if you could just say.
Look at that shit. Look at that guy's studio. Look at that, chat. Oh. He's got a rolling block. He's got a flintlock. It looks like he's got a bit of a that actually might be a flintlock as well, or a snap-ons. It's got a lever action. Then he's got a revolver sitting on the back. He's got an AK. I've actually seen these. These are pretty cool pictures. That's it. He's probably got like the original like posters from Russia for shit like that. But you could buy reproductions of these. They're pretty cool actually. But this guy's mega based.
Oh yeah.
Yeah, there's no Joker poster. He's not a real expert. Yeah, who's simping now? I'm not simping for the man. I want the shit in his office.
All right, counsel, we're back.
Here says, I'm definitely going to come. Yes.
Next witness.
Hella says future problems.
Well, wait a second. Let's make sure we have the court. Oh, there you are. Okay. All right.
Yeah, hella Fish Lips was on earlier. Detective Fish Lips.
Ms. Johnson.
All by yourself.
Oh, no, I'm sorry, Your Honor, it's me.
Oh, okay.
I was just waiting for counsel to turn their videos on.
Yes.
Sometimes I can't see everyone. The state.
I don't think, are they on? I don't see them.
No, they're out smoking a J. Sparking one up.
Bueller.
I think we're waiting for Mr. Nikas.
Whoa. Oh.
All right. Thank you. Go ahead. Let me call him and I'll swear him in.
The state calls Lucian Haig.
All right. Please raise your right hand. Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you.
Mr. Haig, for the record, would you please go ahead and state your full name and spell your first and last name?
Lucian Conrad Haig, LucienHaag.
And what is your occupation, sir?
I'm self-employed with my own forensic consulting firm, Forensic Science Services, in Carefree, Arizona.
What is it that you do?
Oh, he's near me.
My specialty has to do with firearms evidence, basic firearms identification.
Can you move up closer to the microphone, sir? I think you need to move up closer to the microphone.
All right. My work involves examining firearms and firearms evidence with a special emphasis on the reconstructive aspects of shootings.
Can you tell us what a criminalist is?
Yes, a criminalist covers the basic work of people in a crime laboratory. Physical scientist who's involved with the testing and analysis of physical evidence, of course, firearms, tool marks, drugs, narcotics, blood stains, trace evidence, and so on.
He's going to testify.
Would you describe?
Actually, firearms examination is a subset.
What'd you say,
out
Golly?
of criminalistic.
He's going to testify Nick's trial.
So would you describe yourself as a criminalist?
Yes, I would.
And how long have you been employed as a criminalist?
You should go. You see if
For
he'll do a
about
stream with
57
you.
years now.
You're like, you know.
And
We hang
I
out?
think you mentioned that you have your own independent consulting firm. Is that
He doesn't
correct?
testify from home,
That's
guys.
true.
And for whom did you work before you started your own independent consulting firm?
I worked for the city of Phoenix in the police crime laboratory, starting there in 1965 as an entry-level criminalist. I became the technical director of the laboratory, so I
God, he's
supervised all the various units,
He's
trained
been
others
around, man.
in the
Jesus.
various units of the crime laboratory.
He's like me and
when I
Sam
elected
Cole
to leave
originally
there
did
in
in the
March of
drafting room together.
1982.
Yeah.
That's when my part-time consulting firm became my full-time employer.
And what were your specific duties there at the City of Phoenix Police Crime Laboratory?
Well, in the early years, through the 60s and 70s, I worked in the various areas of the laboratory: trace evidence, blood alcohol, comparative analysis, firearms unit. But my real interest and passion was the ballistics and firearms unit. So when I was a technical director, I was now training other people in all of these various units. But my main focus, again, had to do with not only basic firearms evidence, but I've said it once before, the reconstructive aspects, things like a distance determination, whether a bullet went through an intermediate target, areas that deal with how did the event occur or not.
Does your experience include firearms examination?
Yes, of course. That's the basic function in the firearms unit. I had specialized training in that subject after I left Cal Berkeley with my chemistry degree, a 2-year program in criminalistics at Cal State Long Beach, taught by the primary firearms examiner for the city of Los Angeles crime lab.
And do you have extensive experience in firearms forensic testing, or rather forensic testing of firearms?
Yes, as I said, I've been doing that for over half a century.
Now, so it's my understanding that when you left the Phoenix Crime Lab in 1982, that's when your part-time consulting firm became full-time?
That's correct.
Do you continue to work full-time?
I'm trying to retire. I think I'm flunking retirement, but I've cut way back. I just have 5 or 6 cases, a lot of projects, but not casework. I think that's now limited down to 5 or 6 active cases.
Okay, great. Could you hang on just a second. Have you conducted research in the area of criminalistics?
Yes, I have.
Criminalistics.
Have you written any articles or given presentations on the subject of firearms evidence and examinations?
Yes, a large number of them over the last almost 50 years. I think they number almost 200 now. Presentations before peer-reviewed groups. Many of those have become publications, and I've ultimately written a textbook on shooting incident reconstruction.
Yes, Katie, I'm
co-authored
gonna.
by my
You know what? I
youngest son,
probably will
Michael
get fucking
Haig.
banned for this.
Have you conducted seminars on the subject of firearms evidence and examination on more than one occasion?
Yes, many times.
Have you ever taught college-level courses in your field?
Yes, while I was at the city of Phoenix, they allowed me to adjust my work schedule so I could teach a 2-semester course in criminal. I did that for about 11 years at 2 community colleges here in the state of Arizona. I was certified in criminalistics as a criminalistics instructor by the state of Arizona.
And did the criminalistics courses include firearms evidence and examinations?
Yes, they did.
Are you a member of any professional associations or societies?
Yes, a number of them, starting closest to home, the California Association of Criminalists. I'm a regular member of that organization and have been for many years.
Being a criminalist, you have
The
to know how
American
to commit
Academy
crimes.
of Forensic Sciences covers the
You must
United
know and love
States
crime.
and a few foreign countries. And of course, the most important one is the Association of Firearm and Tool Mark Examiners, often referred to as AFTE. That is the worldwide organization of people that, almost all of which, with few exceptions, I being one of them, work in government crime laboratories in the firearms unit in this country and as many as 40 other industrialized countries.
In addition to testing and examining firearms, are you also personally familiar with firearms?
Yes, I am. I've been a shooter since childhood. I always had an interest in firearms and how they work. I was a competitive shooter when I was in high school. My high school actually had a rifle team. I competed in shooting events when I moved to Arizona. So yes, I find them interesting, and they're also, of course, the subject of my profession.
Have you frequently been called to testify as an expert in court as a result of the various types of testing you've carried out on firearms and firearms-related evidence?
Many times.
Give us an estimate of how many times.
I was there
Well, I
at the
don't
first
keep
Supreme
hard
Court
statistics,
hearing.
but certainly I'm sure over the last 50 years or so, it's over 1,000 occasions.
Yes.
A lot more when I was in the crime laboratory because of
I
course,
opposed
those are
Brown
criminal
getting a Board of
cases, so
Education.
I could easily be in court once or twice a week for one kind of hearing or other or actual trial.
You
It's
made
much
sure
more
they included the
infrequent now.
Second Amendment
More
and the
common
Constitution.
than depositions,
Yes.
as much of my work is civil.
My
Has
friend
to do
Alex,
with
you may have heard
firearm
of him.
misadventures,
Last name Hamilton.
accidents, so on.
Have you been called by both the prosecution and the defense?
Yes, I have.
And how did you become involved in this case?
My recollection was a little over a year ago, a phone call from you.
And did you agree to consult and perform some examinations and some testing in this case?
Yes, I did.
So let's start at the beginning. Tell us, if you can kind of walk us through the initial examination that you did, and any testing that you did, and the evidence. And specifically, I know that you took a lot of firearms into evidence. I want to speak with you today specifically regarding the firearm that you understand to have been the firearm that was in Mr. Baldwin's possession.
Yes, well, my work began with, as they all do, getting an understanding of what the issues were in the case. So I was reading a lot of documents, looking at interviews, both audio and transcribed interviews of a number of individuals, including Mr. Baldwin, a man named Seth Kenny, the armorer, other people who were present on the scene, looking at the sheriff's reports of what sort of evidence was impounded. And of course, we all know the physical evidence ultimately went to the FBI laboratory. So I needed to see, and ultimately was provided, the examiner's, not only his reports, but his worksheets and notes. So every investigation, at least my approach, is to learn everything I can about the issues in the case, what people collected, what they state they saw. Not that it's evidence, but it's a starting point to decide what kind of tests and in what order are such tests appropriate. Ultimately, in July of last year, just a couple of days, as I recall, before the 4th of July, I had sent a list of all the things I wanted to see. It was pretty extensive, of items that were impounded, and of course included the what I'll call the evidence Pietta revolver. It's easily distinguishable from all the other prop guns of the same design and caliber because it's got a nickel-plated hammer. The ammunition, now there's basically 3 types of ammunition in this case. They're blanks. These are cartridges that can't hold.
Mr. Haig, I'm going to stop you right there. Go ahead and skip the ammunition because I don't think that's relevant to this motion. So we'll save some time there. So I understand that you examined the ammunition. So specifically with regard to the Pietta, take us through what you did with that gun.
Yes, well, when my son and I received it in a pistol box, evidence type box, it was partially disassembled. There were some broken parts, a severely damaged hammer, a broken trigger, the tip of which is called a sear, and a thing, the company calls it a bolt. It's also known as a cylinder stop latch. So we photographed the gun as found, ultimately replaced the broken parts after they were thoroughly examined and photographed with comparable parts that were functionally, measurably equivalent. And by that I mean a hammer, a trigger with an operating sear, and a cylinder stop latch. As soon as we did that, the gun was functional.
So can you specifically explain to the court exactly what parts of the gun were damaged?
Yes. 3 parts. This is a very simple design. There's a hammer that has to be manually retracted with the thumb. So that's a volitional, purposeful act. Inside of the gun is a portion of the trigger that can't be seen until you disassemble it. And that's called the sear, S-E-A-R. It's the top of the trigger. And finally, the third part that was broken is called a bolt or a cylinder stop latch. This is a small component that, as the cylinder in this revolver rotates into position as you cock the hammer, it locks the cylinder in alignment with the axis of the barrel. So those 3 parts were broken, and in the case of the trigger, truly broken, snapped, and the hammer just the full cock step or notch. There are 3 notches on the hammer. The full cock notch was essentially obliterated.
I want to use a demonstrative aid just so that we can see exactly
we're not. Oh, hold on. Scott.
those parts and how those parts interact. This is not something I'm asking to have admitted into evidence. It's just a demonstrative aid for the court.
I think, no, Carrie, is it among the things that you sent over yesterday or last night or yesterday?
All right, Dolly, we're gonna
Do I have it?
here.
No, it's a
What?
demonstrative aid. I
yeah.
sent you exhibits.
We're not playing with
Okay.
it. We're not letting them show a real gun.
I guess I don't know if I have an objection without seeing it.
Well, the funny thing is the court stream will get taken down too.
Your Honor, it's a video that shows the working of a single action Army revolver, and it's an X-ray version, so it shows you all of the internal parts that you can't see from the outside. That's it.
Okay, that's
Carrie, is it Grand Jury 31?
Yes.
Yeah, no objection. You did send it.
Oh, I did. Sorry. Thank you.
Okay, let's take a look.
Even when she says sorry, she sounds like a fucking asshole. She's like, "Oh, I did send it. Sorry, thank you." It's like, "Oh, okay, I'm sorry. I did send it. Okay, cool." God, everything. It's like, you saved my life. Thank you. It's like she sounded like an asshole if you pulled her out of a burning car.
Let me see if I can get it to present.
Let's see what it is, chat. We'll see what it is.
Can you see that?
Yeah, we're gonna hold.
I'm gonna jump up here. I'm gonna get us to a certain spot that I think might be helpful.
Okay, this'll probably be okay.
Mr. Haig, can you see my cursor?
I swear to God,
I
if I
don't
get
see your
smoked,
oh
I'm
yes,
gonna lose
okay,
my mind.
I see it.
Down here on the trigger?
Oh, no, I think I'm looking at my cursor. Yes. I don't see
Boomer.
your cursor. Oh,
Can
now
we-
I do. Now I do. It's black. I was looking for a white cursor.
Okay, I apologize. And
sir.
I'll try to keep it off the black mark. Is that
I
the
don't
trigger
like
of
the
the gun
black
there?
Yes.
Cursors.
So I know that you can't see it, but what's this thing that we see here? If you can see my cursor, what's this thing above the hammer that we can see?
Yes, I'm not sure. It looks like it's a part of the mechanism to operate the cylinder stop latch, which if you come up just a little further there, that's the cylinder stop latch, and those little ears on it were broken.
Are you talking about these little ears right here?
Yes, there are actually 2 of them with an opening between them, but one of them was broken off on the evidence item.
So when you say that there's 2 of these little ears, let me stop real quick. Is this big piece of metal here that my cursor's on, is that the hammer?
Yes, it is.
And what's this here?
The firing pin.
So these ears here that you're referring to, does one go on one side of the hammer and one goes on the other side of the hammer?
Yes.
And what's this here?
It looks like a spring, a stop or a spring.
Does it be better if they were
to
color
limit
coded
the
parts?
movement.
The movement of what?
The cylinder stop latch.
Okay, thank you. I'm going to jump ahead. Can you see that?
Yes, I can.
Can you tell us what we are looking at right here? Do you see my cursor?
Yes. This shows an internal view of the trigger and hammer at the full forward or rest position. The top of that trigger is the sear, and it is not engaged in any notch. It's just resting against the working surface of the hammer. So that hammer is fully forward. If we had a live cartridge in the gun, the firing pin would be resting against the primer of a live cartridge, an unsafe condition.
So when you say that's the position that we're in right now, is this our firing pin right here where my cursor is?
Yes, it is.
And so would that firing pin in this position be resting on a bullet if there was a bullet in that chamber?
Or more correctly, be resting on the primer of a cartridge. The bullet is up in the front end of the cartridge.
Understood. I apologize for my mistaken terminology. So this
Like
here
you fucking
is the sear,
casual.
is that correct?
Yes.
And tell us a little bit about these notches that we can see here on the hammer.
Right. If the hammer were to be retracted just about a quarter of an inch, that sear tip on the trigger would snap into that notch that's right next to it in this view. That's the safety notch, sometimes called the quarter cock notch. Now the hammer and firing pin cannot reach the cartridge. If we go to the next notch, basically just opposite the hole in the pivot hole in the hammer, that's the half cock or loading notch. In that position, the hammer will be halfway back. The cylinder will now be free to rotate, so you can spin the cylinder, whereas before you could not because the stop latch we previously talked about is holding it in place. And finally, this one's hard to see because it's really just a step, but much further down at about about the 7 o'clock position, that's the full cock. I like to call it a step, but it's often called a notch. So imagine retracting
Hey, Ron,
that
check
hammer.
this link.
Trigger
Here you
just
go.
rotates.
It should show up there.
Backward. It's
We're on
going
Twitter
to
still.
rest. The sear is going to rest on that step with the hammer fully cocked. So when the trigger is pulled, the hammer, driven by a spring that we can see over there in the grip, a flat spring, the hammer is driven forward and goes all the way down. And if there's a live round in the chamber, fires the gun.
Okay, so why don't I'm going to go ahead and play this, and let's just walk through it. Is that what you're talking about right there?
Yes, the person has now pulled the hammer back to the full cock position, and it will stay there in a properly operating gun until the trigger is pulled.
It's like the Freebird starts playing.
So when we're in this position right here, is that the quarter cock position? If those two were engaged, they're not totally engaged in this video?
Yes, they are not engaged, but if the trigger rotated so that the sear, the top part, is deep in that notch, you would be in the quarter cock or so-called safety position. That would be the loading position. And again, the sear would be deeply into that notch. It's truly a notch. And the cylinder would now be capable of being rotated by the hand of the user to rotate it around and either take fired cartridges out or put live cartridges in.
So in this position, that's where the cylinder spins.
I'm sorry, could you ask the question again?
When the hammer is in this position, you can move the cylinder.
Yes, you just take your fingers and rotate it.
Just take
clockwise.
your fingers. Just right up in there with your fingers.
And then I think you indicated that this is our full cock position here, and this is the position when the gun is ready to fire. Is that right?
Right. And the stop latch is sort of ghosted in this image.
It almost looks like we're talking with
popped up, and it's
Lucian
in one
Haig
of those
here in
notches
chat,
you can
guys.
see on the cylinder, locking it in place so it's aligned with the axis of the barrel.
Okay. Thank you. Let me move to a couple of exhibits.
Speaking of T, you had an interesting question there.
Bear with me.
Yes, you can go to the dragonstreasure.com, a haven for teen and anime lovers. You can use a promo code criminal, and you can get a little bit off there.
I'm sorry,
Pieces
I'm
be
not
cock on
as
YouTube? I
proficient
think
with
so.
presenting when I'm on Google Meets. I'm going to show you what's been marked as States Exhibit 35. Do you see this photograph, sir?
Yes, I
Do you
do.
see this? Okay. Can you explain to us what we're looking at here?
The one you had your cursor on just a moment ago, the one that's silver colored with really fine lines on it. No, the one to the right. That's,
Hang on, let me get right here.
nope, move it over. There you go. Yeah, that's the working surface of one of the triggers from one of these guns. That's the way they would look when they come from the manufacturer. Those are finishing marks, very fine grinding marks on the working surface. So you're looking right down on the top of the trigger. The one on the left that looks sort of golden.
Let me stop you right there. Are we looking at the top of the sear?
Yes,
Okay, thank you. And what's the one on the left?
that's the severely damaged working surface of the broken off sear from the evidence revolver.
Can you explain to us in real life, because when we're looking at these photos, can we get an idea of this part right here of the gun, the sear, either one of these parts, how big are they?
I would say about 1/8 of an inch from top to bottom as you view these. Think of it like you're looking down on the tip of a fairly
Just a
small
tip?
screwdriver, looking right down on the working surface of a screwdriver. Same idea.
And approximately how wide would this be?
Probably a couple hundredths of an inch, 0.02, 0.03.
Was this photograph taken using any special equipment that shows all of these details?
Yes, that's what's called a stereo zoom microscope, where we could put a camera onto the microscope, focus it, and take the pictures.
So you are actually using a microscope to look at these very fine marks. They are that small.
Yes,
Very fine marks on both sides.
and lighting is, you have to bring in lighting from the side to highlight them.
Okay.
They're using Google Meet. Sarah Boone is now a fan of excited utterance? What? What you talking about?
Pardon me.
Come on, Carrie, quit boomering. It's a Friday. You're booming your way into the weekend, honey. Oh God, it's so nasty outside. It's like 90 degrees. I just opened the
Mr.
window.
Haig, I just want to let's cut to the chase and let's talk briefly about these markings on the very tip of that sear that you described to be about as big as the tip-top surface of a flathead screwdriver. Is that right?
And a small one at that.
Okay. Do those, in your opinion, would markings like that, those microscopic marks that you see on the tip of that very, very small piece of metal, would they affect the functionality of the gun at all?
Well, the ones from the manufacturer, of course, the answer is no. All the triggers that we looked at typically have those very fine, perfectly parallel striae. The evidence one, on the other hand, if it affected it at all, it stands to make what shooters call a creepy trigger. It would grate. But those marks aren't from a trigger job or from the manufacturer. It's damage.
Okay. So let's back up. in terms of all of the things that you've reviewed,
Sarah.
did you review videos from the filming of the movie Rust as a part in order to form conclusions in this case?
That was a part of my work, and I think I've at this point viewed more than 20 videos of Mr. Baldwin handling the evidence firearm.
And did you also review all of the FBI report in this case?
Yes, I did.
And based on, let me ask you this, have you come across anything in the videos that you've seen or in the FBI report or any of the transcripts of the testimony that you've reviewed? Have you come across anything that would indicate that this gun malfunctioned?
No, I have not.
So I want to go kind of in chronological order, and I want to go through some of the videos that you've watched of Mr. Baldwin on the set of Rust. Bear with me here, because what happens to these exhibits is when they sit too long, I can no longer access them. Even though they are right in front of me, I can't get them to display. So,
Boomer.
This is just awful. Oh my God.
Mr. Haig, did you review a series of videos that from the filming of Rust that were recorded on October 16th of 2021?
I believe so. I didn't write the dates down, but if it's something you sent me, I looked at it extensively.
Well, along with those videos, were you provided the dates?
I believe so.
Okay.
Your Honor, I'm going to object to the evidence, the videos as not relevant to this inquiry about the condition of the gun.
Hey, Hella, I know you're there, but I know it's early, so if you want to join.
Do you want my response?
She just joined.
Yes, please.
Well, the
she was on screen.
defense's entire
Well, that's what I'm saying,
position
like,
has been
you can do that to me, man.
the gun wasn't functioning
Meet your
properly.
cousin on there.
There had to have been something wrong with it. That was the cross-examination of Mr. Ziegler. I am here to show you numerous videos of the gun functioning exactly the way it should. And we have an expert here who's looked at the videos, and he can tell you this is exactly how it's supposed to work.
All right. Were you not provided these, Ms. Clark?
She was.
We were provided videos, Your Honor. I'm not sure which one she's showing, and it seems like an awful lot of video footage for something that I think is tangentially relevant at best.
Yeah.
All right. Overruled. Thank you.
Ooh. Sorry, Hella.
Mr. Haig, can you see that video?
Yes, I can.
Does this look like a video that you've watched at my request?
Yes.
Little close.
Hey, Mark.
Yeah, well, I'm gonna run in.
No, just,
Yeah?
Just.
When you drop your arm, that means he's 10 feet away. I can't see how close he is, but I want to be almost up by the time he gets there.
No, I'm gonna go into this.
yeah.
Well, 'cause let me show you something. Hold on. Step back to your original mark. So 1,000, 2, 1,000, 3, I'm getting up.
Right.
Then when he drops his arm, Halyna get out, he drops his arm, that means Brady's close. I'm gonna start to really get up.
Okay.
Okay.
Here we go, let's try it.
And everyone
Rolling, rolling.
doesn't need to be right here, like in the path of the gun. Could you please move?
Just want to be over him a little bit so I can see it.
Because I want to put in
Is that a quarter load?
Is that Hannah?
Now, wait a second. If I'm gonna shoot right,
Yes.
you want to go on the other side of the camera?
You
I don't want to
can
shoot
hear it
toward you.
back there.
Okay, right here. Okay, I'm gonna shoot close to you. Here we go.
Okay.
Here we go. Ready. And action. Go!
Look how timid she sounded.
You wouldn't shoot like that back then, Alec.
That's right. Motherfucker.
Mr. Haig, in this video, can you see Mr. Baldwin firing his gun?
Yes, handling it earlier and then ultimately firing it multiple times.
Given your vast experience with firearms, and to be clear, you also have considerable experience with single action army revolvers. Is that right?
Hella, you don't show up to the bird feeding cam? I've been there before.
Shame, hella shame.
Especially because doesn't she have a bird? I thought Hella
No.
had a bird. Oh, too.
She just has a lot of birds outside.
Yeah. Is this hearing live? Yes, it's, remember, guys, it's 2 hours in the it's 2 hours behind. It's only 4:30 there. Oh my God, it's 6:30. Alec Baldwin's eating my fucking weekend up.
Yes, I do.
I did not
Is there
think it was gonna
anything
go all
about what
day.
you saw that causes you
Yeah.
to feel like the gun was malfunctioning or not working properly?
No, not at all.
In everything that you've read about the case, the hundreds of pages of police reports and transcripts, have you ever seen anyone read anywhere where anyone said this gun wasn't functioning properly?
I think I need to hear the question again. I missed the first part of it. Sorry.
In the documents that you reviewed, police reports, transcripts of witness testimony, did you see anything where anyone claimed that the gun wasn't working properly?
No, I did not.
And that's Hannah Gutierrez's statements, right?
I'm sorry?
Did you review Hannah Gutierrez's statements?
Yes, I'm sorry. Her statement and interview,
Did you review Mr. Baldwin's statements?
several of them are interviews as well.
Did you review any statements from Mr. Halls, the assistant director?
At some point I did, yes.
Any of those people ever say this gun had a problem or wasn't functioning properly?
No.
Let me see if it will let me switch easily. So I just showed you what was marked as State's Exhibit 8.
I am. Oh my God. Oh.
I'm going to now show you State's Exhibit 9. Can you see that?
I can, yes.
While I understand that it looks
Oh my
at
God,
the
Val,
beginning
we
to
saw
be
his
the
cock.
exact same as the video we just watched,
You missed it.
I'm going to play it.
I said, oh my
okay?
God, his cock slipped
right.
out. Baldwin's cock slipped out.
Oh,
Take your only mark. And set, ready, and action. Grab the rifle.
Okay.
Any problems you see there with the way that gun functioned?
No.
Nope. He's out of shit. Well, to be fair, he's in his 60s, so I mean, I'll give him that. I'm not going to
I'm
make
going to show
fun
you
of him for
State's
that being a
Exhibit
fat
10.
guy, so.
Yeah, and I'm just going to object again. It's cumulative. We've been at this for a long time, and these exhibits are all going to show the same thing unless I'm very much mistaken.
and I want to go home.
Well, the
Are
problem,
you
Judge,
agreeing that the
is
gun
that
works then?
the entire claim that is the basis of this motion is that the gun was modified prior to it going to the FBI. Now, the only way that that works for the defendant's motion is if any modification, no matter how slight, affected the functionality of the gun. That's what the entire motion's about. So if the defendant wants to stipulate that at no time during the filming of the movie the gun ever malfunctioned, I don't have to show these videos.
Overruled.
Hey, Mark. So, Joe? Yeah. I'm not gonna open the door until the first squib hits the door. Right. So door, squib hits, open door, another squib while it's opening, and then I charge out. Ready? Set. Stand by, let Joe get to the monitor. All right, set. Video, ready, and action.
Okay, why wasn't he shooting with the rifle instead? That'd be more effective in that setting. I mean, just bow, bow, bow.
Mr. Haig, did you get a better view in State's Exhibit
Fucking run that
10
thing.
Of Mr.
Run that,
Baldwin and his
Henry.
gun?
Yes, actually, each one of them has some value, but this one you can see the hammer being cocked in one of the discharge scenes, letting go of the hammer. It does not fall from the full cock, and then he fires it with a normal trigger pull.
Any functionality problems that you can tell?
No, there are none.
That gun works exactly as it should, is that right?
As intended and as designed by the manufacturer.
You can say it appears. You can't say it with 100% certainty, though.
State's Exhibit 11.
Hey, Mark. I don't know, I'm opening around. Here. Take Mark.
There's speed loaders for lever action rifles.
You good? And set.
Well, it depends if they have a
Ready.
King's Gate or not.
And
And Henry wouldn't.
We're gonna get a Rust 2.
I don't know. Yeah, still. Charlie,
Mr.
because
Haig,
the movie, I
State's
know.
Exhibit
you used to be
11. Any
Henry,
problems
you
with
used
the
to be,
functionality
boom,
of that
ka-chunk,
gun?
Bam, ka-chunk,
No.
bam, ka-chunk. You'd be laying down hate with that bitch. Also, what? Why do my hands look what? Oh, they're like look super white. Like, I don't hear anything because we don't get the sound, guys. Remember, it's a movie production, so all that sound gets added in later. There's only so much sound you get, but you get the footage. You know, for those of you, you know, that's why we're not getting it.
State's Exhibit 12.
This is organic stuff taken right off the cameras.
Hey, Mark. Take Mark.
Yeah.
Set. Ready. And action. One more. I forgot the recoil stuff. No, right away. Let's reload. Here we go. So, Halyna. Hi.
Oh, there's Hannah. What a cutie.
Yeah,
Mr. Haig,
Anna and Halyna.
any malfunction you can see in State's Exhibit 12?
No.
Run away from the Rust-Oleum army. Harlan Rust. And his enemy
Your Honor,
sandpaper.
we'd stipulate that these can be admissible for the hearing and that these videos will show proper functioning of the firearm in an effort to expedite this for purposes of this hearing.
How many more? Which ones? 13 through what?
What are you going to argue then? How are you going to argue
This
the gun got
is, Judge,
fucked with?
it's going to be 13 through
Why does he throw his arm in the air after each shot? Because he's like
13 through 32.
He's probably tipping the gun back to cock the hammer.
All right, so the defense is stipulating that 13 through 32 show the functioning, what's
Sage went
the
for this
proper
one. Oh, yeah.
terminology? Functioning of the gun, but
It
what's
will not show any malfunction of the firearm in those exhibits that the state has submitted for purposes of this hearing, and that Mr. Haig will say that. We will stipulate that Mr. Haig will say that they do not show any malfunction of the firearm.
I don't think that's Judge. I don't think that's good enough. They need to stipulate Not that he will say that there isn't a malfunction with the firearm, but they need to say that there is not, in fact, a malfunction of the firearm in any of these videos.
Okay, so Your Honor, our stipulation is that he will say that because this is an examination of Mr. Haig, and my understanding is what we're interested in is what he will testify to about these videos. But otherwise, if the state wants to play them all and the court wants to watch them all, we withdraw our.
I don't want to watch them all. I don't want to watch that many more exhibits. So
Neither do I.
Fight over this. Is it that he can testify that the gun was functional for 13 and 32?
Okay, he can testify that the gun was functional for 13 and 32. Mr. Haig, have you viewed many videos from the filming of the set of Rust?
At least 20.
Film and Rust.
Have you seen any that cause you any concern about the functionality of the gun?
No.
No.
All right.
No. Okay, I'll move on, Judge.
She has no chill. It's 4:30 in the afternoon on a Friday. She's like, I want to fucking go home.
This hearing was supposed to be short.
Yeah, it's 4:30.
And they haven't even done cross yet.
Yeah. She's fucking pissed.
It's not like
She's
it's a trial.
It's not just her. It's court staff. Everybody else has to be here because of her. This
stenographer.
No, because it's probably being audio recorded. They're not going to do that.
Okay.
4:30 on a Friday is late for government employees.
Mr. Haig,
hi,
if you
Hella.
recall, just as a point of clarification, two or more of the videos that you reviewed, were they actually recorded on October 21st?
I believe so. They're in the mock church.
And with those videos that were recorded on October 21st, no problem with the functionality of the gun, right?
None that I could see.
Now, sir, when you reviewed the FBI report in this case and you saw that there was accidental discharge testing that took place, did you have any concerns about that testing that we understand ultimately damaged the gun?
Yes, I would say I did.
Tell us about that.
Well, fortunately, it comes at the end of a long list of tests, but it looks like it arose because Mr. Ziegler's understanding was this was an accidental discharge. An accident, as I've defined it in my book, means there's something wrong with the gun, not the user. So he pressed on with their SOP, their protocol, their standard operating procedure, to look into, to evaluate an accidental discharge again, meaning there's something wrong with the gun. And that procedure involved some pretty aggressive, well, very aggressive final testing by delivering an impact to the cocked hammer with a rawhide mallet, multiple blows. And as we probably all know, that caused a failure of the sear and the hammer.
Do you agree, however, that testing was done pursuant to FBI procedures and protocols?
Yes, it was. If there's a suggestion or an indication of an accidental discharge.
And do you agree that experts may disagree in terms of what kind of testing they think is necessary to ascertain an opinion?
You can, or I have found differences in an approach to solving a question in laboratories, including my own.
Oh, did he get muted?
Now, let me show you what has been marked as.
Hello.
Oh, I bumped Dolly.
Did you ditch Dolly?
I think
All
it's
right,
going to
hello,
be
Hella.
State's Exhibit 37.
Oh, Hella, how the fuck are you in two places at once?
Why?
You didn't see that?
No.
I think it's going to be State's Exhibit 37.
Explain yourself.
Oh.
How are you two places at once?
Isn't she adorable? I like her.
So
She's cute. And she's in New Mexico, so I'm in the past
yeah,
and in the future.
yeah, it really is your doppelganger.
Yeah, she's hot.
Crazy.
Mm-hmm.
She's hot.
She's hot. How are you?
Is there someone that's unmuted that has background noise? It's not me.
Fuck you, Carrie. You can hear me now.
Right here,
Fuck
I do
you.
have a ceiling fan.
It's probably me.
Oh, I'm
Judge
sorry,
is like,
Judge.
it's me. I want to. Yeah, I'm causing you problems. Oh, sorry, Judge.
Can you see that there? That's State's Exhibit 37.
Yes, I can.
And can you tell us what we're looking at here?
Like, I want to go home.
You are looking at a
counsel.
profile view of the severely damaged evidence hammer, where we can see the quarter-cock notch, which is in good shape, dirty, but it works. The
It's a dirty
half-cock
cock.
notch, which is undamaged. But then we go to the pivot point, the hole. There should be a right angle step there, and it's completely obliterated.
Let me ask you, the quarter-cock notch here that we're looking at, does that appear to be excessively worn or create any functionality issues with the gun, in your opinion?
No, two parts of your question. It's not going to get wear because you just have the sear resting in that notch. There's no movement there. It just sits down in that notch. And I've already forgotten the second part of your question. It's not damaged. It's just got some debris on it.
Come on, old man.
So nothing about this quarter-cock notch, in your opinion, would cause any functionality difficulties with the gun?
No, did that when I examined it.
Okay. And this notch here, this is the half-cock notch, is that right?
Or loading notch. Two names for the same thing.
Any problems with that?
No. It's undamaged and it worked.
Yes,
when
go
I examined
Oilers.
it.
Beat the Panthers.
And we'll get to that examination here shortly. So this, your concern, what's abnormal about this hammer in this photo is that the full cock notch is missing. Is that right?
Yes, it's just basically rounded off or broken off, sheared off.
Did you form an opinion about how that damage to the full cock notch occurred?
There's only one choice, and that's the impact testing that Mr. Ziegler applied to it at the end of his protocol.
So just to confirm, it is not your opinion that this damage to the full cock notch existed prior to Mr. Ziegler's accidental discharge testing. Is that correct?
That's correct. It did not exist prior to that testing.
I'm going to show you State's Exhibit 38 for comparison. What are we looking at here?
You're looking at a pristine hammer, one of the number of hammers that my son and I had. I think I bought two. We disassembled several out of our own guns. The only problem, it's not a problem in this picture, it's just split right left. So now the half-cock notch is on the right and the load notch is in the middle, and the full cock notch is by that large hole that you see. And there you can see a complete, perfectly formed and finished full cock step or notch.
Okay. And what you're talking about is this right here.
Yes.
Okay, great. I'm going to show you State's Exhibit 40.
Oh, now I see what it is.
Can you tell us what we're looking at here?
What?
Yes, I assembled
I had no idea what we were looking at.
3
Oh yeah, these are the hammers.
hammers, undamaged hammers from this make and model of gun. And nearest you is the evidence hammer. So it's a total of 4, but there's the evidence hammer, and it's they're on a rotating pin. You can see what looks like a screw there, so I can line them easily.
You might call it a knockabout in Australia.
If one is so
or something.
inclined, you can come
Might
across
we?
and look at the
I
various
don't know.
If we
notches.
had guns, we
and
don't
see
have
that
guns.
No,
they're
no,
all
a
in
hammer,
agreement.
like a
They're-
hammer.
They're indistinguishable.
Call a
as
hammer
far
a
as
knockabout.
dimensions
I don't
and
know. You probably
shapes
call
and
it
so on,
something.
until
We just
we
call it a
get to that
hammer.
full cock
Oh, okay.
step or notch on the evidence hammer, the one that looks
Give me the
silver and is
Chazawamba.
nearest you in this view.
Chazawamba.
That's right there. And if you then look at
A
the
boing boing.
notches in the 3 hammers next to it, there's no comparison. The evidence notch is effectively gone.
Did you do some additional testing of this gun in August of 2023?
Yes, I did, with the help of my son.
So let me ask you, before we talk specifically about that testing,
I'll be right back.
prior to doing that testing, had you already formed an opinion that the full cock notch
Now, Lois.
of the evidence hammer was damaged by FBI testing and was not damaged prior to testing by the FBI?
Yes,
How are you able to do that?
a number of ways. First of all, you've already asked me about all the videos that show the gun working properly. Then a real detailed examination of the FBI lab report showed multiple ways that this gun was working properly. Photographs of the hammer at full cock, trigger pull test, probably the most important test, because they give a numerical value for what sort of force must be applied to the cock, to the trigger and a cocked hammer to fire the gun. And that Mr. Ziegler, successfully test fired the gun at least 12 times with live ammunition. So putting all those together, it's clearly working fine until he gets to that point. And by his own description, if the hammer and trigger failed during that test, that's why they repackaged it the way they did. They took it apart. The FBI laboratory, took it apart to see what had failed. They recovered those parts, the hammer you're looking at here, the broken trigger, and the stop latch, and put them in a separate little container inside the pistol box.
So, Mr. Haig, when you did your forensic testing of the gun prior to August, did you have to replace the parts in order to put the gun back together?
Absolutely.
So you replaced those 3 broken parts to put it back together?
That's correct, with equivalent parts that are dimensionally identical, indistinguishable from the broken parts, except for the damage, of course.
And where did you obtain those parts so that you would know that they were the same as came from the manufacturer?
My recollection is the hammer and trigger came out of my son's Pieta Colt 45. We had others to choose from, but that's my present recollection. They were all indistinguishable. I think we used his. The trigger might have been mine, one of the ones I purchased, but they were intercompared with a group of new or parts out of working guns to effectively return the evidence gun to normal condition.
Were they all Pieta parts?
Yes.
Thank you. Now, we've seen numerous videos of the gun working properly when it's in Mr. Baldwin's hands. In August of 2023, at my request, what kind of additional testing did you do?
We put the damaged hammer that you're looking at in this view in the evidence gun, but a new or undamaged trigger and a new undamaged stop latch. So this would isolate the performance of the damaged hammer.
What was the point to that testing?
It was to determine despite that damage to the full cock step, would the hammer remain at the full cock position when you manually cock the hammer back? That was part one. If it didn't, would the half cock notch capture the falling hammer, which is what it should do if you have either a slip off or a full cock notch that's so damaged that it won't hold the full cock position. So two parts.
And when you conducted that testing, did you make a video?
Yes, we did.
I'm going to show you, I think these are unfortunately mislabeled, but I believe these exhibits should be 33 and 34, and they are in the folder that was provided that's marked Exhibit 33 through 34, August 24th, 2023. I'm going to show you State's Exhibit 33. Can you see that?
Yes, I can.
And what are we looking at?
Looking at the evidence revolver, we can tell it by that silver nickel-plated hammer, which differentiates it from all the other prop guns. Of course, the cylinder and cylinder pin have been removed in this particular picture or video.
So this is the original hammer missing. The full cock notch has been put back in the gun, and all the other parts are working fine. Is that right?
Yes, and all the pins, all the springs are the same. So the only thing that's different now is this damaged hammer.
Okay, but we've got a working trigger and we've got a working bolt. Oh, I'm sorry. We don't have the bolt in this video.
I'm not sure.
Okay, let's go ahead and play it.
This is August 24th, 2023.
There's no bolt
in the
in
property
this
room,
situation.
Santa Fe Sheriff's Office. And Mike, you're on to describe what we've done to the evidence gun.
So it's the item one revolver, the Pieta. Original parts include all the pins, screws, grip, the original hammer. It has the original hammer spring as well as the original flat spring that operates the trigger. The trigger is a replacement trigger, so the top of the sear is a functioning original piece. And as said, original hammer, it does have a replacement bolt as well. Otherwise, all parts are original.
Okay, and the hammer's in the fully forward position at this. Hammer falls, doesn't hold, but the half cock notch captures it. Let's do it again.
I'll take it all the way down. We can see the quarter cock notch also functions. Half cock functions. And then all the way to full.
And it fails to hold, but is captured at the half cock.
I'll apply some.
So, Mr. Haig,
That's exactly what we watched at trial, guys.
if that hammer had been damaged the way that it is now,
I'll take
would
some chats
Mr.
from
Baldwin
chat.
have been able to shoot that gun the way that he did in the videos?
No.
Would Mr. Ziegler have been able to test fire the gun 12 times?
Not in the normal way. No, he would not.
Real quick, we got 2 super chats. Zach for $1.99. Thank you, Zach. Is saying full cock notch is a great name for a rock band. Yes, it is. I still think
100%.
herniated squirrel is a good death metal name. And Jasper, thank you for the super chat, Zach. And Jasper's saying, hope the Baldo's an exhibit in the Ricada case. You have to keep that in a paper bag so it can dry out. Thank you, Jasper. Let's get back to the show.
Can I just ask a question?
And
Because
you're
I'm an idiot and I don't know anything about guns. What are you trying to prove?
So Alec Baldwin's trying to claim that there was a mechanical defect and that him merely cocking the hammer back, if he did, like he had the hammer cocked back and it went forward all the way and detonated a cartridge.
Right.
And these guys are proving, the FBI proved that was mechanically impossible because they beat on the hammer so hard they broke it. And then these guys are doing it and they're showing it's not operating 100%. But even if it's not operating at 100%, it still can't fire on its own.
Gotcha. Thank you.
So they're just showing Alec Baldwin's full of shit. Is what their
okay. Well,
argument is.
he is full of shit. But
Well,
yeah.
yes. But that's what they're showing when they're showing it cocked back at different stages. So.
Okay, so it's not possible to.
No, what he's
have
saying
it
is
fire.
impossible to have happened.
Yeah.
It's literally a mechanical impossibility.
Mechanically impossible for that to happen.
Yes. Unless there was a critical failure in multiple parts and pieces, which would have happened, and that only would happen one time because the gun would probably literally be broken. Because there's a bunch of little bits and bobs in here that would literally have to break in half.
So, like, you know that moment in the Blues Brothers when the car at the end just goes like that?
Yes.
Yeah. So the gun would have
Pretty
just
much.
had to pretty much explode.
Yeah, this gun would have to suffer a catastrophic failure.
Gotcha.
So.
Okay, thanks for that.
Yeah. And all these notches would have stopped it. And that's what I'm saying. All the notches on the sear and on the hammer, all those notches and grips, they would literally all have to break off. So literally you'd suffer a complete failure. And that would be impossible. Literally impossible.
Thank you.
The student needs to flag the judge, otherwise I can't take him seriously. Maybe it'll happen this time.
For time saving, we have State's Exhibit 34 is just kind of a different version of that video, so I don't have to show it as long as it's a part of the record. Unless anyone wants me to show it, I'm happy to. All right.
You don't need to show it for me. What is Ms. Clark saying? Anything?
No need to show it for me.
Judge is like, I don't care.
Just end.
No.
God, we're not even on
So
cross.
we know that the damage to the hammer,
I know,
could not have
like this
existed
right now. Just
prior
tell me.
to April, I think. Of
Where's Alec when we
2022
need
when the FBI did their accidental discharge testing. Is that correct?
I would agree with that. Yes.
Just gotta end it. I'm just gonna end it.
And
right now.
you concluded that the markings on the very tip of that sear did not affect the functionality of the gun. Is that correct?
Right.
Now, in that regard, let me ask you, did you issue a supplemental report August 31st of 2022?
I believe so. Yes.
Very
Third and
supple.
final report.
What's that?
Third and final report in this work.
Thank you, sir. And in that report, did you give any kind of an opinion about whether or not those markings that we could see in the photos that we looked at earlier were caused by the accidental discharge testing?
No, at that time I was uncertain, and I gave an open-ended comment that I couldn't explain them given the lack of information I had at that time concerning the history of the gun and the nature of Mr. Ziegler's testing.
Well, specifically, Mr. Haig, did you say in your report that you thought that it was unlikely that those markings were the result of Mr. Ziegler's accidental discharge testing?
I did say that, or write that.
And let me ask you, at the time that you wrote that report, how much information did you have about the manner in which Mr. Ziegler conducted his accidental discharge testing? And specifically, I'm talking about the striking of the hammer with the mallet.
Only very, very limited information that he used a rawhide mallet. Beyond that, I knew nothing at that time.
So recently, did you make a request to speak to Mr. Ziegler?
Yes, I did.
Tell us about the circumstances of that.
Well, this was somewhat troubling because these marks that you've seen earlier, which exhibit it is, are on a diagonal. I hope you can see my hand here, rather than perfectly back to front, which I would have expected if the blow to the hammer that caused the trigger and sear to fail was delivered with a perfectly back to front blow. So I needed to get more details. I assumed it was obviously wrong, but they had a special fixture, a rig, an apparatus to hold the gun and swing the blow so it came square on. In that interview just a few days ago, I learned that it's free swung, so we don't have any numerical impact values in terms of kinetic energy. And he conceded in a free hand swing, there could have been a side component. In other words, instead of 0 back to front, coming in at, let's say, 80 or 90, he was unable to clarify that, other than he conceded, yes, we can have a side blow. That could explain my puzzlement, really, about why they're diagonal. I would have expected them at the time to be perfectly back to front. So that clearly offered an explanation. The other is maybe logic or common sense are less and less common, but if the hammer got that badly damaged, something serious had to happen to the sear tip. And really the only choice is the impact testing, despite the fact that the marks, the really egregious marks on that sear, have an angular component.
So after speaking to Mr. Ziegler and getting more information about the manner in which he conducted his accidental discharge testing, did that cause you to change your opinion as to whether or not those markings at the very tip of the sear were caused by the FBI testing?
Yes.
So what's your opinion today?
It's really the only choice, just by
Okay.
simple logic and the history of the gun, and now more information about the impact testing.
Now, hypothetically, let's say that these strange markings at the very tip of the sear, let's say that they weren't caused by the FBI and that they did exist during the filming of the movie. In your opinion, would they have affected the functionality of the gun at all?
They would not, and they did not.
And is it unusual in your line of work that you would meet and speak to other experts about your opinions?
No, not at all. I just have to do it through the attorneys involved.
Okay. And just to be clear, when you attended that meeting with Mr. Ziegler, that was something that you requested from us, correct?
If anyone wanted to get past why I was so puzzled by the diagonal marks, and clearly, yes, I needed to know more.
Just to follow up, kind of close the loop on a couple of other things. In the testing that you conducted with regard to the spent casing from the set of rust. So when I say the spent casing, I mean the spent casing that appears to be the casing from the fatal bullet. You did testing on that, correct?
Yes.
And based on can you explain the kind of testing that you did?
Yes, well, first of all, I had Mr. Ziegler's what are called photo micrographs. He took excellent pictures of a comparison. So I could see that the evidence cartridge, before I ever put it under the microscope, had achieved normal operating pressures. In other words, when a gun goes off, the cartridge is slammed back against the breech face. I also test-fired cartridges, same caliber, same brand, and did the same comparison. The only difference is I used a 3D scanning device. He used a normal microscope. They're both up to the task. And I, too, could easily match a test-fired cartridge with that particular cartridge case, impounded as being the fatal cartridge.
Were you able to determine from firing pin depth impressions what position the hammer of the gun was in when the fatal bullet was fired?
Yes.
What position was the hammer in?
In my opinion, from my testing and all the test-fired cartridges I had from the FBI laboratory, it's a normal hammer fall from a full cock position, as opposed to what might be called a slip-off, where someone is trying to lower a hammer, or they've got it at a quarter cock and they miss it and it slips, the hammer falls. The firing pin impressions there, this is by actual testing, will be substantially, visually, measurably different. So it's a normal hammer fall from the full cock position, in my opinion.
Your Honor, in terms of time, do you want us to keep going?
No.
I don't have any other spot for you. How much longer are we going to take?
Oh, Jesus H.
I don't have that much longer with Mr. Haig. We should be able to wrap it up. I just wanted to check in with you because I think it's 5 o'clock.
It is, but as I said, I don't have any other spots for you. So thank you.
Okay, no problem. Mr. Haig, can you describe the process
Oh my God.
that one would engage in to remove the firing pin from a Pieta single action army and reinstall that firing pin? Is that easy? Is it complicated? What happens?
No, it's easy. You just need an appropriate punch.
Wash my
It's not going to
fucking mouth
mar
out.
the hole. If you look at the pictures of the hammer, you can see the firing pin.
I rushed home
Let's say a
from
little
work
pivot
because I
pin.
thought it was going to end soon.
Rotates. That's driven out.
Well, hey, at least he
The
had to
firing
work
pin
early.
falls out. And now you've got a gun you could take to a trade
I
show
thought
and
this was going to
meet
be
their
better. The
requirements. of not
warning
having a
wasn't
firing
actually
pin.
bad. It was pretty
Put
good.
it back. Again, you align the
I
firing
am so
pin
sorry,
with the
chat.
hole in the
but
hammer. Reinsert that pin
I
and
bet
just
even
tap it
Bronk
till
has
it's
quit
flush
by now. He's
on
like,
both
this is
sides,
gay.
usually with a brass driver, a gunsmith tool.
And I don't
Okay.
blame him.
Let me just review my notes real quick.
Oh, Jesus.
Sorry. And just to correct the record, I think I indicated that the testing that Mr. Haig did in August was in 2022. I just wanted to correct that. It was actually in
Yes, I did
2023.
this.
I'll pass the witness.
Shanice says, I voted for Karen Reed today.
Cross
Oh my
exam.
God.
Thank you, Your Honor. Good afternoon, Mr. Haig. I want
All right,
to
Hella.
start back with the your review of the FBI's report and your conclusions regarding the
Don't
FBI's
let the family
exam.
down.
So you reviewed
so
the
sexy.
FBI's report in July of last year. Is that correct?
Yes.
Okay. And over the course of your review of that and other materials, you determined that the testing the FBI did was completely unnecessary. Is that correct?
No, all the testing they did until we got to the point of the accidental discharge test. I
Sorry,
felt that was unnecessary if the person, in this case, Mr. Ziegler, knew more about the issues.
Okay, so just to put a finer point on my question, you would agree that the testing that Mr. Ziegler did, the accidental discharge testing, was unnecessary in light of the circumstances of this case?
Yes, I would, and I do.
Okay, and you would not recommend that testing based on the circumstances of this case if you were in Mr. Ziegler's shoes?
Well,
I would not
my
have
hair
a
again.
firearm had come to my laboratory.
Okay. And your understanding is that Mr. Ziegler did not disassemble or document the internal components of the firearm before he conducted the destructive testing?
That's right, he did not.
Okay, but you and your son did disassemble and photograph parts of multiple firearms in the course of your testing in this case, is that correct?
I think we disassembled 9 Pietas that were prop guns, and both my son and I have the brother to the evidence gun, same make, model, barrel length, so on. So we have
Okay.
11 examples.
Hi.
Okay, and you do that because you want to document the condition of those firearms on receipt, is that correct?
I'd say it was a little more than that in the sense of here they are, let's have a look. I already know what they look like inside, but it would just be a question someone might raise. Did you ever examine the interior of any of those other guns? I want to be able to say, yes, we looked at them all.
And is that something that you would routinely do in the course of a firearms examination?
You're a little scratchy in the audio. I missed that one, sorry.
Is that something that you would routinely do, disassembling the firearms and documenting them in your experience as a firearms examiner?
Well, I'm sorry, I'm still missing it.
Is everyone else having a tough time?
I hear you. But it's
Your
really-
voice is just a little raspy, but why don't you turn the volume up? Maybe that's the problem.
And maybe speak a little slower.
Or she had to throw that dig in.
Yeah. Oh.
Okay, I think I have it as high as it can go. Can you hear me now?
He's talking too
That's
fast
better.
for him.
Okay, so my question is, when you undertake to examine a firearm, do you commonly disassemble and
Yelling at
document
her
the internal
grandpa.
components?
Hi,
It's going to depend
Grandpa.
on what the issues are, what the
Happy
context of the case is. If it's an alleged,
birthday.
and there's a difference. If it's an alleged accidental discharge, that's a gun problem. And yes, if it's an alleged unintentional discharge, the gun may not necessarily need to be disassembled.
Okay, and based on the circumstances of this case, you said you disassembled 9 Pietas as
Sorry,
well
Sean,
as
I'm
2
gonna bring
additional
this up.
firearms that you had in your possession?
Yes,
Okay, and how long does it take to take those guns apart?
that's pretty much a day's work.
Using
For
my
each gun?
powers.
Gloss. Like that.
About a day's work. My son did most of it. I watched. He's better at it than I am.
Oh, gosh. Ow.
Okay. And would you consider it good practice to document those internal components?
I missed part of your question. Would I consider it?
Good practice to
Oh.
document those components?
Good
Yes,
practice.
that depends on the issues. Certainly in a civil case where the gun manufacturer is a defendant
It's like
and there's
talking
an
to my
allegation
grandma
of a
all over
compromised
again.
gun, you bet. Everything's going to get photographed and measured.
Okay, and you did it in this case, so you presumably thought it would be a good thing to do in this case?
I think we did photograph all the various parts from the various guns.
You described, we've spoken before, you described to me previously a test called a push-off test. Push-off test?
Oh yes, push-up, sorry.
Okay. And would you agree that, and can you tell me what a push-off test is?
Yes, it's going to be easier to demonstrate. Here's the brother for the evidence gun.
Sean!
What?
There's your
Oh,
full cock
shit.
position,
Yeah.
and you just put pressure with
Hold
your
on.
thumb.
There we go.
Push maybe 2 or 3 pounds of force. And if that
Oh,
first cock
gosh.
knot
I looked
is
away for a second.
damaged,
Yep. We're going to.
the hammer's going to fall, and it's going to be captured, as we've seen in the video, at the half cock knot.
The court's going to get
Is
taken
it fair
down,
to say that a push-off test is not destructive?
Clearly, it is not.
Okay. And would that have been a more
Fucking
appropriate
assholes.
test given the circumstances of this case, in your opinion?
It would have been a useful test, and if the hammer held at that point, then we're
My
back
hair.
to your earlier question. I
My
wouldn't
hair's that
see,
bad
if I
right
knew
now?
more about the case and was in Mr. Ziegler's position,
I got a
go
poof
beyond that.
going.
Okay, so just to make sure I'm clear, in your opinion, would it have been appropriate to do a push-off test in this case?
It's certainly appropriate in my laboratory. It's common. It's just part of my worksheet. If, again, there's an allegation of an accidental discharge, a hammer fall without a trigger pull.
And is it your understanding Mr. Ziegler did not conduct that
It's
test?
all fixed
That's
now,
my
Chad.
understanding.
Nice.
And instead he conducted the destructive accidental discharge testing that we've talked about before?
Well, I conducted the test that ultimately became destructive. It wasn't necessarily intended to be.
Understood.
You can't have guns shown on a live stream.
You were speaking with Ms. Morrissey before
They should
about
immediately get nuked.
a test
That
that
would
you
be
and your
so
son
fucking awesome.
performed where you
That would be good.
replaced the broken hammer, or you put the broken hammer back into the gun, and you otherwise put in a replacement sear and bolt. Do you remember that?
Yes.
There's no bolt.
Okay. And I believe you said you did that to isolate the damage to the hammer. Is that correct?
Right, to see if that damaged hammer would even hold the full
You're talking
cock
about the
position.
bolt that went
Okay. And
through.
my understanding is you did not conduct a test to isolate the damaged trigger. Is that correct?
That's correct.
And would it even be possible to do a test like that at this point?
Well, it's always possible to put the broken trigger and a good hammer back in the gun. I saw no need to do that.
Is it your opinion that that test would be pointless given the current condition of the firearm?
Yes.
What if the gun identifies as a magic wand?
Ms. Morrissey showed you a series of videos earlier, and I understand that you've reviewed more than we reviewed here today. Do you recall that?
I do. And we only looked at a few today.
Have you said you reviewed about 20?
Yes, at least.
Do you know how many days Mr. Baldwin was on set?
No, not at this time. I may have at one time, but I don't today.
And you don't know how many days Mr. Baldwin's gun was fired on set, do you?
I do not.
You haven't seen all of the footage from Rust, have you?
I doubt it.
Okay, you've just seen what's been provided to you by the state, is that correct?
Yes.
And Ms. Morrissey mentioned some video from October 21st, but in the video from October 21st, Mr. Baldwin doesn't fire his gun, does he?
He does not.
I want to talk about this August 31st report. You referred to it as your third and final report. You sent that report to the state on August 31st, 2023, correct?
I believe so. Yes.
Okay. And I'm going to show you what was submitted in the exhibit packet as Exhibit H, but I believe we're just going to be calling it Defendants 3. That's the number we're up to. Mr. Haig, can you see my screen?
Yes, I can see it.
Okay. And my understanding is this is subject to our prior stipulation, but this was again submitted as Exhibit H in the packet to the court. Mr. Haig, do you remember sending this email?
No, I don't. I accept it as mine, of course, but I don't remember it.
Okay. Can you tell me about the conditions or what prompted you to send the report on August 31st to the state?
Actually, it's the unhighlighted sentence that I think pretty well explains it. I try to anticipate cross-examination questions, whichever side I'm working for, anticipate what I might be asked. If a person with similar expertise looked at evidence,
He's already
so
like,
I could envision, and apparently did, someone looking at the broken parts, seeing those really egregious damage marks on the sear tip, and wanting to know, what do you think about those? Where do they come from? Why don't we hear any reports about them?
And it looks like you say here, Mike and I agreed that something needed to be memorialized. So was there a conversation between you and Mike about submitting this report?
Yes, I would say so.
And remind me who Mike is, please.
I didn't hear that question.
Is Mike your son?
Yes, I have two. He's my younger son.
And did Mike work? And Mike worked closely
He's
with
my
you
boy.
on your expert reports in this case, correct?
Yes, he did.
And Mike is an expert in his own right, correct?
Yes, he is, clearly.
Okay. And so you and Mike had a conversation about memorializing
Like, not to toot my own
the odd
horn, but
tool
my boy
marks
is smart.
on the evidence trigger. Is that correct?
My son could kick your son's ass.
We're both reading the same sentence. I don't remember it, but I still stand by it.
Okay. And so is it fair to say that you volunteered to provide this report to the state?
I'm not sure if I volunteered it or said, shall I prepare a report? I just, frankly, too many things have I've done since then to remember that.
Okay. So other than this email, do you have any recollection of how the third report came about?
Not beyond, I think, what we've discussed both today and in an earlier interview this week.
Okay. This came up because you and Mike had observed odd tool marks on the evidence trigger, correct?
I missed that one again. Sorry, Sarah.
This came up because you and Mike observed odd tool marks, correct?
Oh, yes, we observed them long before that supplemental report was written when we first looked at the parts.
Okay, and I think that was around July 7th of 2023. Is that close?
Yes.
All right. And you authored two other reports in this case, correct?
Yes.
One on October 2nd, or August 2nd, that is fairly lengthy.
Yes.
And another one that is somewhat shorter on August 26th.
I believe you're correct. Yes. I don't have them in front of me. Those sound right. Those dates sound right.
And these odd tool marks didn't make it into either of those reports, correct?
That's right. Only the third one.
And you don't have any explanation for why those odd tool marks didn't make it in?
No, I didn't think they were that important. It's clearly damaged effects. But again, from this email, we decided let's get pictures of them so someone else can see them and realize that we didn't just blow them off or not consider them.
Okay, and so you assumed that this would be provided to the defense, correct?
Of course.
Okay.
He's trying to cover his own ass.
And do you understand that it wasn't in fact provided to the defense until May of this year after your son's interview?
Objection.
I became aware there was some sort of a breakdown in
would he know?
communication between your office
How's that
and
relevant too?
Ms. Morrissey.
Can you explain what you mean by a breakdown in communication between my office and Ms. Morrissey?
See ya, Ella.
See ya. I gotta get going. I'll see you tomorrow. You too.
Bye
bye.
Bye, guys.
Didn't hear otherwise until there was this issue about belated discovery.
Okay, and you didn't mention this report in your prior interview when you and I spoke in April, correct?
You're gonna have to. Sorry,
That's a
it's
problem.
very scratchy. Still, try it again.
Do you recall speaking to me in April?
She's like, damn
I
it,
don't.
Grandpa.
Okay. Do you recall doing an interview in this case?
I've been involved in several interviews. I do remember you visually, but again,
Visually?
a lot of things since,
Pervy grandpa.
since April.
Yeah,
I don't dispute we had an interview. I just don't remember much about it.
Thing.
Okay, so you'd agree with me that if I tell you we had an interview on April 29th in this case?
No, I agree. I'm sure we did.
He's like, is that when you whipped your
And
tits
in that
out?
interview, you didn't tell me about this third report, correct?
Is that when you
I
wore
don't
that
even
low
remember
cut
the
thing?
interview.
Yeah.
Would you dispute that you did not tell me about this third report?
No, I would not. Don't have any way of doing that.
Okay, and you said you became aware of a breakdown. How did you become aware of that?
Just vaguely, as I sit here now, that there was a failure to disclose some kind of a
This is Bronca's
snafu.
grandfather.
And that was news to
Father.
me.
Yeah.
And this was sometime this spring.
And that was after you testified in Ms. Gutierrez's trial?
One more time.
After Ms. Gutierrez's trial?
He's like, he has no goddamn idea.
I'm sorry, I still can't understand the question.
You learned about
He's like,
this
Jesus
breakdown
Christ.
in communication after you testified
He can't
in Ms.
hear you.
Gutierrez's trial, the armorer.
Don't know. I really don't remember when it became an issue or of concern.
So you don't know when you learned about this issue with the third report?
Not as I sit here today.
You don't remember if it was in the last month?
I doubt if it was in the last month, but again, I've got lots of other things I'm doing that occupy my thoughts.
You mentioned that you asked for an interview with Mr. Ziegler in connection with this third report. Do you remember that?
I do.
When did you make that request?
I'm not sure.
Did you make that request last year when you sent a list of items to the state that you needed to inform your opinion?
I don't know. I don't remember.
Did you speak? You didn't speak to Mr. Ziegler before Ms. Gutierrez's trial, though, did you?
No, I did not. In fact, most recently is the only time I've ever talked to him.
And so you didn't clarify those questions you had about the
He's like,
third
you're the guy who
report
broke the fucking gun.
until this week, did you?
When they met.
I don't
The
believe
guy's
so.
like, Mr.
Again,
Haig,
still
I love you. I have your
confused
book.
of
Can you
where
sign
this is
it?
going, so I'm not very helpful.
Do you recall you testified in Ms. Gutierrez's case that other than the FBI testing, you didn't see any other modification or damage?
That's my opinion. I don't recall whether testifying to it or not, but that would be my opinion regarding the evidence gun. But the one exception, it has a nickel-plated hammer. Doesn't change the function, but it certainly makes the gun stand out when you watch the videos.
And when you testified at Ms. Gutierrez's trial, you had not yet spoken to Mr. Ziegler, is that correct?
That's true.
Okay, and so at that point in time, those markings were still unexplained, to use the words from your report, correct?
Yes.
Okay. And you never asked to speak to Mr. Ziegler to clarify those markings before you testified at Ms. Gutierrez's trial?
That's right. I did not ask to talk to him before the trial of the armorer. Only more recently, when it became apparent this trial might go forward.
And do you recall telling me on April 29th of this year that the working surface of this sear looked as expected and normal?
I don't even remember the interview of the date you described. I remember seeing you, but beyond that, I don't remember anything from the interview.
The only thing he remembers about her is how she looks.
If you told me in April that the working surface of the evidence sear looked expected and normal, would that be false?
Rebecca, I'm having trouble hearing the question.
I'm going to represent to you, and I can refresh you if you'd like.
Yes. Well, this is where you say, would you agree with me if you told me X, Y, and Z? They can do that. That'll be quicker. Also, guys, let Nick Starro know I promise to be coming over at some point when this goddamn thing ends.
That on April 29th, you told me that the working surface of the sear looked as expected and normal.
I don't remember that, and I still haven't heard all of the question. I apologize, but the quality of the audio from you is really hard to hear.
Your Honor, I'm not having any difference in hearing the audio from Ms. Clark that
You're
I heard
not
from Ms.
90.
Morrissey or anybody else today. And I'd ask to approach the bench if there's a way to approach remotely.
Are you
I
kidding
hear
me?
you just fine, by the way.
Louder in person, but I'm doing my best.
I can try to speak lower. That's
I don't
the
think
only.
we can approach the bench on this. Why don't you turn your volume up to the max, both of you?
Oh, that was great. I love this guy.
Mine is up as far as it goes.
Yeah, now it's over-modulating. It's loud, but some over-modulating.
Overmodulating. You don't know what that term means. You're a gun guy.
We're at the point, Your Honor, where my concern is, of course, that the right to cross-examine the witness is being impeded by this. And between the remote nature of this, the fact that we're at the end of the day, I'm just going to alert the court. The defense is not going to, I understand that the court's time is precious, and I mean that genuinely, but the issues here are just too serious, and it's just too hard. It's just going to be one of those rare times in my career where I think there's something going on that just I can't let lie. And so the defense is not going to be resting today. We're going to be seeking to put other evidence before the court, just to alert the court of that.
Well, what do you mean other evidence? Completely. This is an issue of we need to fix the hearing, but other evidence before the court. I mean,
He's using the old guy of
you've
line,
interrupted
man.
enough. He's answered questions. You can repeat the questions that he hasn't asked. I'm just curious as to whether this can be corrected. Is there any other place you can go to, Mr. Haig?
Can
No,
your sons
I'm
help
in
you?
The small office adjoining
Dolly,
my
hop in the
my
car.
home. I can hear Mr. Spiro. That's the way to
Is
pronounce
there
it.
any other office that you can go to, Ms. Clark?
I can try to call in from my phone. I will say I have not had this problem with anyone other than Mr. Haig, but I can try to call in from my phone and do the audio that way. Would that be preferable?
I don't think.
Yes,
this guy's
see if
fucking
it
with
works
you,
first of all, and then we
honestly.
can regroup on the questions.
Oh, this poor. Oh God.
This judge is like, oh my God, I wish I couldn't hear this.
This judge is so pissed.
I would be too. She started at 9 a.m. their time, and now it's fucking almost
5.
fucking 6 o'clock
30,
there.
yeah.
I'm pissed.
Yeah.
I mean, I love doing this, but fuck, not like this.
Not for 9 hours.
Yeah. I mean, there are trials that Kieran Reed doesn't even take this long to do a trial.
Oh, God, I wish Judge Glanville was running this.
Well, you would have put somebody in jail by now.
Well, yeah, but he would have ended at like 2.
Yeah. Bev would have been like, we're going home for the weekend. Although the thing is, they're set for trial like in a couple of weeks. So
that's true.
They kind of got to roll. Also, you guys are wondering, I had to 3D print something for 2.0, so I'm cleaning it up as we speak.
Oh, damn, they blocked out her number. At the bottom,
You guys
they
everybody start
Don't
Your Honor,
fucking figure it out, you
counsel,
assholes
can you
out
guys
there.
hear me now?
All right, it's supposed, Mr. Haig, is that better?
That was better. See if the question.
All right, so listen to the questions. Go back at any point in time in your cross-examination, Ms. Clark, that you feel that you were not
Oh,
getting
Jesus. Any point
sufficient
in
cross-examination
time,
because he could not hear or because of whatever other reason. Take your time.
Thank you, Your Honor. Mr. Haig, can you hear me now?
I can hear you. It's a little better. So let's see how it goes.
God damn it.
But I wanted
Okay.
to see you too.
It's just think of Hella. There you go.
I want to go back to when you noticed
I'll be
the
right back.
damage to the evidence here. And I understand that that was early July, correct?
It would have been
Of-
the official exams in July of last year.
Okay. And I believe I understood you to explain to Ms. Morrissey that there was egregious damage to the working surface of the sear and that is what is reflected in your third report. Is that correct?
Yes.
Okay. Do you recall doing an interview with me in April of this year, April 2024?
As I told you, I don't recall it. I don't dispute that we had one, but I just don't recall it.
Okay. And if you and you told me at that interview that the working surface of this sear looked as expected and normal. You recall that?
No.
Would that be a true statement?
I believe so. Yes.
That the working surface of this sear looked as expected and normal? That's true?
We're back to the same problem. I'm missing a word here and there. Sandy, do you mind if my wife stands here and sees if she hears it? Can't do that, eh? Okay. Judge says no, Sandy, go away.
Hold
Your
on,
Honor,
folks.
I don't.
Hold on,
Sorry.
folks.
Uh-oh. Uh-oh, SpaghettiOs. She's like, she's like, by order of the court, I'm gonna kill myself. She's like, we're done for the day. Where are you going, Judge? To drive into
Counsel,
traffic.
tell me if that is what you want to do.
As I've indicated, Your Honor, we're not going to be able, the defense is not going to rest today. So I would ask, and I understand, and I say this genuinely, the court schedule and fitting this in where we are in the lead up to trial, but the issues are just serious, and I'm not going to be able to rest today. So I would ask, even if we don't decide at this exact moment when there could be potentially another hour from the court, but given the hour, given the ability to cross-examine this witness, and given that there's going to be other documents and evidence that we have to put in because of what's going on here today, we're not going to be in a position to rest today.
Can I ask, does the defense have other witnesses that you intend to call?
So I have to meet with my colleagues after this and decide, given what I think is going on here, which is troubling, to put it lightly. So I don't know exactly how this is going to proceed.
He thinks it's all bullshit?
Having practiced in many, many states, it's very rare that I'm put in a position where reports are hidden, witnesses change their answers in this kind of manner. And I hope the court will take this seriously. We're certainly taking it seriously. And I just cannot be in a position where we don't have a moment to confer and the court looks at me an hour past the end of the day and says, can you just rest? I'm not going to do that. I'm going to ask for more time. And so I'm just being direct with the court on where we are.
Well, that's not really germane to my question. My question is, we showed up to do a hearing today. I understand Mr. Spiro's concerns, but if the court tears a hole in its calendar and resets us, is the defense then going to show up with witnesses that we haven't interviewed?
Let me do this. Your plan, Mr. Spiro, was that you were going to use these 3 witnesses. And now I don't understand how because he can't remember, you're going to be calling other witnesses.
It's a bit of an issue, though.
These are the 3 witnesses for this hearing. I am going to call this hearing again at 2:30 on Monday. And it's going to end at 5:30 no matter what. All right.
Understood.
Now, I will see you back on Google at 2:30 on Monday. Thank you. And Ms. Morrissey, Mr. Haig you have got to hook him up with some way better IT.
Understood.
This cannot happen again, or I will begin to entertain confrontation issues.
Understood.
All right, thank you. We're in recess.
Ooh.
Was he still not able to hear her?
He's probably still sitting there like, oh, are we waiting? Are we still on? He's probably like he'll be sitting there till like noon tomorrow. Like, are we still live? He's like, honey, I think we're still on. Stop dinner.
Wait, I missed it. What happened?
So what's going to happen is they're going to come back Monday, and she told the state, get him a better fucking setup.
Okay.
So that's what just happened. David, you're in here, man. How you doing? Yeah, holy crap, still here. We just finished. Yeah. 8 hours and 37 minutes, chat. Just once again, just Monday at 2:30, they're gonna come back. We're not gonna watch that. We'll watch it later. So
yeah, when you know you can fast forward.
Yes. They agreed to ask 3 witnesses, but to be fair, I think they're arguing, is he playing dumb? And if that report was hidden from him, that is a massive issue. But we'll see what that does at the end of the day. We'll see.
Yeah.
Yeah, her voice is made with technology. She keeps tucking her chin. Yeah. So we got a couple other things to read here. Isaac Baruch's wholesome gabagool art for $5 says, for your entire day being stuck watching this. Yes, my God. Like, oh, I'm glad I got my work done this morning that I had to get done today, because I'm like, fuck. Sean's weekend is more ruined than Lady on a casting couch after 3 hours of filming. Yes. Fenric says no educational gun videos allowed on YouTube. Live streamed. Live streamed is the key.
Really?
Yeah. If it's live, you can't show a gun.
What?
So that
are
should have
they
been
afraid
new.
of?
That should have what?
What are they afraid of? Like they
YouTube,
allow-
because it's YouTube just trying to be anti-gun because of, like, oh, well, people might start glorifying guns. And well, also you have like streams where like streamers have been playing with guns on streams and shooting into their, like, accidentally discharging. That's happened a couple of times. A couple of Twitch people have shot their desks and stuff like that.
Of course.
And then Cat Not Williams gifted 5
Aw,
memberships. Cat, thank you so much.
You're awesome. Cat.
Appreciate it. All right, guys. Someone's getting shot on the live. Yeah. Commies are gay is the reason. Yes. Oh, my God. So, yeah, chat, that's it. Jeff starts in 30 minutes and Nick is on right now. So go over and say hi to Nick Start. Well, actually, hold on. I'll send you
Can you
fuckers
redirect?
over there. I'm going to make you bitches go over there.
Yeah, I'm gonna go pop on.
Okay, yeah. You guys are all going to start saying, no, Daddy Sean, we don't want to go. And I'm going to be like, you got to take it. Ah! And you're just going to have to take it.
Is Ricada live? You can redirect there.
No, but I'm gonna make you guys accept. I'm gonna force this down your throat. Never mind. I'm not gonna say it. Not gonna say it. Nick Starro, it doesn't show up.
I can send you the link. Private chat.
Well, no, I'm trying to do the redirect.
Yeah.
Search your videos. Was it like I can do the?
Can you paste the link
I don't know.
directly?
You can. I don't think so.
I thought you can.
Hold on here.
Unless YouTube is being racist against Swedes.
Oh, here we go. Got it. Okay. All right, Chattel. That's it for tonight. I mean, we've already covered it. Don't do it. Don't do it. No. Bernie says we can go ask Nick if coping on Twitter will bring his kids back. I mean, he's the mayor of Copenhagen right now.
It's a conspiracy.
Well, that too. So, Angela, hold on, Angela, you had a question? Let me see. What was Angela asking? What is locals, Angela? Okay, so here's what. So, Angela, do you know what Patreon is? Patreon is the place where you can go sign up and you can support someone through there on a monthly basis instead of super chatting them. They take less of a cut.
Yeah.
Patreon is run by a bunch of communists.
Commies.
So if you don't do what they like, they can shut you down. Locals is the anti-version of that.
It's the heterosexual version.
Yes. Locals is basically don't Fed post and you're okay. So it's just like that. It costs you nothing to become a member. You can join for free. You can become part of, like, you can comment on the wall and the articles we have. So at potentiallycriminal.locals.com, you can sign up for free. Costs you nothing. You can use the Oh, was that my computer or your computer? Somebody just got an email.
No, it wasn't mine.
Okay. Oh, I got one. What is it? Oh, LinkedIn. Fuck that. I don't give a shit. LinkedIn can suck my dick. Oh, and I need to move those. Hold on here. Not junk. And then not junk. Court just sent me something earlier today and it went into the spam. And I'm like, that would be bad. Anyway, Locals is a lot of fun. You guys can go there. We can post stuff. We do all kinds of things. If you want to support me there, you can support me there. YouTube takes 30% of a cut. They take far less. I forget how much it is, but it's a lot less. You can support me for $3 a month. You buy 10 months, you get 2 months free. And with that, you get access to live shows. I do live streams over there twice a week. We do a Monday night show, and then we do a show every Thursday night after the Thursday night stream here. And we just hang out and we can do all the stuff you can't do on YouTube. Like we could have like police shooting or talking about guns, or we could watch Mr. Medicare, or we can watch a Formula One race. We can do all kinds of things. The shit we can't do on YouTube. So that's what it is. And if you only use the promo code Booger Sugar, you get 1 month free access, complete access. And it costs you nothing. And if you're still not sure, Angela, get a hold of me, message me. My email should be down there at the bottom, and I'll be happy to talk to you if you want, and I can help you work something out. And we've also watched pig racing. Yep. The League of Pigs. So
EDW Raptor had a super chat.
EDW Raptor, you did a super chat also?
You just said don't forget it.
Oh, you just popped it right in there, snuck it right in there. Give us a desk pop, Sean. No. I'm not gonna do that. Pig racing. Oh, you guys, you don't know about the League of Pigs? Hold on, yeah. Hold on here.
What?
And then we're seriously gonna end.
Is this Rosie O'Donnell racing?
No. Sir.
Sorry.
Sir. You don't know about League of Pigs. This is amazing. Here we go. This is a real channel. Ready?
Season 10 brings on the arrival of our most dynamic racetrack to date. Known as the Oval, this will completely change the sport as we know it forever. But before we move any further forward, let us get a reminder of who is Top Pig. He's in dire trouble now, and he has a mountain to climb. You can sense they're getting tired at the end of this round, and he seizes his moment. Ginger looks tired, and Oinku knows, and he's pushed forward here. Hoshi on a roll. They don't know how to handle him, and it's become apparent here in round 2. And the Oinku fans cannot believe it. They've snatched the most pivotal season to date.
This is called the League of Pigs. They have a whole YouTube channel.
Wow.
And they have not, they're about to start season 10, and the pigs are finally getting professional sponsorships.
Are you serious?
Yes.
Congratulations, Hoshi and all of his supporters for winning what many would consider the most significant season in the show's history. And as the regular viewers will know, it's almost customary at the start of a season to make some announcements. So while Ginger and Piggy Smalls research this new racetrack, let us do just that.
Yeah, there's like Pepper Sanchez, Hoshi Oinku, Piggy Smalls, Bear Trotsky, and then there's God, what's the other one? I forget the other one. But yeah, they do races. They do races. The winner's converted to bacon. Well, that big one will be good bacon. So little kids falling off sheep. Yeah. Still waiting for an owl to pick one off. It's in Britain. They're safe. So.
Camel, join this race. You break those barriers.
Yeah. So Lamau Piggy Smalls. Yeah, he's good. He's actually got sponsored. He got sponsored. So yeah, Angela, but like I said, yeah, we watch this on Locals. You know, we gotta have I want to have something special for you guys over there, and that's our thing over there. So Dessa's tempted to sponsor. They have a Patreon you could send them to also, but yes. But no, they have business sponsors, like actual corporate, like one of the pigs, Piggy Smalls, is like a corporate sponsorship now. By a game energy drink company. So we'll watch this for a minute, guys. Then we're gonna go see Nick.
First of all, we need to highlight the macro picture after 9 seasons of racing. All of the pigs have double championships. All of the pigs, that is, except one. That pig, Pepper Sanchez, is the only pig to win just a single championship, which means that over the next 3 rounds, we're going to either witness a miracle or one of the other pigs is going to be crowned the undisputed champion of pig racing. Secondly, we just want to underline how difficult it is to get the pigs to turn more than 90 degrees during races. In season 8, we saw a car crash of an experiment as we tried to get the pigs to turn 180 degrees back on themselves during a race. And if you think it got magically easier in the wood, then you are a very optimistic person indeed. No, as this clip showed, it was just as difficult down here in the woodland. And before any of you say it, the reason why we couldn't continue filming and include this in the season was the simple fact that if we allowed these pigs to beeline to the food, we would never get them racing on this oval track. And finally, we want to mention that the oval track is not simply a new racetrack. It is a promise from this league that there will be substantial differences between seasons. No more small adjustments. We are going all in moving forward. Oh, and finally, any pig that wins the championship moving forward will receive the fabled Henry Cup. Those of you that have been watching know exactly the reason why. And with all of that in mind, let the madness begin. Well,
so here's the one race. We'll watch one race, chat.
Well, this does not look promising as Piggy Smalls is on top of the box. And things go from bad to worse as Hoshi decides he's going to improvise rather than get on board with these new changes. That's almost a tradition at this point, leaving Bear as the de facto leader. But she is receiving pressure from Ginger, and now Piggy Smalls is attacking on the inside. And as they go round the tree, Piggy Smalls has stolen the lead off Bear. Bear now struggling to fend off Ginger and Piggy Smalls. Piggy Smalls must get the win, surely, but Ginger's attacking for second. And as you can see already, it's very difficult to get a clear view of the finish line from the main camera. And that is why in the future, we're going to switch over very quickly to the overhead finish line camera. And I want to assure viewers that the oval track is the only time this will happen. But if we want to see the pigs racing on a dynamic race course and observe them doing corners and bends, then this is a compromise we must make. And let us pray that the large delay for Hoshi on receiving food is all the convincing he'll need to stay on the track for the rest of the season. For the creation of the new oval track, obviously more of the woodland had to be cleared. And that meant the pigs.
And the neat thing is the pigs are part of the excavation crew.
Were able to get much further into the wood than they were last season. A fact that's certainly not lost on the 5 pigs. And they almost instantly adapted to foraging deeper into this wood. Piggies and woodland fit like a hand does to a glove. And they spend much of their lives foraging. And so keep in mind that when you're watching these 5 roaming around this woodland, you're getting a glimpse into the past in what would have been the sole life of a pig back 100, if not 1,000 generations ago. Admittedly, I acknowledge that the white and red chicane boards, along with the machine cut wood, is taking away from the ancient woodland vibe somewhat. But if we...
So there you go. There you go. That's a League of Pigs.
Nice.
Yeah. So how did he get outside the track? Well, it's not like the gate wasn't right up to the edge. So when the gate fell down, he ran around the edge of it. So, yeah. We were told to remind you to visit Nick Starro. Someone else didn't quite catch it. Yes. We're going over there, chat. We'll see what happens. We'll watch Monday later. We'll watch the last little bit of this. I'm sure it's going to get very antagonistic and very fun. This is much cooler than marble racing. Yes, it is. So, yes. League of Pigs, everybody. And like I said, Angela, if you want to shoot me a message on email me at potentiallycriminal@gmail.com. And I can help you get set up on locals. But it's potentiallycriminal.locals.com. So anyways, guys, thank you for being here. Dolly yes. Talks.
Thank you.
Thank you so much for being here. I'm so sorry I roped you into this.
No, it's all right. I had fun.
All right.
Thank you for
guys.
having me.
Well, we will see you until next time. And even if Alec Baldwin's an asshole, he's still not guilty.
Yes.
Oh, because actually he's guilty of that, but he's not, even though he's an asshole, he's not guilty of manslaughter yet. So
he deserves a fair trial.
Yes. Good night, chat. We'll see you guys over on Nick and Jeff.
Yes.
Bye.
Later.